ನೀವು ಅದ್ರ ಬಗ್ಗೆ ನೀವು ತಲೆ ಕೆಡಿಸ್ಕೊಬೇಡಿ. ಹೋದ್ರು ನಿಮ್ಗೆ ನಾಳೆ ನಾನಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಮ್ಯಾಕ್ಸಿಮಮ್
ಏನ್ ಮಾಡ್ಬೇಕು ನಿಮ್ದೇನು ಸರ್? ಇಲ್ಲ ಸರ್, ಅದು ಇರುತ್ತೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಹಂಗ್ ಮಾಡಲ್ಲ. ಅದಿರೋದಕ್ಕೇನೆ ಆ ತರ ಮಾಡಿರೋದು. ಇರುತ್ತೆ ಸರ್. ನೋಡಿ ಹೇಳಿ. ಅದಿದ್ಯಾ ಅದು? ಇದು ತಗೊಳ್ಳಿ, ಇದು ಬಂದು ಅಟ್ಲೀಸ್ಟ್ ಅದೆಲ್ಲ ಹಾಕೋಬೇಕು. ಸ್ಟ್ಯಾಂಪ್ ಅದೆಲ್ಲ
ಆದ್ರು 2:30 ಇಲ್ಲ ನಾಳೆ. ಕುಡಿ ನಾಳೆ ತಗೊಂಡು. ಅರ್ಜೆನ್ಸಿ ಏನು ಒಂದೇ 16 ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇರೋದ. ಫೈನಲ್ ಅಡ್ಜುಡಿಕೇಶನ್ ಫೈನಲ್ ಹಿಯರಿಂಗಿಗೆ ಕೊಡಿ, ಮೆಮ್ಮ ಕೊಡಿ, ಹಾಕೊಂಡು. ನೀವು ಕೊಡದವ್ರು ನಾವೇ ಹಾಕ್ಸ್ಬಿಟ್ಟಿದೀವಿ ಓಲ್ಡ್ ಎಲ್ಲ. ಇಡಿ ಒಂದ್ ನಿಮಿಷ ಕರೆಸ್ತೀವಿ ಪೇಜ್ ವೈಸ್.
ಮೆನ್ಷನ್ ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್ 633 to 41.
39. ಹೇಳಿ ಏನು? ಏಕೆ ಪಿಕ್ಚರ್ ಇಲ್ಲ? ನಾವೇನ್ ಮಾಡಕ್ಕಲ್ಲ. ರಿವಿಷನ್ ಪಿಟಿಷನ್ಸ್ ಪೇಪರ್ ಏನಿದೆ ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. 21 ಮ್ಯಾಟ್ರು, ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಹಾಕೊಂಡ್ರದೆ ಇವತ್ತು ಬಂದ್. ಯಾಕೆ ಮೇಡಮ್ ಇಷ್ಟೊಂದು ಕಡಿಮೆ ಇದೆ ಅಡ್ಮಿಷನ್ಗೆ? ವೈ? ಒಂದು 10 ಇರ್ಬೇಕು ಅಷ್ಟೇನೆ. 33 to 44.
42 to 47. 48 to 57.
54 my lord. 54 my lord.
54 ಹೇಳಿ.
A week's time maybe.
2016 ಮ್ಯಾಟ್ರು. ಡೇಟ್ ಕೊಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇವತ್ತು ಕಡಿಮೆ ಇದೆ, ಇವತ್ತು ಕಡಿಮೆ ಇದೆ ಎಲ್ಲ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್. ಇವತ್ತೆಲ್ಲ ಫೈನಲ್ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
ಸ್ವಲ್ಪ ಇವತ್ತು ಎವಿಡೆನ್ಸ್ ಇತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಬರಕ್ಕಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್
54 2016 ಮ್ಯಾಟ್ರು ಯಾವ ಅಡ್ಜರ್ನ್ಮೆಂಟು ಇಲ್ಲ. ನೀವು VC ಇಂದಲೇ ಮಾಡಿ, ಪರವಾಗಿಲ್ಲ. ಐ ವಿಲ್ ಹಿಯರ್. ನೆಕ್ಸ್ಟ್
58 to 66.
65. ಹೇಳಿ ಏನು? ಹೇಳಿ. ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಹೇಳಿ. ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನ್ರಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗುತ್ತಾ? ಟೈಮ್ ಕೇಳ್ತಾರೆ, ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತಾರೆ.
ಪ್ರೀವಿಯಸ್ ಡೇಟಿಗೂ ಅದೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಅಲ್ಲಿ ಅದೇ ತರ ಕೇಳಿದಾರ? ಅಡ್ಮಿಷನ್ ಬಂದ್ಮೇಲೆ ಮತ್ತೆ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದಾ? ಆಯ್ತು. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ ಟೈಮ್. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್?
20ನೇ ತಾರೀಕು 22.
22 ಅವತ್ತು ಯಾವ್ದು ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ ಮೇಡಮ್?
ಹೌದು ಸರ್,
ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. 22.
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಫಸ್ಟ್ ಟೈಮ್. seal number 1 Srinivasan T.
Counsel absent, 2 weeks time granted.
seal number 2
Chandraknath Ariga, absent, 2 weeks time granted.
3
Lata S. Shetty, absent, 2 weeks time granted.
4
Pradeepa BV, Istisavek, 2 weeks time granted as sought.
5
Anil Kumar D, absent, 2 weeks time granted.
6
Nanjunda Gowda MR, absent, 2 weeks time granted.
7
Javed S, 2 weeks, 2 weeks time granted as sought.
8 Prakash KN,
absent, 2 weeks time granted.
second time non
Second
complaints.
time
9
Srinivasa
Srinivasan,
absent, 2 weeks time granted.
10
10
orders matter.
along with office note. ಏನ್ ಮೇಡಮ್ ಏನಕ್ಕೆ ಅಡ್ರೆಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಇದು? ಇವತ್ತು ಯಾಕೆ ಲಿಸ್ಟ್ ಆಯ್ತು?
ಪರ್ಟಿಕ್ಯುಲರ್ ಇವತ್ತೇ ಡೇಟ್ ಬೇಕು ಅಂತ ಕೇಳಿದ್ರು.
ಡೇಟ್ ಬೇಕು ಅಂತ ಕೇಳಿದ್ರಾ? ಆಯ್ತು. ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಕಾಪಿ ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲೇ ಇದೆ ಬಿಡಿ. 77 82 ಬೇರೆ ಒಂದಿದೆ.
ಥರ್ಡ್ ಸಕ್ಸೆಸಿವ್ ಬೇಲ್
ಥರ್ಡಾ
ಥರ್ಡ್
ಒಟ್ಟಿ 3
ಹೌದು
77 ಒಂದು. ದಿನೇಶ್ 77 February 22. Having heard the respective counsel in favor of the accused number 2 only, connecting office under committed granted bail in favor of accused number 2. Will not come to the aid of this petitioner. The specific allegation in this petition is that he assaulted victim. The victim had sustained injury to head, and cause of death is also on account of hemorrhage and shock on account of injury on the head. ಹೇಳಿ ಈಗ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ 22 ನಲ್ಲಿ ಮತ್ತೆ ಅವಾಗ ಏನಂತ ಆಯ್ತು? Witness and the recovery is also made at the instance of the petitioner wooden stick. Which was used for committing the murder. Whether he committed the murder with an intention or not, the same has to be considered in the course of the trial and not at this stage. ಹೇಳಿ ಈಗ. Husband of the wife. Husband of the
Immediately rushed to the hospital at CR. There it was declared not paid. Thereafter, company himself informs to the complainant, means none of that other offenses. Thereafter, he lodges the complaint.
ಸರ್ ನೀವು ಆಫೀಸಲ್ಲಿ ಇದ್ದೀರಾ?
ಸರ್ ಅದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಯಾವಾಗ ಮಾಡಿದ್ದೀವಿ?
On raising suspicion on against the petitioner, he lodges complaint for 302. Thereafter, this petitioner at A2, A2 is none other than the brother of A1. A2 has been endorsed on bail by his son before the year 2021.
A2 ಹೆಂಗ್ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರು? A1 is husband. ಅವನ್ ಹೆಂಗ್ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರು? ಇಬ್ರು ಹೋಗ್ತಾ ಇರೋದು ಬೈಕಲ್ ಅಲ್ವಾ? ಅವನು ಇದ್ನ ಆ ಟೈಮಲ್ಲಿ ಮತ್ತೆ?
Conspire. Both. There was a different parents in connection with the separate house. The deceased was demanded the petitioner to arrange a separate house for their marriage. He rejected her claim, so that cannot come to the parents. In that connection, there are frequent parents. On one day, in the date of the he committed the assault by dragging her out of the house on the ground. Was suspected in state. That's not the allegation. Thereafter, A1 and A2 conspired together to project the scene
as an accident ಅಂತ, accidental injuries ಅಂತ. ಅಂದ್ರೆ ಅವನಿಗೆ only 201.
Now, prosecution has cited 29 cases. CW1 to CW8, they have been they are the alleged cases. Now they have done the chase. CW1 to CW8 was an examined as PW1 to PW8. All the witnesses are expect. And the alleged witnesses to the recovery of the stick. Using that picture, it is said to have been
assaulted.
They have also done this. That is how it changed.
ಅಂದ್ರೆ ಎಲ್ಲಾ ವಿಟ್ನೆಸಸ್ ಹಾಸ್ಟೈಲ್ ಆಗಿದ್ದಾರೆ ಅಂತ. No one has supported ಅಂತ. What about the relative witnesses? 1 to 6. ಏನ್ರಿ ಎಲ್ಲಾರು ಹಾಸ್ಟೈಲ್ ಆದ್ಮೇಲೆ ನಮ್ದೇನ್ ನಿಮ್ದೇನ್? ಬಟ್ ಎಲ್ಲಾ ಹಾಸ್ಟೈಲ್ ಆಗಿದಾರ? ಏನಾರು ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಇಲ್ಲ.
ಪಾರ್ಟ್ಲಿ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಪಾರ್ಟ್ಲಿ ಸಪೋರ್ಟ್? ತೋರ್ಸಿ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಹಿಮ್ ಕಂಪ್ಲೀಟ್ ಹಾಸ್ಟೈಲ್ ಅಂತ. PW1 ಯಾರು? ಮೃತದೇಹವನ್ನು ನೋಡಿದಾಗ ಯಾವುದೇ ಗಾಯಗಳು ಕಂಡು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ಅವನೇ ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವನು. ಮಾತನಾಡದ ಕಾರಣ ನನಗೆ ಅನುಮಾನ ಬಂತು. ನನ್ನ ತಂಗಿಯ ಸಾವಿನಲ್ಲಿ 2ನೇ ಆರೋಪಿಯ ಪಾತ್ರ ಇರೋ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈಗ ನನಗೆ ತೋರಿಸಿದ ದೂರಿನಲ್ಲಿ ನನ್ನ ಸಹಿ ಇರುತ್ತದೆ. ನನ್ನ ತಂಗಿ ಸಾವಿಗೆ ಯಾರು ಕಾರಣದಿಂದ ನಾನು ದೂರನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ನನ್ನ ತಂಗಿಯ ಸಾವಿನ ಬಗ್ಗೆ ಪೊಲೀಸರ ಮುಂದೆ ನಾನು ಯಾವುದೇ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಹಾಸ್ಟೆಲ್ ವಾರದಿಂದ ನನಗೆ ಕರೆ ಮಾಡಿ ಎಲ್ಲ ವಿಚಾರಗಳನ್ನು ತಿಳಿಸುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಂಗಿ ನೀನು ಬೇಕಾದ್ರೆ ಹೋಗು, ನಾನು ಬರುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದ್ವಿಚಕ್ರವಾಹನದಲ್ಲಿ ಹೋಗುವ ನನ್ನ ತಂಗಿ ದ್ವಿಚಕ್ರವಾಹನದಿಂದ ಬಿದ್ದು ಪೆಟ್ಟಾಗಿ ನನಗೆ ತಿಳಿಸುತ್ತಾಳೆ ಎಂದರೆ ಸರಿ. ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಒಂದನೇ ಆರೋಪಿ ನನಗೆ ಕರೆ ಮಾಡಿ ದ್ವಿಚಕ್ರವಾಹನದಲ್ಲಿ ಜಮೀನಿಗೆ ಹೋಗುವಾಗ ನನ್ನ ತಂಗಿ ದ್ವಿಚಕ್ರವಾಹನದಿಂದ ಬಿದ್ದು ಪೆಟ್ಟಾಗಿ ಸಿರಾ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗುತ್ತಿದ್ದ ಸರಿ. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ನನ್ನ ತಂಗಿಯ ಮೃತದೇಹವನ್ನು ನೋಡಿದ ಆಕೆ ಹಣೆ, ಗದ್ದ, ಮೂಗಿಗೆ ಏಟುಗಳಾಗಿದ್ದು ಕಿವಿ ಮುಕ್ತದಿಂದ ರಕ್ತ ಬಂದಿತ್ತು ಎಂದರೆ ಸಾಕ್ಷಿಯು ನಾನು ನೋಡಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಬಿದ್ದು ಗದ್ದಕ್ಕೆ ಪೆಟ್ಟು ಮಾಡಿಕೊಂಡಿರ್ತಾಳೆ ಮತ್ತು ಕೋಲಿನಿಂದ ಹೊಡೆದಿರುತ್ತಾಳೆ ಹೋಗಿರ್ತಾಳೆ ಎಂದು ಯಾರು ಹೇಳಬೇಡ. ದ್ವಿಚಕ್ರವಾಹನ ಬಿದ್ದು ಗಾಯಗಳಾಗಿ ಎಂದು ಹೇಳಿಕೊಟ್ಟಿದ್ದು ವೈದ್ಯರಿಗೆ ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಇನ್ಯಾರು ನೆಕ್ಸ್ಟ್ ಯಾರು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವಿಟ್ನೆಸ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಸ್ಟೈಲ್
Doctor and police witnesses. Doctor and
ಡಾಕ್ಟರ್
police witnesses.
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಏನು ಇದೆಯಾ? ಏನ್ ಮೇಡಮ್ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಅದೇನ್ ಬೇಡ. PW2 ಯಾರು? ಹಾ ನೋಡ್ದೆ ಅಂತ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟಾ? ಕಾರ್. ಹಾ
PW3 is the wife of PW2. She is also neighbor.
ವೈಫ್ ಆಫ್ PW2 ನಾ ನೈಬರ್ ಅದು.
Son of A1.
ಸನ್ ಆಫ್ A1. ಹಾ ಅಂದ್ರೆ ಡಿಸೀಸ್ಡ್ ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ತಾಯಿಗೆ ಪೆಟ್ಟು ಬಿದ್ದಿದ್ದನ್ನು ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ನನ್ನ ಅಪ್ಪ ನನ್ನ ಅಮ್ಮನಿಗೆ ಹೊಡೆದಿದ್ದನ್ನು ನಾನು ನೋಡಿರುವುದಿಲ್ಲ.
Is the mother of A1 and A2. She has stand house.
A1 and A2 ನಾ A1 and A2 ಮದರ್ ಯಾರು ಸಪೋರ್ಟ್ ಮಾಡ್ತಾರೆ? ಮಗನಿಗೆ ಏನಷ್ಟ ಕೊಡ್ತಾರೆ ಎವಿಡೆನ್ಸ್? ಹಾ
PW6 mother, she is also wife of A2. She has stand house there. PW7 and PW8 were the witness to the seizure of alleged stick and car mother. For the commission of offense. They have done hospital.
ಕಾರ್. ಹಾ
They have done hospital. Son and A. The remaining witnesses are actually examined.
PW1 to 8 ವಿಚಾರಣೆ ಆಗಿದೆ. ಏನ್ರಿ?
The police witness and doctor has to be examined.
Only formal witnesses ಅಷ್ಟೇ. Third, heard the petitioner, counsel and also the counsel appearing for the state. This is a successive bail petition filed by the accused number 1 Allah, who is the husband of the victim. This court earlier rejected the bail petition in criminal petition number 611 of 22 with order dated 1st day of February 2022. And so also on 21st day of November 2022 in criminal petition number 8577 of 22. Wherein this court comes to the conclusion that charges level against this petitioner is that he inflicted injury with the club and club also seized and requires the trial. Now the counsel appearing to the petitioner would contend that prosecution already examined PW1 to 8 and even 1 to 9, 1 to 9. And PW1 is the brother of the victim. He also turned hostile. And PW2 and 3 are the neighbors who gave the evidence statement before the police that they have witnessed the incident of assault made by this petitioner. And they also turned hostile. PW4, yaradu? PW4 is the son of the petitioner and also the victim. And he also not supported. And PW5 and 6 are the father and mother of the accused. Howda?
PW6 is the wife of A.
No, PW5 is the mother of accused and PW6 is the wife of the accused number 2. And they also not supported the case of the prosecution. 7 and 8 are the recovery witnesses and of the stick, and they also not supported the case of the prosecution. And counsel for the Respondent would submit that the remaining witnesses are doctor and police witnesses to be examined. Having considered the material on record when the complainant, who is the brother of the victim, has not supported the case of the prosecution and none of the witnesses have supported the case of the prosecution and already PW 129 have been examined. Only formal witnesses to be examined before the court and nothing is there to appreciate by the trial court also when all the witnesses have turned hostile and hence this court having taken note of the material on record and also particularly the evidence of PW 129. It is a fit case to exercise the discretion in favor of the petitioner and no need to continue him in the trial for the remaining period is concerned and with conditions that he may be enlarged on bail. With the following conditions and haki, bare conditions. Prakash RB. Copy
11.
subjections along with counsel submission. Hakilwa. ಸೆಟ್ಲ್ ಆಗಿದೆ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ಹೆಂಗ್ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಯಾವಾಗ ಯಾವಾಗ ಹಾಕ್ತೀರಿ ಹಾಕಿ ಆಲ್ರೆಡಿ ಹಾಕಿದೀರಾ ಮತ್ತೆ ಯಾರು ಬರ್ಬೇಕಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಯ್ತು ತಗೊಳಕ ಸೆಟ್ಲ್ ದ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಆಲ್ರೆಡಿ ಮ್ಯಾಟರ್ ಹ್ಯಾಸ್ ಬೀನ್ ಸೆಟ್ಲ್ಡ್ going to file the joint memo in the next state of hearing and hence office objection is deferred. List this matter on yavat karstiri district kudi madam 13 to
12 SPP.
This matter matters pertains to BBLB matters contractor matters where matters against discharge the status coming.
discharge mel
ಬಂದಿರೋದು.
ಯಾವ್ದ ಸೀರೀಸ್
Yes, yes.
100 ಕೇಸ್ ಹಾ
This may be taken on 18th. Today itself I will pay the process.
counsel HCCP submits that he is going to pay the PF today itself and if PF paid issue notice against the respondent.
16,
Complaints ಬೇರೆ ಇದೆ
ಮಾಡ್ತೀನಿ ಇವತ್ತೇ ಮಾಡ್ತೀನಿ.
also directed to comply with office objection today itself. List this matters on 18 to ಅಲ್ಲ
Yes,
18 to
16, 17, 18.
ಸರ್ವಿಸ್ ಮಾಡಿಸ್ಕೊ ಬನ್ನಿ ಅವು ಅದೇನ ಸೇಮ್
16, 17, 18.
ಎಷ್ಟು ಕೇಸ್ ಇದಾವ್ರಿ
150.
150 16 17 18
same.
ಮೂರು ಸೇಮ್ ಆರ್ಡರ್ 13
Avinash
ಅವಿನಾಶ್ SP furnishing a PF and petition copy for issue of notice ನೋಡಿ ಏನಾಗಿದೆ CD in filing ಬೇರೆ ಇದೆ dispensation of complaints of office
Claims
objections are ignored for present ಅಂತೇನ ಇದೆ office objections are ignored for present ಅಂತ ಇದೆ ಮೇಡಮ್
ಇವಾಗ
the council complaints ಏನ ಇದಾಗಿದೆಯಾ
ಸರ್ PF ಹೌದು ಸರ್
Suspension ಆಗಿದೆ.
ಆಗಿದೆ ನೋಟಿಸ್ ಆಗಿದೆ.
ನೋಡಿ this court with order dated 9/5/24 suspended the sentence to pay the 50% of the amount including the amount already deposited within 6 weeks. And though this order was passed on 9/5/24 and notice was issued to the respondent, PF not paid and also copies are not furnished. ಹೌದಾ ಮೇಡಮ್
ಹೌದು.
ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬರಲಿಲ್ಲ ನೀವು ಹಾಕ್ಸ್ಬೇಕಲ್ಲ ಕೋರ್ಟ್ನವರು and hence the order dated 9/5/24 is recalled and our respondent is given liberty to proceed against the petitioner in accordance with law. If PF paid within 1 week, issue notice against the respondent. If PF not paid within 1 week, list this matter for dismissal on
13 to
13 to
14
ವರದರಾಜ PN ಹೇಳ್ರಿ ಏನಾಗಿದೆ ಇದ್ರಲ್ಲ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆಯಾ ಇಲ್ಲ ಬರೀ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸಾ ಮತ್ತೆ ಕೊಡ್ಲಿಲ್ಲ counsel submits that during the course of the day is going to pay the PF and if PF paid issue notice issue emergent notice
50 Rajgopal Naidu
Rajgopal Naidu furnishing of petition ಆಗಿದೆಯಾ ತಗೊಳ್ಳಿ though this court suspended the sentence on 3/12/24 and issued the notice to the respondent PF not paid and hence the order dated 3/12/24 is hereby recalled and respondent is given liberty to proceed in accordance with law. If PF paid within 1 week, issue notice against the respondent. If we have not paid, list the matter for dismissal. List this matter on
13-2.
13-2.
19,
I'll give petition of counsel absent ಅಂತ ಹಾಕಿ first.
19,
ಅದ್ರಲ್ಲೂ ಬರಿಬೇಕು ಮೇಡಮ್ 13 ಅಲ್ವೇ. ಹಾ. ಪ್ರೊಸೆಸ್ ಯಾವ್ದ್ರಲ್ಲಿ
ನೆಹರು ಎಮ್ಮ 19 ಅಲ್ಲಿ.
ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆಯಾ? ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು? 30 ತಗೊಳ್ಳಿ. This court suspended the sentence on 30/12/24 and also notice ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ ಇಲ್ಲಿ ಮೊದಲೇ ಹಾಕಿದಾರ. And also order to issue notice to the respondents in spite of obtained the suspension order. ಕಂಪ್ಲೈ ಮಾಡಿದಿರಾ ಹೋಗ್ಲಿ ಆರ್ಡರ್ನ? ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ ಅಂದೆ. ಈ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಡಿ ಎಲ್ಲಿದೆ? ಹ್ಯಾವಿಂಗ್ ಮೇಡ್ ದಿ ಪೇಮೆಂಟ್ ದುಡ್ಡು ಕಟ್ಟಿದ ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ. ನಿಮ್ ಪ್ರಕಾರ ಯಾವತ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರಿ, ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಹೇಳಿ? ಇನಿಷಿಯಲ್ ಸ್ಟೇಜ್ ಬೇಡ್ರಿ, ಈ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾಗ ಎಷ್ಟು ದುಡ್ಡು ಕಟ್ಟಿದಿರಿ? ಇದು ರೀ 9,000 ಮೋಸ್ಟ್ಲಿ ಡಿವಿ ಆಕ್ಟ್ ಇರ್ಬೇಕು ಇದು. 323, 325 ಅಲ್ಲಿ ಆ ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದಿರಾ? ಈ ಸರ್ಕಾರ ಇರ್ಬೇಕಲ್ವ ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿ? ಮತ್ತೆ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್? ಆಯ್ತು ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? Order dated 30/12/24, PF not paid and issued notice against the respondent, but PF not paid. And the offences are 323, 325. And counsel submits that the fine amount was paid when the appeal was filed before the appellate court. And hence, if PF paid today itself, issue notice against the respondent. If PF not paid, ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ ಇನ್ನು? ಕೊಟ್ಟಿದ್ದೀರಾ? ಆಯ್ತು. And counsel submits that he has paid the PF today in the office and hence issue notice against the respondent.
Hearing on I-20, Manjunath
MR. Unserved cover received station, no such person in the address. ಅಲ್ಲ ರೀ 2232 ದಿವಸ ಇದೆ, ಯಾಕೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಅದರ್ ಸೈಡ್ಗೆ? ಬೇಡ, ಡಿಲೇ ಬಗ್ಗೆ ಹೇಳಿ. ರೆಗ್ಯುಲರ್ಲಿ ಕೊಡ್ಲಿ. ಯಾವಾಗ ಅದು? 2016. ಮತ್ತೆ ಈಗೇನ್ ಬಂದಿದ್ರಿ? ಎಂಟ್ರಿ ಮಾಡಾರ ಫೈನಲ್ ಆರ್ಡರ್? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು ಫೈನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಹೋಗ್ಲಿ ಆರ್ಡರ್? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ಕೊಡಿ. ಎಷ್ಟು? ಹಾ,
Now, my lord, data is become major. Other first respondent
ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್, ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಸಂಖ್ಯೆ 56. ಯಾವ ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ರ ಆರ್ಡರ್ ಆದ್ರಿ? 184. ಅದ್ ಫಸ್ಟ್ ಆರ್ಡರ್. ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು? ಅದನ್ನು ಕೊಡ್ತಾ ಇದೀರಿ. ಈಗ ಫಸ್ಟ್ ನೀವು ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ 184 ಅಲ್ವಾ? ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ 5000 ಕೊಡಿ ಅಂತ. ಆಮೇಲೆ ದೌರ್ಜನ್ಯ ಉಂಟಾರ ನಷ್ಟಕ್ಕೆ 5000 ಕೊಡಿ ಅಂತ, ಮಗಳಿಗೆ 3000. ಇದ್ರಲ್ಲೇ ಮೇಜರ್ ಆದ್ರೂ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಆಯ್ತ್ರಿ. ಈ ಆರ್ಡರ್ ಆಗಿರೋದು 2009 ಅಲ್ಲಿ. ಈಗೇನ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡೋದು? ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅವಾಗ 16. ಮತ್ತೆ ಈಗೇನ್ ರಿವಿಷನ್ ಹಾಕಿದ್ರಿ? ತೊಗೊಳ್ಳಿ. Heard on IA number 1 of 24 and there is a delay of 2232 days in filing and the order impugned challenge is dated 6th day of October 2009, passed in criminal miscellaneous number 184 of 2009, wherein also compensation awarded is 5000 to the wife and also an amount of rupees 5,000 for under section 20 of DV Act, and an amount of rupees 3,000 ordered to the daughter, and an amount of rupees 10 lakh as compensation under section 22. And also allowed the application under 18, preventing him in committing any domestic violence. And the same is challenged before the appellate court in criminal appeal number 57 of 2015. And the same was dismissed on 27/1/2016, since there was no representation and steps also not taken in spite of sufficient opportunity was given, and hence appeal was dismissed for default, and present revision is filed in 2024, though the petition was dismissed in 2016, and the reason stated in the application is that made several effort to reunion of both of them, including minor daughter, but respondent did not agree and continued to reside with her parents. And during COVID-19, her mother passed away on 25/5/2021, and his mother also father also sustained a stroke and suffering from cardiac attack, and he is also under treatment, and he is taking care of his father. N reasons ಕೊಟ್ಟಿದ್ದಾರೆ 16 in the dismissal like and no reasons are assigned for delay from 2016 to 24 except narrating the same, and hence I do not find any ground to condone the same. Condone or issue notice to the respondent, though notice was issued to the respondent earlier, and having considered the affidavit, no satisfactory reasons are assigned even for service of notice against the respondent, and hence I do not find any ground to issue notice against the respondent, and there was a huge delay of 2,232 days, though the petition was dismissed in 2016. No satisfactory reasons, and nothing is awarded in the affidavit also for the delay from 2016 to 24. And hence IA is rejected, consequently revision petition is dismissed.
21.
Direction filed by the advocate for petitioner. Henry?
The lordship indicated the matter will be heard on the merits itself. Last day, lordship indicated the matter will be heard on the merits.
Direction in.
Objection ಅಲ್ಲ.
ಆಯ್ತು, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ಏನ್ ನೋಡೋಣ.
Offense ಇಲ್ಲ.
But due to the mental and physical aspect, the petitioner come out from this family, and now in deciding rented house in separate house. And he has filed a DV Act before the trial court, the traffic court, and also filed a application for inter-alia for amount of 1,10,000. The other trial court has passed the order 30,000 rupees per month, and then it would say when medical and education. That order was challenged by the respondent before the appellate court. The appellate court was ordered 25,000. It is the 5,000 amount, and no order passed from the regarding medical and education sector. Then I started education, then I referred to petition filed with traffic court. Traffic court is ordered, there is no order in the medical and education sector. I can't pass any order. And only pass 25,000. Against this order, I challenged before the appellate court. The respondent is working as software engineer and drawing handsome salary more than On the date of, on the year 2021, is drawing salary of rupees 2 lakh and. In spite of this also, he's having two house. And getting 1,50,000 rent. In spite of this, he has not paid any money. Made some, he has lost my 2 daughters. And I am working as a.
ಇದು interim maintenance, ಹಾ.
He has a school teacher in the drawing salary 60,000 per month. Spite of this, I am fully dependent upon the respondent. Despite having sufficient income. Despite of the income, he was neglecting to maintain me as on my daughters. For that, I challenge before the Honorable Court.
Having 2 daughters?
Yes, ma'am. One is handicapped. Another one is studying in the first grade.
Handicapped study ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೋಫಿಯಾ ಸ್ಕೂಲ್ ಅಲ್ಲಿ ಸೇರಿಸಿ. ಸೋಫಿಯಾ ಸ್ಕೂಲ್.
He is also attending school.
Sophia opportunity
Income of rupees 1,93,000 and stated his monthly expenses rupees 50,000. Upon perusal of the bank statement, his salary is constantly rupees 1,93,850.
In pending of his petition, he has gifted his 2 house to his sister to evidence his maintenance. Totally is neglecting inside of sufficient amount. And now he is trying more than 3 lakhs amount per month.
2 house ಮೊದಲು ಇವನ ಹೆಸರಲ್ಲೇ ಇತ್ತಾ? ಇವನ ಹೆಸರು
ಇಲ್ಲ 8 ಮನೆ ಇದೆ. 8 ಮನೆ ನನ್ನ ಹೆಸರಲ್ಲೇ ಇದೆ. ನಾನೇ ತಗೊಂಡಿರೋದು. 8 ಮನೆ. ಎಲ್ಲ
2 ಸಿಸ್ಟರ್ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಅದು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸಿಸ್ಟರ್
One has been gifted.
one house
ಇದೆಯಾ ಗಿಫ್ಟ್ ಡೀಡ್ ಇದೆಯಾ? ಅವ್ರ ಪ್ರಕಾರ ಎಲ್ಲಾನು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ.
ಇಲ್ಲ
ಎಲ್ಲಾನು ಗಿಫ್ಟ್ ಮಾಡ್ಬಿಟ್ರಿ ಅಂತ
There's only
ಸಿಸ್ಟರ್ಗೆ.
one property
house
has
gift
been
ಮಾಡಿದ್ದಾರೆ.
gifted.
ಒಂದ್ ಮನೆ ಗಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರ ಪ್ರಕಾರ ಒಂದಾ?
2 house, 1 house gifted.
2 house.
2 buildings. 2 building.
ಬಿಲ್ಡಿಂಗ್ 2 ಇದೆ.
2
1
buildings.
ಬಿಲ್ಡಿಂಗ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
1 building. That I because they are unquote. They are to pay 1,10,000 rupees maintenance and as well as the educational maintenance, educational medical expenses.
ನೀವು ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ, ಆ ಆರ್ಡರ್ ಮೇಲೆ ಮತ್ತೆ ನೀವು ಅಪೀಲ್ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಅವ್ರು ಹೋಗ್ಲಿಲ್ಲ
ಅಷ್ಟೇ, ದಟ್ಸ್ ಆಲ್. ಕೆಳಗಿನ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಏನಾಗುತ್ತೋ ಅದನ್ನೇ ಸಸ್ಟೈನ್ ಆಗ್ತದೆ.
Court order very clear. There is no order regarding the medical and educational.
ಸರಿ ರೀ, ಅದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡೋಣ, ಕೆಳಗಿನ ಕೋರ್ಟ್ ರೆಸ್ಟೋರ್ ಮಾಡೋಣ ಅಷ್ಟೇನೆ. 1,93,000 ಇದೆ. 30,000 ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಇಂಟ್ರಿಮ್ ಮೇಂಟೆನೆನ್ಸ್.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ 5,000 ರೂಪಾಯಿ ಏನ್ ಕಮ್ಮಿ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ ಪ್ಯಾರಾ 15 ಆಫ್ ದಿ ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಕೋರ್ಟ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಲೆಕ್ಕ ತಗೊಂಡಿರ್ಲಿಲ್ಲ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಡಕ್ಷನ್ ತಗೋಬೇಕು ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಅದನ್ನ 5,000 ರೂಪಾಯಿ ಕಡಿಮೆ ಮಾಡಿದ್ರು.
ಆಯ್ತು, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಡಕ್ಷನ್ಸ್ ಆದ್ರೂ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ ಇವರು?
ಅದು ಮಾಡಿಲ್ಲ. ದಟ್ ನಾಟ್ ಇನ್ ಫ್ಯಾಕ್ಟ್ ನಾಟ್ ದ ಪ್ರೀವಿಯಸ್ ಬೆಂಚ್ expressed the matter has to be remanded to the applied court. So far as the education and medical expenses. Sorry.
15,000 as monthly maintenance towards children and 10,000 to the wife ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಯಾಕಂದ್ರೆ 10,000 plus wife is earning.
ಮೇಂಟೆನೆನ್ಸ್ 16,000 ಬರ್ತಾ ಇದೆ. ನೀವು 1,93,000 ತಗೋತಾ ಇದ್ದೀರಿ.
1 ಲಕ್ಷ ಅದರಲ್ಲಿ ನನಗೆ ಎಲ್ಲಾರು ನಾನು ಇದು ಕಟ್ತಾ ಇದೀನಿ, ಸಾಲ ಕಟ್ತಾ ಇದೀನಿ.
ಸಾಲ ಕಟ್ತಾ ಇರ್ತೀರಿ, ಏನ್ ಮಾಡೋದು? ಸಾಲದ ಜೊತೆಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳನ್ನು
ನೋಡ್ಕೊಳ್ತೀವಿ. ಅದೇನಿಲ್ಲ. Not kindly see notes para 5 minutes of the appeal. For a moment notes para 5 ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ para 5 ಅಲ್ಲಿ ನೋಡ್ಬಿಡಿ, 4ನೇ ಲೈನ್.
ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲ, ರಿವಿಷನಲ್.
ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲೇ
ರಿವಿಷನಲ್.
ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ಈ ಏನ್ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್
ಈಗ ಅಪೀಲ್ ಹಾಕಿದಾರ, ರಿವಿಷನ್.
ಸಾರಿ, ರಿವಿಷನ್ ಅದ್ರಲ್ಲಿ para 5 ಸ್ವಾಮಿ.
ಹೇಳಿ.
The petitioner further submits the respondent behavior is gradually changed and finally the petition came to know the respondent. ಅದು 2 ಲೈನ್ ಓದ್ಬಿಡಿ ಸ್ವಾಮಿ. ಈ ತರ ಎಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಿ ಅವರು ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿ ನಾನು ಆಚೆ ಕಳಿಸ್ದೆ ಅಂತ ಈಗ ನಿಮ್ ಮುಂದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ. This is the allegation.
Respondent behavior is gradually changed and finally the petitioner came to know that respondent is having illicit relationship with his male partner.
ಈ ತರದ
relationship with it. ಅಲ್ಲ, ಅದೆಲ್ಲ ನಮಗ್ ಬೇಡ, ಈಗ ನಮ್ಗೆ
ಅಲ್ಲ. ಅವ್ರು ಹೇಳಿದ ಈಗ ನಿಮ್ ಮುಂದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
We are only with regard to the quantum is concerned.
Not quantum is concerned. Not the trial court has passed the order. They didn't pass the challenge that order. It is the appellant who challenged that order.
ಏನೇ ಹೇಳ್ತಾ ಇರೋದು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಏನಿದೆಯೋ ಅದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡೋಣ ಅಷ್ಟೇನೆ. ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಯಾಕೆ ರೆಡ್ಯೂಸ್?
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅದು not so far as quantum notes 25,000 notes para 15 notes in the appellate court order.
Para 15 ಹೇಳಿ.
Para 15 ಓದ್ತೀನಿ ಒಂದೇ ನಿಮಿಷ. But on going through the material on record, the trial court has given reasons for arriving at the conclusion by awarding rupees 30,000 per month. In page 13, the trial court has given reasons. However, in the entire discussion of the trial court has not considered that quantum of income tax that would be payable by the appellant herein, which would be rounded off to the tune of 30%. If that is taken away, the order passed by the trial court awarding monthly maintenance to the tune of rupees 30,000.
ಏನಾರ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇಷ್ಟು ಕೊಡ್ತಾ ಇದೀನಿ ಅಂತ ಏನಾರ ಹಾಕಿದಾರ? How can the court can comes to such a conclusion 30% anta directly without any material? There must be some material. There must be some material. Whether the court can presume this?
They should have filed the income statement. ಮಾಡಿಲ್ಲ.
Income tax returns ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದಾನೆ ಇನ್ಕಮ್ ಅನ್ನೋದನ್ನ ಹಾಕ್ಬೇಕು. ಅದ್ರ ಮೇಲೆ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. Without any basis, how can the appellate court can reduce it in coming to the conclusion that 30% income tax anta?
Trial court will not say it's lordship is restoring.
ಗಲಾಟೆಗಳು ಇದು. ಹೌದಲ್ಲ?
ಅಲ್ಲ, lordship may remand the matter.
ನೀವೇನಾದ್ರು ದಾಖಲೆ ಹಾಕಿದ್ದು
ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ನಾನು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇಷ್ಟು ಕಟ್ತಾ ಇದ್ದೀನಿ, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇಷ್ಟು ಹೋಗುತ್ತೆ ಅಂತ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ.
And lordship may remand the matter. I will produce the receipts notes for paying the EMI and also this income tax returns to the concerned court.
ಅದ್ ಮಾಡೋಣ. ಇನ್ನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿಲ್ಲ. ಲೆಟ್ ದಿ ಮೆರಿಟ್ಸ್ ಡಿಸೈಡ್ ಆಗ್ಲಿ ಅಷ್ಟೇ.
ಅದನ್ನೇ.
ಅದೇನೆ ರಿಮೈಂಡ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
Let them consider this application afresh.
ಯಾವ ಅಪ್ಲಿಕೇಶನ್?
ಈಗ ಅವ್ರ ಏನ್ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ
ಅದನ್ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಕ್ ಮಾಡ್ತಾರೆ. ಈಗ ಓನ್ಲಿ ಇಂಟ್ರಿಮ್ ಅರೇಂಜ್ಮೆಂಟ್ಸ್ ಮಾಡಿರೋದು.
ಹೌದು.
ರಿಮೈಂಡ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಏನಿಲ್ಲ.
ಈ
How
application.
can the appellate court can presume all these things, counsel?
Therefore, I will place that document.
ನೀ ಅಲ್ಲಿ ಕೊಡಿ.
ಅದನ್ನೇ.
ಬಟ್ ಇಲ್ಲಿ ಕೊಡ್ದಲೆಲ್ಲ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ನ?
The merits ಗೆ ನಾನು
ತಗೊಳ್ಳಿ. Heard the petitioner counsel and also the counsel appearing for the respondent. The present revision petition is filed against the order passed in criminal appeal number 720 of 23, wherein compensation awarded before the trial court was reduced to 25,000 from 30,000. Also on perusal of the order of the trial court an interim maintenance award was passed 30,000 as interim maintenance till the final disposal, and further respondent has to pay the entire school fees of both the children. The above said interim maintenance amount shall be adjustable to the amount, if any, comma, the petitioner is getting towards maintenance from the respondent from any other proceedings. And also directed to pay the maintenance amount 10th of each English calendar month. Medical expenses then separate ಮಾಡಿಲ್ರಿ, ಎಲ್ಲಿದೆ? ಬರೀ ಸ್ಕೂಲ್ ಫೀಸ್ ಅಂತಿದೆ ಅಷ್ಟೇ. And the same is modified by only reducing the same to the 25,000. The appellate court also, while reducing the same, given the reason that the respondent has to pay the income tax, and the same would be rounded off to the tune of 30%. If that is taken, the order passed by the trial court awarding maintenance of rupees 30,000 would be on higher side. Even fails to take note of what is the income of the respondent while modifying such order. Nothing is discussed in the order, and the order passed by the appellate court is nothing but a callous order, without placing any document with regard to making payment of 30% of income tax. Such observation is made is erroneous. And trial court also comes to the conclusion while passing such an order, considering the document, that he is getting salary of rupees 1,93,000. One lakh 93,000, yesterday 500,
1,83,850.
ಇಲ್ಲ ಇದೆಯಲ್ಲ 93,000 ಅಂತ.
1,93,850.
93,000. And the same is also not discussed in the 1,93,850. Same is also not discussed anything in the appellate court order, except making an observation that he has to pay the income tax 30%. Whether he is paying 30% income or lesser, the same also, nothing is placed on record, and hence the order passed by the appellate court is perverse, and hence it requires interference, and hence directed to continue the maintenance of rupees 30,000 as ordered by the trial court, and also directed to
Education expense.
pay the entire school fees of both the children as observed by the trial court and hence a trial court order is restored. ಯಾವ ವರ್ಷ ಇದು ಹಾಕಿರೋದು petition? 22 na?
22.
And the trial court decide the matter on merits considering the income of the respondent as well as the petitioner wife is also drawing admitted salary of rupees 16,000 and also comply with the directions of the Supreme Court
ಅದು ಮಾಡಿದ್ದಾರೆ.
that ಮಾಡಿದಾರಾ? ನೇಹಾ
ಮಾಡಿದ್ದಾರೆ.
ಕೇಸ್
Both of them has filed.
ನೇಹಾ ಕೇಸ್
ಮಾಡಿದ್ದಾರೆ.
direction of the Neha case while determining the quantum of compensation on merits. With this observation, revision petition is disposed of.
Respondent is liberty to produce all documents on merit.
ವಿದ್ಯಾರ್ಥಿ ನೀವೇ ಹಾಕೋಬಹುದು, ಅದಕ್ಕೇನು ಲಿಬರ್ಟಿ ಏನು ಕೊಡೋದು? ನೀವು ಹಾಕಿ ಏನೇನು ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ರಿಲೈ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಮಾಡಿ ಅಷ್ಟೇ. 22.
22. Brinda.
My lordship for the petitioner, my lordship.
Yes, madam.
My lordship is shortly.
181 days, sir. TD
Yes,
of
my
consent.
lordship.
Notice issued to the respondent with postal sara as no such person in this address.
We will find
sir.
that out, my lordship. Whatever was mentioned in the trial court records, we have issued it to that. We will find out that
Madam, now-
address again.
Now you have to ascertain the correct address and take steps.
Please, my lords, we'll do that.
Counsel for the petitioner seeks 2 weeks time to ascertain the correct address and take press steps. And hence 2 weeks time granted. And if correct address is furnished and PF paid within 2 weeks, issue notice against the respondent.
23.
If not paid, list the matter on 19/2. 22.
23.
23.
It's a delay of 467.
Hmm?
It's a delay of 467 days, my lord.
Delay of 467 days.
467 days.
HCGP is directed to take notice and objections ಏನಾರ ಹಾಕ್ತೀರಾ? And seeks time to file objections to IA 1/25. Innobariga. And also issue notice against the respond number 2 on IA number 1 and 2 and also on main. The copy serve ಮಾಡಿದಾರಲ್ಲ?
Serve ಮಾಡಿದೆ.
IS copy, petition copy
IA ಕೊಟ್ಟಿಲ್ಲ.
serve ಆಗಿದೆ.
IA copy ಕೊಟ್ಟಿಲ್ಲ. IA copy ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ.
And counsel and HCGP submits that IA copies are not furnished and hence petitioner counsel is directed to serve the copy of IAs on the HCGP forthwith.
24.
Lankesh L. 466 days delay. Issue notice on IA 1/25 and also main against the respondent. And so also on IA number 2/25.
25.
Srinivasan MOE. 11 days. ಯಾವ್ದ್ರಲ್ಲಿ? 24 ಅಲ್ಲ? 24 ಡಿಲೇ 466 ದಿವಸ ಇದ್ದಾಗ ಹೆಂಗ್ ಪ್ರೆಸ್ ಮಾಡ್ತೀರಿ? ವಾರಂಟಿ ಇಶ್ಯೂ ಆದ್ರೆ ಏನು ಮಾಡಕ್ಕಲ್ಲ, ಮಲ್ಕೊಬಿಟ್ಟು ವಾರಂಟಿ ಇಶ್ಯೂ ಆಗಿದೆ ಅಂದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ನೆಕ್ಸ್ಟ್
25.
ಇದ್ರಲ್ಲಿ 11 ಡೇಸ್ ಇದೆ. ಆಯ್ತು. IA 1/25 is kept pending for consideration since only 11 days is. ಬಾಕಿ ಅಮೌಂಟ್ ಎಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಾ? ಆಯ್ತು. The counsel for the petitioner would submit that entire fine amount was deposited and amount was also withdrawn. And only question is with regard to the sentence is concerned. And hence issue notice against the respondent on IA number, but IA number 2 no bada. IA number 1/25 against the respondent and also Ashbada full stop and also on main petition. Heard on IA number 2/25 and sentence is suspended till disposal of the revision petition since the sentence is questioned with regard to the imprisonment. ಅಷ್ಟೇ. ಅದೊಂದು ಹಾಗೆ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಬೇಕಾಗಿಲ್ಲ, ಸುಮ್ಮನೆ ಹಂಗೆ ಮಾಡ್ಬೋದು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22 ಬರುತ್ತಾ ನೋಡಿ. ಇಮಿಡಿಯೇಟ್ PF ಕೊಡಿ, ಹೋಗ್ಬರ್ಲಿ.
28.
Usman P.
26.
831 days in filing. Issue notice on IA number 1/25 and also IA number 2/25 and also on main petition. ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, 831 ದಿವಸ ಡಿಲೇ. 10-15 ದಿವಸ 20 ದಿವಸ ಆದ್ರೆ ಮಾಡ್ಬೋದು. ಹಾ, ನೀವು 3 ವರ್ಷ ಮಲ್ಕೊಬಿಟ್ಟು ಈಗ ಬಂದು ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡವ್ರೆ ಅಂದ್ರೆ ಶರತ್ ಕುಮಾರ್ GM.
27.
Notice ಬರ್ಬೇಕು. Issue notice on A1 of 25 and also A number 2 of 25 and also on main petition against the respondent. Next.
28.
ಅದು ಸೇಮ್ 60 ದಿವಸ ಅದು ಸೇಮ್ ಮಾಡು. ಹಾ, ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, 60 ದಿವಸ ಡಿಲೇ ಇದೆ. ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ ಏನ್ ಮಾಡೋಣ? ಹಾ, ಆಯ್ತು. ಕೌನ್ಸಿಲ್ is permitted to take out the notice on the counsel who appears on behalf of the respondent before the trial court.
29.
In terms of preemptory order passed with order dated 29/1/25, non-payment of cost ಕೊಡಿ. ಹಾ, ಆಯ್ತು. ಹೇಳಿ. ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿದ್ದೀವಿ ಏನ್ರಿ? ಹಾ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿರಿ, ಎಲ್ಲ ಮನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ನೀವು ಟೈಪ್ಡ್ ಹಾಕ್ಬೇಕು ಅಂತ 21/3/24 ಟೈಮ್ ಕೊಟ್ರ ನಿಮ್ಗೆ ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ. ಮತ್ತೆ 25/7 ಎಷ್ಟರಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿದೆ? 8/11. ಹಾ, ಆಮೇಲೆ 10/12 ಅವಾಗ ಕಾಸ್ಟ್ 500 ರೂಪಾಯಿ. ಆಗ್ಲೂ ಕಟ್ಲಿಲ್ವಾ? 2 weeks time granted to cure the office objections. ಆಗ್ಲೂ ಮತ್ತೆ ಕಟ್ಲಿಲ್ಲ. ಮತ್ತೆ 500 ರೂಪಾಯಿ ಫರ್ದರ್ ಕಾಸ್ಟ್. On further cost of rupees, the court wide order dated and granted 2 weeks time to pay the objections and payment of cost of 100. The cost is paid but office objections are not complied. And further cost ಹೇಳಿರಿ. Further cost ಕಟ್ಟಿದಿರಾ? The counsel submits that he has paid the further cost. ಏನಿದೆ ನೋಡ್ರಿ, ಅದು ಮೆನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ ತೋರಿಸಿ. ಇದೇನ್ರಿ ಹಿಂಗ್ ಬರ್ದ್ ಬಿಟ್ರೆ ಮತ್ತೆ ಇದ್ಯಾರು ನಾವು ಓದೋರು ಯಾರು? ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು. ಈ ತರ ಮಾಡಿದಿರಿ. ಹಾ, ಅದಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಇದು ಏ ಮಾತ್ರನಾ ಮೇಡಮ್? ಮೇನ್ ಅಲ್ಲೂ ಏನಾರು ಹಂಗೆ ಇದೆಯಾ? ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಇಂಡೆಕ್ಸ್ ಕೈಯಲ್ಲಿ ಬರ್ದವ್ರ? ಅದೇ ಆಯ್ತು ಬಿಡಿ, ಕೈಯಲ್ಲಿ ಬರ್ದಿರ ಆಯ್ತು. ಅದೆಲ್ಲ ಸಣ್ಣ ಸಣ್ಣ ಅದು ಏನು ಓದ್ಬೋದಲ್ಲ. Offenses punishment 138 of NAC which confirmed in ತಗೊಳ್ಳಿ. ಕಂಪ್ನಿ ಸೀಲ್ ಇಲ್ವಾ? ಕಂಪ್ನಿ ಸೀಲ್ ಹಾಕಿಲ್ಲೇನ್ರಿ? ಹಾ, ಹಾಕಿದೀರಾ? ಕಂಪ್ನಿ ಸೀಲ್ ಹಾಕಿದೀರಾ? ಲೆಫ್ಟ್ ಸೈಡ್ ಒಕ್ಕಲತ್ತು ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಫಾರ್ ಶ್ರೀ ಎಂಟರ್ಪ್ರೈಸಸ್ ಅಂತ ಇದೆಯಲ್ಲ, ಸೀಲ್ ಪ್ರೊಪ್ರೈಟರ್ ಅಂತ ಇದೆ ಮೇಡಮ್. 2 ಕಡೆ ಸೈನ್ ಮಾಡವ್ರೆ, 1 ಕಡೆ ಸೀಲ್ ಹಾಕವ್ರೆ. ಹಾ, ಒಂದ್ ಕಡೆ ಸೀಲ್ ಇದೆ ಅಲ್ಲ. The office objection regarding seal is concerned overruled. Already put seal in one of the seal, but not put in other signature. One of the signature ಅಂತ ಆಗ್ತದೆ. And the correction made in the prayer in the IA is also readable, and hence the office objection is overruled. This is the matter for admission on 22.
Parted in admission.
Prasanna Kumar P. Heard in part. ಏನ್ ರೀ ಇದು ಮ್ಯಾಟ್ರು? ಹಾ, ಇದೇನು ಸುಮಾರು ದಿವಸದಿಂದ ಏರ್ ಮಾಡ್ತಾ ಇದೀವಲ್ಲ, ಯಾಕೆ? ಹಾ,
Objection is ready, Lord, should kindly take note.
objections ಯಾವ್ದ್ರಲ್ಲಿ?
6/2 of 24 criminal petition.
ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕ್ತಾ ಇದೀರಿ ನೀವೀಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
6/2 of 24.
6/2
of
222 ನಾ?
Yes.
ತಗೊಳ್ಳಿ. ನೀವ್ ಯಾರಿಗೆ? ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್?
Yes, please.
Special counsel for Lokayukta filed statement of objections in criminal petition number 6222 of 24. Copies are made other side ge. Copies are also served on the counsel for the petitioner. ಹ್ಮ್ ಈಗ ಇವ್ರದ್ದು ಆಯ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್. ಸ್ಟೇಟ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತಿದ್ದೀರಾ?
Yes, my lords, last, my lords, the earlier judgment of my lords, my lord, at the page,
ಅಲ್ಲ ಏನ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದೀರಾ?
objections ಏನಿಲ್ಲ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ವಾ ನಿಮ್ದು?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಹಾಕ್ತೀರಾ ಏನು ಅಂತ?
ಇಲ್ಲ,
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಯಾರ್ ಟೈಮ್ ಕೇಳಿರೋದು?
ಇವರು ಲೋಕಾಯುಕ್ತದವ್ರು ಟೈಮ್ ಕೇಳಿದ್ರು.
ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್ ಅಗೇನ್ 6 ಟೈಮ್ ಫೈನಲಿ ವೀಕ್ಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಟು ಫೈಲ್. ಆಯ್ತು, ಇವತ್ತು ಹಾಕಿ ಆಯ್ತು ಅದು. ಆಯ್ತು, ಈಗ ಹೇಳಿ ಇಬ್ರು ಹೇಳಿ, ಯಾರ್ಯಾರು ಹೇಳೋರು? ಫಸ್ಟ್ ಯಾರು ಹೇಳ್ತೀರಾ? ಬರ್ತಾರಾ? ಆಯ್ತು, ಒಟ್ಟಿಗೆ ಹೇಳಿ ಹಂಗ.
ಎಸ್.
ಫಸ್ಟ್ ಓವರ್ ನೀವು ರೆಡಿ ಇದೀರಲ್ಲ? ಕಾಪಿ ಫರ್ನಿಶ್ ಮಾಡಿರೋದ್ರಿಂದ. ಹಾ,
Thirty-one.
31.
Mahendra G, BS.
I appear for the petitioner's counsel, my lord.
ಹಾ.
This was heard on the last occasion.
Hmm.
Mr. Prasad was to get back with regard to the MMDR complaint.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
ನಾವು ಎಸರ್ಟೈನ್ ಮಾಡಿದ್ವಿ ಕಂಪ್ಲೇಂಟು ಏನು ಕಂಡು ಬರುವಿಲ್ಲ ಇದ್ರಲ್ಲಿ. ಕಂಪ್ಲೇಂಟು ಅಂದ್ರೆ MMDR ಒಫೆನ್ಸು ಮತ್ತು IPC ಎರಡೂ ಸೇರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು ಒಟ್ಟಿಗೆ. ಸೊ ಕಂಪ್ಲೇಂಟ್ ಏನಾದ್ರು ಸಪರೇಟ್ ಆಗಿ ಹಾಕಿದಾರ ಅಂತ.
ನೀವೇನೋ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು, ಹಾಕಿದಾರೆ. ಕಾಪೀಸ್ ಹಾಕಿದಾರೆ ಎಲ್ಲ. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ
ಫಸ್ಟ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ವಿ.
ಕಾಪೀಸ್ ಕೊಟ್ರೇನ್ರಿ ನಿಮ್ಗೆ?
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ, ನೀವು ಕೊಡ್ಬೇಕಲ್ಲ.
ಪ್ಲೀಸ್ ಒಂದೇ ಸಿಗ್ತಾರ ಸರ್? ಕೊಡ್ತೀನಿ ಈಗ.
ಅಲ್ಲ ರೀ, ಅದರ್ ಸೈಡ್ ಕೌನ್ಸಿಲ್ ಕಾಪಿ ಇಲ್ದಲೆ ಹೆಂಗ್ರಿ ಹಾಕ್ತಿರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ?
ಇದನ್ನೇ ಕೊಟ್ಟಿರ್ತೀನಿ ಆಮೇಲೆ.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
In this case, my lord, we already filed a final report. First, we filed a final report. After that, my lord, we filed a private complaint also. To annex the entire document. As a final report, document itself is annexed to the private complaint. They taken a contention that, my lord, MMDR Act is concerned, private complaint has to be filed. That is also complaint. In the earlier round of litigation, my lord, other accused also approved this honorable high court. My lord, this honorable high court dismissed the criminal petition. That is also I produced along with my statement of objection. And the only objection raised by the petitioner, my lord, it's a private complaint is not filed. Private complaint is we already filed. And the second contention they have taken that, my lord,
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಒಂದು ಸಪರೇಟ್ ಕೇಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ they have taken and maintained single charge sheet.
ಫೈಲ್ಡ್ ಸಿಂಗಲ್ ಚಾರ್ಜ್ ಶೀಟ್,
single order sheet, sorry,
ಸಿಂಗಲ್
order sheet. They maintained the earlier we filed a complaint, final charge sheet.
Police have filed the charge sheet even including the offense,
Including
MMDR. ಆಯ್ತು.
After that, my lord, your lordship decision in the year 2019.
ರವಿ ಕೇಸ್.
And we filed a
separate
private complaint. That private complaint we have produced.
In the very same court,
Very same court.
Whether court has taken cognizance?
Yes, my lord.
On private complaint?
Private complaint is concerned, my lord, is already taken a cognizance. Once they already taken a cognizance. That is the reason second cognizance is not maintainable. That's why same order sheet is maintained. So after that, my lord, that grounds not available to the petitioner.
Petitioner in view of filing a private complaint.
Yes, my lord. I produced that, my lord. Kindly see page number 130.
ಈಗ ಹಾಕಿರೋದಾ?
Please.
Page number
130.
130.
Please.
ಆರೋಪಿಗಳು.
That's why, my lord, it's a private complaint. Second ground they raised that, my lord, he's not a managing director. That for that contention, my lord, I in statement of objection, I clearly stated in the page number annexure 5, page number 50.
Nim statement of objections alla?
Yes, sir.
Statement of objections, sir.
They raised, at the time of taking the interim order, my lord, they submitted before the Honorable High Court, my lord, he is not a managing director. That's the reason that there is no role at all.
Hmm.
That's why,
This court granted stay.
interim order granted.
Yeah,
I filed a statement of objection.
yeah.
In the charge sheet, my lord, is a managing director is not a party. Because the iron and other minerals procurement is concerned, my lord, this petitioner is a head of that act.
For the transportation is concerned.
The company resolution is there. That company resolution I have produced.
He is in the charge of affairs of
Yes, yes.
transportation of mining.
Mining and other procurement act is procurement is concerned, my lord. He is a head. Page number 50.
Page number
50. Annexure 5.
$50
50.
Ah,
Last one, Binod Chaudhary is a first petitioner.
Binod Chaudhary.
Binod Chaudhary.
Iron
Full-time
ore and
director.
other minerals, procurement, logistics, operations, etc. Roles and responsibilities.
Yes, ma'am.
You like-
He is head of that.
Hmm.
That is the reason, my lord, we made as a party. Managing director is nothing to do with this act. That's the reason that he is made as an accused,
Hmm.
not managing director.
Hmm.
And there is a contention that my lord is not a managing director.
Hmm.
That contention is not available to the petitioner.
Hmm.
And the earlier round of litigation, my lord, I produced annexure R4, page number 25.
R4.
Yes, ma'am.
Ah.
All contention raised by the petitioner,
Ah.
cognizance and all, my lord, is covered by this Honorable High Court, my lord, in earlier round of litigation.
Ah.
Question of taking that once again the same contention doesn't arise.
Hmm. Already dealt with the matter anta.
Yes, ma'am.
Hmm. That's why, my lord, and
ಫಸ್ಟ್ ಒಂದ್ಸರಿ ಇವರೇ ಬಂದಿದಾರ?
ಇಲ್ಲ ಇಲ್ಲ ನಾವಲ್ಲ ಬೇರೆ ಅಕ್ಯೂಸ್
ಬೇರೆ accused,
ಬೇರೆಯವರು ಬಂದಿದ್ದಾರೆ.
ಬೇರೆಯವ್ರು
ಹಾ.
ಬೇರೆಯವ್ರು ಬಂದಿದ್ದಾರೆ. All contention they raise that, my lord.
Similar contentions are taken in the earlier petition.
Yes, my lord.
Ah.
And the all contention, the cognizance is not taken properly.
Hmm.
And all these contention, my lord, raised before this Honorable Court. This Honorable High Court dismissed the petition
Hmm.
filed by the co-accused. That's why that ground is also not available.
Hmm.
And it's a matter of trial. The
Hmm.
second petition is also the head of the Deputy General Manager.
Hmm.
Yes, the entire the act is concerned the instruction of the petition number 1.
Hmm.
He is responsible. Section 23 is concerned, my lord, is very clear. He is also responsible.
Hmm. He is also in charge of
Yes. He's a
A2, A3, Deputy General Manager.
Deputy General Manager.
Hmm.
And all contention, my lord, is raised by the petitioner.
Hmm.
It's a contention taken in the petition. It's
Hmm.
already answered in the earlier round of litigation, and the private complaint also already filed.
Hmm.
And also, my lord, the is in
Hmm.
head of that.
Hmm. Yes, counsel, any reply?
Please, my lord, I have prepared a small note. I would
Ah.
request my colleague to hand it over
Yes.
for the lordship's convenience. ಅದು ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಬಗ್ಗೆ
Hmm.
ಅವ್ರು ನಮ್ ಕಾಪಿ ಕೊಟ್ರೆ ನಾನು ನೋಡ್ಬಿಟ್ಟು ಆನ್ಸರ್ ಮಾಡ್ತಿದ್ದೆ.
This is the duty, kindly see, my lord, this is the duty of the petitioner.
Hmm.
He has to obtain the earlier.
Yes, I have obtained, it is not there.
And
My
30
submission is, Mr.
Kindly see, my lord,
Prasad's submission is
the
not
endorsement is
correct.
there, trial court document is there, trial court document, I have obtained the certificate copy, I produced before this Honorable High Court.
Yes, even I have obtained certified
Honorable High Court,
copy.
my lord, it's a private complaint is not filed.
Hmm.
If that is so, my lord, it's a false submission, it's before the trial court.
Hmm.
And they raise each and every document,
Hmm.
it's the duty of the petitioner.
Please,
And he has to produce, and he has to, instead of that, my lord, I produce the document.
Hmm.
in
And now,
fact,
my lord,
I have
to
obtained
verify my
certified
document, it's a trial
copy.
court document.
Hmm.
My lord, I have obtained certified copy. ಅದ್ರಲ್ಲಿ private complaint ಹಾಕಿದ ಬಗ್ಗೆ ಏನೂ ಇಲ್ಲ. Your lordship may kindly see, in fact, my colleague has the entire order sheet.
Hmm.
This is 41 of 2016.
He also filed the entire copy of the entire order sheet, page number 1 to 29. Copy of the private complaint also produced.
Page number
1 to 129. Today he has filed these documents, order sheet.
Yes, and he is referring to which page, my lord?
ಅದು separate ಇದೆಲ್ಲ ಅದನ್ನ ಅದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟಿಲ್ಲ?
They obtained only order sheet. They are not at all obtained the certified copy of the private complaint.
ಅಲ್ಲ ನಮ್ಗೇನು ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರೆ ನಮ್ಗ್ ಸಪರೇಟ್ ಸಮನ್ಸ್ ಬರುತ್ತೆ, ಅದೇನು ಬಂದಿಲ್ಲ.
ನೀವ್ ಯಾವಾಗ ಸಪರೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದು?
31/12/2000.
31/12?
23/12/2018. Page number 130, my lord, is I produced the document.
ಅದು ನಿಮ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
Private complaint.
ಹಾ, ಫೈಲ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ? 23/12/2018 ಅಲ್ಲಿ.
18.
ಆಯ್ತು, ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೀರಾ?
ಅದೇ ಕೊಡಿ.
ಮತ್ತೆ ಆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ ಅದು. ಹಾ, ಇದಕ್ಕೊಂದು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಮೇಂಟೈನ್ ಮಾಡಿದಾರ? ಏನು
Private, earlier, my lord, we filed.
ಬರೀ ಸೀನ್ ಅಂತ ಹಾಕಿದಾರೆ ಇವ್ರು ಅಷ್ಟೇ. ಇಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸೈನ್, ಅದು ಸೀನ್ ಅಂತ.
Seen.
ಹಾ,
And continue the order sheet, my lord, is the same order sheet, because as per the same document,
ಹಾ,
we had to produce a final report, we had to produce before the court, very same documents.
ಹಾ.
That's why, my lord, the annexes is also same. And the Pradeep Podiar case is concerned, my lord, is Honorable Supreme Court is clearly said that, my lord, is both the cases private
ಟೈಟ್
complaint
ಟುಗೆದರ್ ಅಂತ.
together.
ಹಾ,
That's why, my lord, they maintain.
ಆಯ್ತು. ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ನಿಮ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ?
Earlier,
ಕಾಪಿ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರೀ ಸೀನ್ ಅಂತಿದೆ.
earlier, my lord, they are already taken a kind of cognizance in the.
ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಳ್ಳಿರಿ,
ತಗೊಂಡು.
ಬಟ್ ಅದ್ರ ಮೇಲೆ ಬರಿಬೇಕಲ್ಲ ಆರ್ಡರ್ನ. 23/12/2018 ಅಂತ ಇದೆ ಅಲ್ಲಿ, ಇನಿಷಿಯಲ್ ಇದೆ.
1 moment, my lord.
ಇದ್ರ ಮೇಲೆ ಏನ್ ಆಕ್ಷನ್ ಮಾಡಿರು? ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಮೇಂಟೈನ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ತಗೊಂಡು ದಿಸ್ ಕೋರ್ಟ್ ಆಲ್ರೆಡಿ ಟೇಕನ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಅಂಡ್ ಬೋತ್ ದಿ ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಟುಗೆದರ್ ಅಂತ ಆರ್ಡರ್ ಬರಿಬೇಕಲ್ಲ. ಅದೇಲಿದೆ.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. ತಾವು ಪೇಜ್ 58 ನೋಡಿದ್ರೆ ನಾವು ಕೊಟ್ಟ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
Same certificate copy I have produced.
1 minute, sir.
Page number
Mr.
64.
Prasad, 1 minute, let me complete.
64,
Page 58.
1 second, 64.
ಅದೇನಾಯ್ತು, ಮಧ್ಯ ಬೆಳ್ಳಾರಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ಪೇಜ್ 59 ಇಂದ
EP allowed matter is stayed. ಇದೆಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್ 64 ಅಲ್ಲ?
Sorry, ಅದು 2020.
Your lordship, in fact 64 ತಾವು ನೋಡ್ಬೋದು. third unnumbered para 64 ಅಲ್ಲಿ 29/12/2020 64 ಪೇಜ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು. Third unnumbered para, your lordship may kindly see, Special Investigation Team Karnataka has filed charge sheet against the accused person for offence punishable at section 379, 420, read with 120 of IPC and under section so and so of PC Act, under section 21-23, read with 4141A of MMDR Act, and rules 165 and 144 of Karnataka Forest Rules. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರ ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ಲ,
ರೆಫರೆನ್ಸ್ ಇಲ್ಲ.
ಅದು ಪ್ರಸಾದ್ ಹೇಳೋದಷ್ಟೇ.
ಬಟ್ ಸೀನ್ ಅಂತ
ಹೇಳ್ತಿದ್ದೀನಿ.
ಸೀನ್ ಅಂತಿದೆ ರೀ ಬರೀ
ಸೀನ್ ಅಂತ ಇದೆ.
ಹಾ,
ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. ಬಿಕಾಸ್ ಅರ್ಲಿಯರ್ ದಿ
ಕೇಸ್ ಈಗ ಬಳ್ಳಾರಿಗೆ ಹೋಗಿದ್ಯಾ?
ಬಳ್ಳಾರಿ
ಇಲ್ಲ, ಬೆಳ್ಳಾರಿಗೆ ಹೋಗಿ ವಾಪಸ್ ಬಂತು.
Vivek case is concerned, the committal procedure is not followed in this case. They raise the contention. That is the reason it's a matter sent it back to jurisdictional Ballari magistrate court. And the committal procedure is complete. On that point of time, my lord, trial, the magistrate court taken a contention, but that, my lord, a private complaint is not filed. Page number 60. And taken a cognizance, the committal, sorry. We have no jurisdiction. In the first para, Honorable High Court, Karnataka, it is clear that the magistrate cannot take cognizance the offence of punishable under section MMRD on final report and can take cognizance only on the offence punishable under so and so. In view of the said order, the Honorable High Court of Karnataka and on the other material available record, there is prima facie case material against the accused for the offence punishable so and so, cognizance is taken against the accused number 1 to 15 for the offence punishable under section IPC so and so.
MMDR Act ಅಲ್ಲಿ ಅವರು ಕಾಂಗ್ರೆಸ್ ತಗೊಂಡಿಲ್ಲ. And thereafter, my lord, it's a committal procedure is followed. ಅದರ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಬಗ್ಗೆ ಎಲ್ಲೂ ರೆಫರೆನ್ಸ್ ಇಲ್ಲಿ
ಹಾಕ್ಬೇಕಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಲ್ಲ,
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಮಾಡ್ಬೇಕಿತ್ತು.
ಬಟ್ ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್,
ಈಗ ನಾವು ಮ್ಯಾಟರ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ಬಳ್ಳಾರಿ ಆರ್ ಬಿಫೋರ್
ಬಿಫೋರ್
ಬೆಂಗಳೂರು.
ಬೆಂಗಳೂರು
ಮತ್ತೆ ವಾಪಸ್ ಬಂತ?
ಹೌದು.
ಮತ್ತೆ ವಾಪಸ್ ಬಂದಿದೆ. ಒನ್ ಮೊಮೆಂಟ್ kindly see my lord. Page number 4 I produced it. Page number 4 I produced today along with memo I produced. Page number 4. In earlier round of earlier before committal procedure, perused the final report. Cognizance is taken against the accused number 1 to 5 and 7 to 15. Registered the case against the accused number 1 to 5 and 7 to 15 is issue summon to accused and so and so. On the basis of this cognizance, my lord, they filed a bail application. They obtained a bail. They raised the contention in the earlier round of litigation. Other accused saying that, my lord, it's cognizance is not taken as cognizance is taken as against the accused, not as an offence. But this honorable High Court, my lord, is come to conclusion that, my lord, is even though it's not taken offence and they obtained bail and mentioning the clear provision, that is the reason it's not the ground is not available to the petition.
Law is settled.
Yes.
Cognizance will be taken on the offence, not on the offender.
Yes, my lord. Because of that reason only they raised the contention in the earlier round of litigation before this honorable High Court. This honorable High Court, my lord, taken the opinion, my lord, after the issuance of summons, they filed a bail application and they contested the matter. And that grounds is not available.
ಸರಿ ರೀ, ನೀವು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಏನು ಪ್ರೊಸೀಜರ್ ಆಗಿದೆ?
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು?
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಬರೀ ನಿಮ್ದ್ರ ಇದ್ರ ಮೇಲೆ ಮಾತ್ರ ಇನಿಷಿಯಲ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ ಅವರು.
ಅದೇ ಇನಿಷಿಯಲ್ ಮಾಡಿ.
ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ
in by oversight or I don't know. They have in order also, my lord, discharge application order also, they mentioned the all the provisions and the earlier
ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರು ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
yes, my lord.
ಅದಕ್ಕೆ
Discharge application, my lord, they mentioned.
Your Honor, your Lordship may kindly see my discharge application is at page 117 of the petition papers. The order is from page 30.
Page number 117, I kindly see, my lord.
Let me complete, Mr. Prasad. Wait for a moment. Have some patience. Page 117 is my discharge application. Your Lordship may kindly see this is a special court, which is a sessions court. This is filed under 227. The special judge's order is at page 30. 30 onwards. He, my lord, applies the test that is applicable to provision under 229 and 239 and rejects my prayer. Page 34 onwards, kindly come to page 54.
54 is reasoning, starts from.
Yes,
Point for
reasons,
consideration-
your Lordship
point for
kindly come to.
consideration and reasoning.
ಹೌದು, reasons ಏನ್ ಮಾಡಿದ್ದಾರೆ? 227 apply ಮಾಡಿಲ್ಲ.
In order to attack the criminal conspiracy, meeting of the mind necessary, section 41A is applicable only when the transport of external agency.
Kindly see point number 1, my lord. Kindly see point number 1 on page 54. Whether the applicants accused number so and so have made out that there are no sufficient grounds for proceeding and the charge against them is groundless. 239 test na apply ಮಾಡಿದ್ದಾರೆ 227. That is wrong. Supreme Court has held in the recent decision, you cannot do that.
Reasoning ಎಲ್ಲಿದೆ ನೋಡಿ, ಹೋಗಿ first.
Reasoning, your Lordship gets said.
Is there any reference in this order with regard to the filing of separate
Yes,
complaint?
they filed a complaint, their application, secondary similar 117.
ಆರ್ಡರ್ ನಲ್ಲಿ ಇದೆಯೇನ್ರಿ ಅಂತ ಕೇಳ್ತಾ
ಆರ್ಡರ್
ಇದ್ದೀನಿ.
ಇಲ್ಲ, ಆರ್ಡರ್
ಈ ಆರ್ಡರ್ಲು ಇಲ್ಲ,
ಆರ್ಡರ್ ಇದೆ,
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಆರ್ಡರ್
ಇಲ್ಲ, order ಅಲ್ಲಿ ಇಲ್ಲ. Your Lordship may kindly.
ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Yes, my lord, kindly see page number 55,
Page number 55.
reason.
Ah,
They mentioned all provisions.
provisions mention ಮಾಡಿದಾರ್ರಿ, but reasoning ಏನ್ ಕೇಳ್ತಾ
Reasoning,
ಇದ್ದೀರಿ?
para number
ಅದ್
50.
provision ಏನಂದ್ರೆ ನೀವು ಅವ್ರ application ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದಾರೆ ಅದನ್ನ extract ಮಾಡವ್ರೆ.
50.
Para
para number
15 ಅಲ್ಲ?
14.
Para
Para number 14, sorry, 14C.
14C.
Their contention.
No, 14C is accused 11 and 14. I am accused 2 and 3. ನಮ್ದು page 60 ಇದೆ, para 15A ದಲ್ಲಿ.
Documents collected during the investigation prima facie shows that the accused number 1 company has exported material, but it had not the mining license. According to the prosecution case, the mining so and so transported from Kalahalli mining yard, so and so legally mined, and so company had purchased so and so bill number 7. 12 to 14 are the partners of the accused number 11. Accused number 2 as the managing director, accused number 3 were at the helm of affairs of the said company. Accused number 4 is the owner.
Para number 18 ಗೆ ಹೋಗ್ಬಿಟ್ರೆ direct ಆಗಿ.
Para 18.
18 ಅಲ್ಲಿ.
15C ಅಲ್ಲಿ accused number 2, your lordship may kindly see para 15C on page 61. He goes on a presumption that petitioner 1,
Yeah, that
accused
is
number 2
15
before your lordship is the
15
managing director.
15C only reference what they are doing in the company, that's all.
Tappu, that is wrong. He is not the managing director. Your 15C, your lordship may kindly see, it is further submitted on behalf of the prosecution that accused number 1 company, he is represented by managing director. Accused number 2 as managing director. This is wrong. In fact, your lordship may kindly see their charge sheet. He is the whole time director.
Whole time director, not managing director.
Not managing director. So he proceeds on a wrong presumption. And accused number 3 were at the helm of affairs. About accused number 3, there is nothing. He is the deputy general manager.
14, 15.
So on a wrong presumption, my lord, this order is passed.
Where is the discussion with regard to
14,
the
15, 16.
Stay discussion, no, wrong discussion.
reasoning?
Page 18, page number 18, para number 18 kindly see.
18, in the present case, the traders
Traders
have
conduct, they are
contended
not
that they are
involved
not
in the
involved in
purchase, sale
purchase of
and,
sale iron ore, so the very not required to obtain permit or to pay royalty to the government. The learned SPP has filed upon order in criminal petition so and so. The Honorable High Court in the said order held that allegations made against the accused squarely attract section 41A of MMDR Act. Appearing for behalf of the as well as learned have relied upon the Supreme Court in this Union of India versus Praful Kumar Samal reported in so and so. Honorable Court held that when the material placed before the court disclosed grave suspicion against the accused, justified in so and so. Vijayan case. So
Kindly come to para 21, my lord. I would request your lordship to come to page 70, para 22.
Para 22.
One kade, one barichare. Para 22. The charge regarding criminal conspiracy is always hatched in secrecy, and it is not possible to place direct evidence of the common intention of the accused. Therefore, conspiracy can be inferred from the circumstances, and it is a matter of trial. Now, this is important. In the case on hand, the accused number 1 being the company, and accused number 2 and 3 being the directors and deputy general manager, had exported the iron ore is made out from charge sheet allegation. One kade one munchin paradalli accused number 2 ge managing director andru. Their charge sheet itself says he is the whole time director. Accused number 1 is company represented by managing director. So the entire order, my lord, is botched up.
It's an order on discharge application. It's a typographical error. Documents also, my lord, clearly reflect, my lord, even though he's a director, full-time director, and he is in charge. Only the advocate submission 14, 15, 16 is concerned, my lord.
Trial court cognizance ತಗೊಂಡ್ರದು ಯಾವಾಗ?
Earlier, my lord,
Date, what date?
first time, my lord, in
12/1/2016.
Huh?
12/1/2016, page 3 of order sheet, your lordship gets it.
16.
12/1/2016.
ನಾನು ಇವತ್ತು ಮೆಮೊ ಕೊಟ್ನಲ್ಲ.
ಹಾ ಇದೆ ಇದ್ರಲ್ಲಿದೆ. ಅದೇ 16 ಅಲ್ಲಿ.
ಹೌದು 12/1.
Pair number.
ಆಯ್ತು ರೀ, ವೆರಿ ಟೇಕಿಂಗ್ ಆಫ್ ಕಾಗ್ನಿಜೆನ್ಸ್
14/1/2016.
taking of cognizance for
Yes.
the offense under section MMDR Act is concerned is
Earlier, my lord, what happened? We filed a final report, the IPC offences as well as the MMDR Act.
ಹೌದ್ರಿ, MMDR offense ಗೆ ತಗೊಳಕ್ ಬರಲ್ಲ ಪೊಲೀಸ್ ಕೇಸ್ ಮೇಲೆ.
They have taken. After that, my
That
lord,
is wrong.
that is wrong. That is wrong. After that, my lord,
Then you have filed an private complaint.
complaint.
Then private complaint ಮೇಲೆ process ಆಗ್ಬೇಕಿತ್ತು.
Private.
ಈ order taking of cognizance in respect of MMDR offense is concerned, it is illegal.
Yes, my lord.
Then you have filed a private complaint.
Yes, my lord.
Then private complaint ಮೇಲೆ ಏನು process ಆಗಿಲ್ಲ ಇಲ್ಲಿ.
That's why.
No doubt you have filed a private complaint before the very same court.
Please.
But court ought to have taken cognizance on the private complaint. Now your argument that already cognizance is taken, cannot take once again cognizance cannot be accepted, your argument. The very taking of cognizance earlier is illegal.
That's why. That's why, my lord.
Now private complaint ಮೇಲೆ process ಆಗಬೇಕಿತ್ತು.
Annexure R4 in my statement of objection.
ಆಯ್ತು, R4 ಏನದು?
R4, this honorable High Court decision. They have raised this contention before this honorable High Court. This matter is already
dealt with ಅಂತನಾ?
yes, my lord.
ಏನಾಯ್ತು R4 ಏನ್ ಹೇಳಿದಾರೆ ಅವರು?
R4 judgment.
ಏನಂತ, ಏನ್ ರೀಸನಿಂಗ್ ಏನ್ ಹೇಳಿ?
Cognizance.
ಅದು taking of cognizance against offender, ನಾವು ಆ ಪಾಯಿಂಟ್ ರೇಸ್ ಮಾಡೇ ಇಲ್ಲ.
R4 ಯಾವ್ದದು?
ಪ್ಯಾರಾ 14 ಹೇಳೋದು.
High Court judgment.
ಹೇಳ್ರಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳ್ರಿ. ಏನು
Paragraph starts from para number 11.
ಈ ಟೇಕಿಂಗ್ ಆಫ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಬಗ್ಗೆ ಏನಿದೆ?
Yes, my lord. That's para number 11. Type to page number 14.
11 ಅಲ್ಲ? ಹೇಳಿ, ಏನ್ 11 ಅಲ್ಲಿ?
Coming to the objection relating to the validity of the cognizance taken by the learned special judge in the consequence orders summons issued by the petitioner is concerned. Perusal of the order sheet produced by the petitioner indicate that perusal of the FIR, charge sheet, seizure mahazar, documents collected by the investigation officer. Learned special judge has taken a cognizance of the alleged offences and is been issued to the petitioner. This order clearly reflects that the application of mind considers the material leading issuance of summons. The offences in respect of which summons are issued are also detailed in order. As such, no fault could be found with the imprint order. However,
the difficulty arises in respect of the offence and provisions of MMDR section 22 of the Act creates a risk.
Cognizance.
And the court in taking cognizance of the offence under the Act, the section reads as so and so. Learned counsel of the petitioner accused has placed heavily reliance on the judgment of so and so Sanjay and so wherein it is held under so and so. What emerges from the above decision is that based on the final report filed under 173 of the Act, special court cannot take cognizance of the offence under the MMDR Act. Apparently, to get over this restriction, the respondent appears to have filed a complaint in each of the proceedings before the special court in terms of section 22 of the MMDR Act. The learned special public prosecutor for the respondent has made available copies of the complaints filed by the authorized officer before the learned special judge. It contains the very same allegations as found in the charge sheet submitted by SIT. These complaints therefore could be taken as due compliance of the statutory requirement prescribed in 22 of the Act, but the question still remains to be considered is whether mere filing of the complaint can be said to that special court has taken cognizance of the offences based on the said complaint, as mandated in section 22 of this MMDR Act. Though it is relevantly argued by the counsel for the petitioner accused that such exercise has not been done by the special court as the impugned order. Cognizance does not deflect that the special judge has looked into the averments made in the complaint yet. What is significant to be noted is that allegations made in these complaints as well as the facts constituting the offences alleged against the petitioner accused in the final report filed by the SIT are one and the same. Under the said circumstances, if the learned special judge has looked into the allegations made in the final report filed by the SIT and on satisfying himself that these allegations prima facie disclose the commission of offence by the petitioner accused under IPC as well as under the MMR Act, it could possibly be held that the learned special judge has taken cognizance of the offence in terms of section 22 of the MMR Act. In drawing the above conclusion, I am fortified that the observations of the Honorable Supreme Court in the case of Fakhruddin so-and-so, wherein it is observed that whether magistrate has or has not taken cognizance of offence will depend upon circumstances of the particular case, including mode in which case is sought to be instituted and the nature of preliminary action. No doubt, even in the said case, it is held that before a magistrate can be said to have been taken cognizance of an offence, it is imperative that he must have taken notice of accusation and applied his mind to allegations made in complaint or in police report or information received from the sources report than a police report. As the case may be on material filed therein, it is only when the magistrate applies his mind and it is satisfied that allegations if proved would constitute the offence under the said initiate proceedings against the alleged offenders that it can be positively stated that has taken cognizance of the offence. Complaint constitute an offence on so-and-so, so-and-so under section 200. Result of inquiry. Report of investigation. Same situation. Same situation, the court has answered that once the complaint was filed, the allegations made in the earlier police report under section 173 and also complaint filed under the special enactment, court has taken the cognizance that is proceeded. No need to pass an order of taken cognizance. That is the observation in paragraph number 18.
Please, I will answer
I
that.
hold that the
Lord,
cognizance taken by the learned special judge and the summons issued by him in respect of MMDR offences is in accordance with section 42 of the MMDR Act.
Correct. Specific cognizance bekanta illa anta. But what happened to the complaint? It is not there. It is a false submission. Your Lordship may kindly come to page 25. First page of the order. Adral enagide 4 case ide of the same petitioner. If your Lordship would kindly turn to page 25.
Complaint is what proceed ಆಗ್ತಾ ಇದೆಯಾ?
Illa ಆಗ್ತಾ illa. That is the problem. May I suggest one thing, my lord? Pakkadalle ide court.
I will direct the trial court. Consider the same and proceed. Both. Third, these revision petitions are filed. Ondena?
One submission.
1518.
One submission. Their application also 227 application also they mentioned all provisions. They are submitted before the Honorable Court called there our simultaneous ನಡೀತಾ ಇಲ್ಲ ಅಂತ. Simultaneous ನಡೀತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Kindly see their the application.
ಇಲ್ಲ ನಡೀತಾ ಇಲ್ಲ.
Applications ಅಲ್ಲಿ ಎಲ್ಲಾ provisions ಇದೆ.
Application ಎಲ್ಲಾ provision ಆಗಿದೆ. ಎಲ್ಲಾ provision ಮೇಲೂ ಆರ್ಡರ್ ಆಗಿದೆ.
May I make one request, my lord? ಪಕ್ಕದಲ್ಲೇ ಇದೆ ಕೋರ್ಟು. Your Lordship may kindly direct the trial court to clarify whether a private complaint arising out of.
I will clarify in the order itself.
ಅಲ್ಲ ನಾನು ತಾವು ಫೈನಲಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು, ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ ಇದ್ರದ್ದು. ನಾನು ಒಂದು ಕಂಪೈಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೆ.
ಹೇಳಿ, ಇದೆಯಲ್ಲ
29(1)ಗೆ. Now this first one, my lord, is Sanjay Dutt and others versus State of Haryana.
Paragraph, which paragraph?
Paragraph 11 and 13. ಅಲ್ಲಿ ಚಾರ್ಟ್ ಅಲ್ಲೇ ಬರ್ದಿದ್ದೀನಿ.
11 and 13.
There, my lord, they say merely because the whole-time director or a director is there, he cannot be mechanically proceeded anta. Now it is not our contention that company will not face prosecution. Company, my lord, will face prosecution represented by the managing director. So these accused, petitioner number 1 before your lordship is arraigned only because he is the whole-time director. And petitioner number 2 is the deputy general manager. So all of them have been roped in. There is no specific allegation at all in the charge sheet. Now, similarly, my lord, this serial number 234 also of the compilation pertain to the same proposition. In my chart, my lord, I have in the second one, that is Sunil Bharati Mittal, important paragraph is 42 to 44 on page 41. Then third one, my lord, Ravindranath Bajpayee, 2215 SEC 430. Important paragraph 8.2, 8.3 and 9 on page 59 to 60.
Page.
Page 59 and 60. Ink page.
59 and 60.
Howdo.
Paragraph number 8.
8.2, 8.3 and paragraph 9 on page 60. Now, next one, my lord, is Narendra Kumar A. Baldota.
Yes.
That is 22 SEC Online SC 1880, page 68 and 70. 68 to 70, paragraph 26 onwards.
26.
Yes, in that Ravindranath Bajpayee is referred 26, 27, 27 and 28.
Majanlal case.
Now the next one, my lord, is Standard Chartered Bank. This is a constitution bench judgment. That is, it commences at page 76. Important page is page 102. That is paragraph 30 and 32. There the Honorable Supreme Court, this is constitution bench judgment. Supreme Court says, even if company is an accused and the minimum sentence is that of imprisonment, company cannot be sent to jail, but fine will have to be imposed. So in fact, in para 32, they say on page 103, we hold that there is no immunity to the companies from prosecution merely because prosecution is in respect of offences for which punishment prescribed is mandatory imprisonment. We overrule the views expressed by the majority in so and so on this point and answer the reference accordingly. In fact, para 31 is also important, my lord, on ink page 102. As the company cannot be sentenced to imprisonment, the court cannot impose that punishment. But when imprisonment and fine is the prescribed punishment, the court can impose the punishment of fine, which could be enforced against the company. Such a direction is to be read into the section so far as juristic person is concerned. Of course, the court cannot exercise the same discretion as regards a natural person. Then court would not be passing the sentence in accordance with law. As regards the company, the court can always impose a sentence of fine and the sentence of imprisonment can be ignored as it is impossible to be carried out in respect of a company. This appears to be the intention of the legislature and we find no difficulty in construing the statute in such a way. We do not think that there is a blanket immunity for any company from any prosecution for serious offences merely because prosecution would ultimately entail a sentence of mandatory imprisonment. The corporate bodies, such as firm or company, undertake a series of activities that affect the life, liberty, and property of the citizen. Large-scale financial irregularities are done by various corporations. The corporate vehicle now occupies such a large portion of the industrial, commercial, and sociological sectors that amenability of the corporation to a criminal law is essential to have a peaceful society, stable economy. So, my lord, my respectful submission is, accused number 1 is company represented by managing director. So we are not shirking our responsibility from trial. Now we are only, in fact, we have withdrawn the revision petition filed. In my note, your lordship may kindly see, note given today, point number 2, we have withdrawn criminal RP 1392 filed by the company on 8/7. So we will face prosecution. Now, as regards discharge, my lord, the other judgments, that is judgment number 6. Honorable Supreme Court, my lord, on page 135. It starts at page 123, 2021 5 SCC 435. The Honorable Supreme Court on page 125, my lord, says that in deserving cases, the accused have to be discharged. Page 135 and 137, para 23. Page 137 of my compilation of judgments.
$135.
135 only it starts. That is para 18. Now kindly turn to page 137, paragraph 23. Para 23, my lord. As aforesaid, the trial courts and the magistrates have an
Yes.
As aforesaid, the trial courts and the magistrates have an important role in curbing this injustice. They are the first lines of defense for both the integrity of the criminal justice system and the harassed and distraught litigant. We are of the considered opinion that the trial courts have the power to not merely decide on acquittal or conviction of the accused person after trial, but also the duty to nip frivolous litigations in the bud even before they reach the stage of trial by discharging the accused in fit cases. This would not only save judicial time that comes at the cost of public money, but would also protect the right to liberty that every person is entitled to under Article 21 of the Constitution. In this context, the trial judges have as much, if not more, responsibility in safeguarding the fundamental rights of the citizens of India as the highest court of this land. So, my lord, this was the judgment of the Supreme Court in 21. Subsequently, my lord, this has been reiterated in 24. Your lordship may kindly turn to page 140. 2024 SCC Online SC 1709. Relevant paragraph 22 on page 148.
Yes.
Paragraph 22. In cases where it appears that said offense is one triable exclusively by the Court of Session, the magistrate will have to commit the case to the Court of Session. I'll skip around 15 lines, my lord. Kindly come to around 16th line. It starts at, when that be so. Your lordship got it?
When?
Ade para 22 dalli. One 15 line between 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. 22nd line, your lordship may kindly come to.
When that be so.
When that be so, in a case where an application is filed for discharge under 227 CRPC, it is an irrecusable duty and obligation of the court to apply its mind and answer to it regarding the existence of or otherwise of ground for proceeding against the accused by confining such consideration based only on the record of the case and documents submitted therewith, and after hearing the submission of the accused and the prosecution in that behalf. Now, my lord, my respectful submission is I have taken your lordship through the order of the trial court, special court. In one place, he says petitioner 1, accused 2 is managing director. In other place, he says director. There is no finding at all. And as far as second petitioner, that is accused number 3, he is the deputy general manager. Nothing
Yes.
on record. Now, my learned friend, my lord, Mr. Prasad, referred to page 50 of his objections with regard to petition number 1, accused 2.
Yes.
So 227 application, ours is a 227 application. The test of 239 is applied. I took your lordships through the order. Test of 239 is applied. So there itself, the learned special judge has missed the board. Then, my lord, he says he is the managing director. No, wrong. That itself would show that the learned special judge has not applied his mind.
Yes.
And at another place, he says director. He has not even gone through the charge sheet. In fact, in the charge sheet, my lord, second page itself, that is page 77 of the petition papers, page 77, clearly the prosecution has mentioned 77 of petition papers.
Yes.
Accused number 1, Messrs. Jimpex Limited Company.
Yes.
ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಶ್ರೀ ಸಮೀರ್ ಗೋಯಂಕರ್ ಅವರಿಂದ ಪ್ರತಿನಿಧಿಸಲ್ಪಟ್ಟಿದೆ. So now accused number 1 is facing prosecution through the managing director. Now kindly turn to page 79.
Yes, counsel, continue.
Yes, page 79, my lord. Accused number 2, Binod Kumar Chowdhury, who is the first petitioner before your lordship. Udyoga, occupation, Nirdeshakaru, Messrs. Jimpex Limited, Chennai. Then further, my lord, in the charge sheet, they say he is the whole-time director, which we do not dispute.
Yes.
Then on page 81, that is accused number 3, petitioner number 2 before your lordship. He is the deputy general manager, Jimpex Limited.
Yes.
And my lord, kindly come to my discharge application on page 117.
Yes.
There, my lord, I say on page 120, I have mentioned the allegations. Page 120, para 6 of the discharge application, I say, my lord, that the further allegation against these accused is that for a period from so-and-so, Bhumika Enterprises, etc., together totaling 9,090.200 metric ton of iron ore was illegally exported. That is para 6 on page 120.
Yes.
This, my lord, I have called out the allegation made by prosecution. Now kindly come to page 35 of the order, the manner in which, my lord, the learned special judge has dealt with. Kindly come to page 35 of the petition papers. Para 2C. The learned special judge says, my lord, the accused have admitted that the allegations made against them in the charge sheet are that they have transported so-and-so. Nowhere have we admitted. We have only said the allegation is this. So, my lord, this being the approach, I am a senior citizen aged around 70 plus, the first petitioner. Second petitioner is Deputy General Manager. So they have been mechanically prosecuted. Both are suffering from cancer. Unfortunately, of course, that is not a ground, my lord. So in the light of the decision of the Honorable Supreme Court, their prosecution would be futile. The first petitioner, the first accused company is represented by Managing Director. And as per the provisions of 305 CRPC, my lord, I will face prosecution. And as per the Constitutional Bench judgment of Standard Chartered Bank, the company will face prosecution. These two accused can be discharged. And now there is so much of confusion about MMDR Act. If at all there is a complaint pending, that can be clubbed with this against the company, and the company will face prosecution.
Yes. That's all.
Please, my lord, one clarification as far as page 50 of the objections which my learned friend, Mr. Prasad, referred to in the statement of objections. This is a document of the year September 24, 2014. Regarding first petitioner Binod Chaudhary, that is second accused. As far as second petitioner, my lord, Mr. Sheshadri, there is nothing on record, not even a scrap of paper. Just because he is the Deputy General Manager and this man being the whole-time director, they cannot be mechanically prosecuted without there being a specific role assigned to them. That is the law, my lord, which I have placed for your lordship's consideration, including the latest.
Yes.
So, my lord, my respectful submission and prayer to your lordship is, company will face prosecution. As far as the present petitioners, they have been unnecessarily prosecuted. They may be discharged, my lord. We are not shirking away from a criminal trial.
Yes.
That is my respectful submission.
Yes.
You already answered that, why is made as a party? It's their own document show that it's is responsible letter. And they are not produced any other document during course of
Right.
investigation.
You are relying upon R5.
Please. And
What about second petitioner, Deputy
second,
General Manager? Is
Section 23 is very clear, my lord.
Right.
At the instruction of the any director, they are not disputing that my lord is a Deputy General Manager. He is agreed that my lord is a Deputy General Manager. That is the reason at the instruction of the director, he did some work, my lord. That's why he is also responsible. And all decisions, my lord, they relied upon is not applicable to this case, because the document itself is a prima facie case that my lord, as against these petitioners. And the earlier round of litigation, my lord, earlier round of the petition, my lord, answered all earlier questions, cognizance and all.
Similar grounds were answered in the earlier decision.
Yes, my lord.
R3.
R4.
R4.
And their age criteria and all, their citing that, my lord, this Honorable High Court may direct the trial court dispose of the matter within 3 months or 4 months. We are cooperate the inter proceedings. Their urge for age criteria.
Whether evidence has been commenced?
The discharge application is dismissed. And once again, they approached this Honorable High Court. It's before this, so 4 years it was pending.
Stay
After
granted.
that, my lord, is 3 years. Because of the petitions and all accused person, my lord, is delaying the process. That's why, my lord, this Honorable High Court, the direct the trial court, dispose of the matter within 6 months. We will cooperate.
But Supreme Court says, don't give any directions to the trial court to dispose of the matter within time-bound period.
It's my
That
submission,
was
my
the
lord.
judgment of
Because
last
both
week.
the parties agreed. And
Last week.
both the parties agreed. We are cooperating. Then court may direct the trial court the pendency of work. On that basis, priority may be given to this case and dispose of the case before the trial court.
Right. Heard reserved.
My lord, one small clarification. As far as annexure R4, which my learned friend is.
Counsel, after hearing you, other side I also heard no reply to reply.
Alla reply alla, avaru annexure
No
R4
end to this.
R4 repeatedly refer ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ we are not parties.
ಆಯ್ತು.
It's the same claim number.
Same crime, but party, not party.
Not party, same,
And no, not
the
same
question
crime.
is raised and the question, that question is answered.
ಆಯ್ತು. Similar question is answered according
Yes.
to you.
No, according to me it is not.
Hmm.
Grateful, my lord.
Yes.
Two, Mohan PS,
32.
Panna Gowda K.
That's for responding.
ಈಗ್ಲ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರಾ?
Ah.
ಆಯ್ತು.
Formally object, but it may be allowed. Formally object, it may be allowed, my lord. Really ಅಂತ may be allowed.
ಆಯ್ತು. ಎಸ್ ಮೇಡಮ್. ಪಾಸ್ ಓವರ್ ಮತ್ತೆ. ಹಣ ಸಾಲ ಒಪ್ಪಂದ ಪತ್ರ. ತಗೊಳ್ಳಿ ಪಾಸ್ ಓವರ್.
Admission matter 33, Prakash Shetty.
ವಿನೀತ್ ರೆಡ್ಡಿ ಇಲ್ವಾ? ಹೇಳಿ, ನೀವ್ ಹೇಳಿ. ಅವ್ರೇನ್ ಬರ್ತಾ ಇಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಬಂದಾಗಿರ್ಲಿಲ್ಲ. ಲಿಕ್ವಿಡೇಟರ್. ಹಾ. ಹ್ಮ್. 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 ಹ್ಮ್.
Complaint filed by one Prabhakar Parsi.
ಹ್ಮ್. ಹ್ಮ್.
He gave an evidence.
ಹ್ಮ್.
Complaint filed on 28/1/2009.
ಹ್ಮ್.
He gave statement on 24/3/2009.
ಹ್ಮ್.
Then he files a complaint on 24/3/2009 against Revisional.
ಹ್ಮ್.
For modification for.
ಹ್ಮ್.
Pursuant to the summons, he actually saw the document and the case was. Thereafter, one main CH-12.
ಹ್ಮ್.
Assistant Secretary of a small company files a complaint against Prabhakar Parsi and the company's then employees. On 30th March 2010. Software payment and
ಹಾ.
the complaint was registered and in the starting
ಹಾ.
So, the Mahendra Singh Chawla,
ಹ್ಮ್.
without seeking permission of the government magistrate,
ಹ್ಮ್.
if evidence 27/12/2010,
ಹ್ಮ್.
without seeking permission, he filed a complaint and without filing authorization letter.
Permission from whom?
The court. It's a company has to only have to take a permission if other person comes for evidence for the case. Permission. And he was father than me. One.
In a case of 138, why the court has to give permission? Under what provision?
Company is a legal represented by human beings. But,
Yeah.
like to represent the company.
On what capacity has filed the private complaint?
Without taking any documents.
Regional manager, Mr. Prabhakar Parsi.
They should a complaint has been and it is now very started. Now, PW1 is to manual say. So producing a document, in the evidence he has taken condition that voluntarily he has stated that Prabhakar Parsi has taken self-decision to file a case. And also he has actually some other this will be convicted on the own government. P46 and reply. The lots of PW DS indicated in 46 issued by the company. Despite this, the complaint was
What is your reply? In exhibit P 46,
46, I have not issued,
reply notice issued by the accused ಅಂತಿದೆ.
That's the only one, that's what I will read the cross hospital.
Hmm. Hmm.
The bill does not know how to direct it from there. And see, 21 and 8.
Hmm.
Upon the top and the seats conversation level 3. I have not used any document to show that how these it's very personal. There are 3 directors in the company. They are my team member and I did not know the name of other 2 directors. It will go when the company has started.
Hmm.
The regional manager here, it is some decision. Correct to state that company is not intended to be or it's not correct to state that we are not mentioned the both of governments of labor.
Hmm. Hmm.
Board of Directors applies to file complaint. Verification. If not, it will be self-decision taken and to file the case. Then you got NCD. One statement by one by court of person.
Hmm. Hmm. Hmm.
Bangladesh name is not only in the environmental context.
Hmm.
People,
42. 52. Hmm. ಯಾವುದು document? 52 is memorandum of association, articles of association. ಹಾ. ಯಾಕೆ ಹಿಂಗ್ ಹೊಡಿತಾರೆ ಮೇಡಮ್ ಇದನ್ನ? ಪೂರ್ತಿ ಒಂದಾಗ್ತಿದಾರಲ್ಲ ಈಗ ತೆಗೀರಿ. Page number? ಹಾ. Directors. ಹಾ. Page? In the very same document. Sonia J. Mehta.
And his name is not there. Mehta is in well settled states, he's not in India. Borrowed 7,000 crores and defaulted. His name is not on any of the.
Hmm. 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 Yes, counsel. Hmm. Hmm. 39? 24. Ah. Hmm. Hmm. 13 to 2018. Ah. Hmm. 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 Hmm.
action cover people security companies paid well company operated by
Hmm. Hmm. Why you did not bring it to the court notice? Hmm. 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 Yes. Hmm. Hmm.
So the complaint on behalf of company could be presented and considered by a forum of
Hmm. Yes. Hmm. 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 ಯಾವ್ದೋ ಎಕ್ಸಿಬಿಟ್? ಹಾ, ಈಗ ಹೇಳಿದ್ರಲ್ಲ ಅದರಲ್ಲೇ. ಹ್ಮ್. ಹ್ಮ್.
let it come at least a plus 12. This should conduct effect compound according to state has the first 164. There is appointment of many director, no one concerned with the authorization letter.
Yes.
Even of the company side, itself is not made.
Sir. Third result.
T4,
54.
Halashetty Jagdish.
Respondent. 40% ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ? ಆಯ್ತು ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ವೈ ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಹಿಂದಿಂದು ಏನಾಗಿದೆ ನೋಡೋಣ. ಪ್ರೀವಿಯಸ್ ಡೇಟು
ಸರ್ವಾಗಿರ್ಲಿಲ್ಲ.
Submit that he has received the information that order of suspension sentence condition has not been complied. Hence, learned counsel for petition is directed to submit regarding compliance. Directed to serve the copy of the petition on the learned counsel for the respondent forthwith. Really the compliance.
Submit ಮಾಡಿದೀನಿ.
ಮಾಡಿದಾರಂತಲ್ರಿ?
ಆಯ್ತು.
Sorry, counsel for the petitioner submits that already complied the order passed by this court and seeks 2 weeks time. And counsel for the respondent present list this matter on 22. Next time no adjournment, madam.
35.
35, Kumara KG.
Let's say, petitioner is my lords, one of the partner. There are 3 partners, my lords, to the firm, partnership firm. Plus the other 2 partners, my lords, they have not challenged. But this petitioner is the 3rd partner, my lords, is made as a 3rd accused. My lords, the transaction in the year of 2012. My lords, check was issued in the year 2004.
For the
Respondent,
Yes.
Check for the
Check was issued by the firm, my lords, in the year of 2014. 15. My lords, in 14, my lords, this petitioner, my lords, resigned from the partnership firm. My lords, with respect to that, my lords,
On what date he has resigned?
my lords, 2014.
14.
15 ಈ ಕೇಸ್ ಹಾಕಿದ ಮುಂಚೆನೆ he's resigned from the
Yes, ಹಾಕೋಕ್ಕಿಂತ ಮುಂಚೆ, but check ಕೊಡುವಾಗ
ಆಯ್ತಾ he was there.
he was there.
My lords, the 3 partners, my lords, his liability, my lords, even though considering his liability, my lords, only, my lords, 10 lakhs check. My lords, 3,33,000, my lords, he already paid to the accused number 1. My lords, he replied, my lords, to the notice issued by the complainant. My lords, accused number 1 has replied. My lords, he's performing the duties of the firm on the day of, my lords, issuance of notice and also the check. But my lords,
But as on the date of transaction, he was
Yes,
in the
I
affairs
was-
of the company.
yes, my lords, I was also the my lords, partner. My lords, now, my lords, he has discharged his liability, my lords, he has paid the 3,33,000, my lords, that was admitted by the, my lords, even the complaint and also the accused number 1. Saying that, my lords, his liability with respect to the 10 lakh, he has repaid the 3,33,000 to the accused number 1. In the evidence also, my lords, it's shown that, my lords, he was repaid. Plus exhibit P 28 and 29, my lords, to the resigning of the company, my lords, he also taken the paper publication. And also, my lords, he has submitted all the bank statement saying that, my lords, he was paid the amount. His liability paid to the accused number 1. My lords, then accused number 1 and 2, my lords, the partners, they have not contested the, they have not challenged this order, my lords. Now, my lords, the court has passed an order, my lords, saying accused number 1, the firm is convicted for 1 year and also pay the amount of rupees to 20 lakhs. Double the check, my lords, they have made. But, my lords, his liability is not there, my lords, as per, my lords, exhibit P 28, 29, 27, my lords. And all, my lords, they have not challenged. My lords, I don't know, my lords, whether they have executed the order against the accused number 1 and 2. whether they have recovered or
check,
that is also not clear.
the check dated is 26/5/2013. And the notice was issued on 28/8/2013. Then the one Ravi Prakash, he replied it on 3/9/2013. Thereafter, this complaint was filed and it was contested. And according to the petitioner over here, he retired from the partnership firm on 1/2/2014. That is after the transaction. That is on the date of dissolve of the check. He was a partner. It's admitted in his cross-examination also. Whatever the amounts he had paid to the accused number 1, it is not with me, not to me. He has not paid any amount to the complainant. Therefore, he paid that amount to accused number 1. That's his duty to collect the amount from him in whatever fashion he wants. But according to me, he is liable to pay the amount as per the orders of this there's a lower court. Therefore, on the date of transaction, he committed an offense under section 138 of the Act. That's my contention.
That's one
Therefore,
question is still
even
remains, my lords, whether they have
Yes,
executed.
Even he has appealed before the district judge. Even the district court upheld the same order of the lower court. Therefore, he came before this honorable court again on the same bench. Therefore, this revision petition should be
You
dismissed.
made the payment in favor of accused number 1.
How one ಕೊಟ್ಬಿಟ್ಟು his, my lords, his liability was discharged. My lords, that was admitted by the accused number 1. And also, my lords, now, my lords, another question remains, my lords, whether the complainant has executed the order in favor of accused number 1 and against the 1 and 2 or not, my lords. There is no such averments in the even appeal in the appellate court. Or, my lords, they have recovered from the firm or also, my lords, there is no such my lords statement. Because they also convicted, my lords.
Because in order they have specifically made it
Plus,
that
the
all
kindly
the
see
three
the
are
order.
liable and in equal proportion. Therefore, we have already initiated action, but so far notice has not been served on them. Now, because even they have preferred appeal before the district court, now that is dismissed. Now we are initiated. Now this petitioner has come before this honorable court. Therefore, we are waiting for it again. DW3 evidentially clear ಆಗಿದೆ. He admitted everything.
And they are also not disputing with regard to the transaction is concerned.
They are also not disputing. We are also not disputing, my
disputing.
lords. We are also not disputing, my lords.
Supreme Court also, the appellate court also relies upon the judgment of the Supreme Court.
Yes, my lords. The Supreme Court said, my lords, because you are the partner at the time of the transaction.
So RSR Engineering Works Limited.
Yes, my lords. On the day of the transaction, you are the partner, my lords. Now, my contention is, my lords, whether they have recovered from the accused number 1 or 2, my lords.
ಮಾಡಿದಾರ ಇಲ್ಲ ಅದನ್ನ, that is not the ground counsel.
And now, my lords, the trial court also, because I am resigned.
It's
What is the my liability, my lords? That nothing is said by the trial court or the high court.
Liability separate ಮಾಡಕ್ ಬರಲ್ಲ.
None, my lords, that is
ಅಲ್ಲ,
contention, because I have resigned.
ಕನ್ನಡ ಕೋರ್ಟ್ ಅಲ್ಲಿ 3 ಜನಕ್ಕೂ 3 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಕಟ್ಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is
ಅಲ್ಲ, ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅದನ್ನ.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರ ಹಾಗಂತ.
ಇಲ್ಲ, ಅದನ್ನ ಹೇಳಿಲ್ಲ.
ಹೋದ್ರೆ ಇವ್ರು 3 ಜನ ಲೈಬಲ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಇವರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ 3 ಲಕ್ಷ ಚಿಲ್ಲರೆ ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆ.
Lords, that if that has passed, my lords, I am ready to, my lords, deposit.
Very upward.
My liability, I am ready to deposit, my lords. Now, entire amount, my lords.
ಅದರಿಂದ 3 ಜನ ಲೈಬಲ್ ಅಲ್ಲಿ
ಅದೇ ಸೆಗ್ರಿಗೇಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. ನೀವು
segregate ಮಾಡಕ್ ಆಗಲ್ಲ ಸರ್.
ಅವ್ರ ಕಡೆ ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
Plus, they also preferred an appeal before the session court, my lords, that is dismissed, whether they have challenged before this court.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಅವ್ರು ಇಲ್ಲಿ ಹಾಕಿದಾರೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ. Plus, whether they have deposited, because my lords, there deposited almost 20%. So almost 60% ಅಲ್ಲೇ deposit ಮಾಡಿರ್ತಾರೆ. Now my lords have deposited 50% here. You total almost my lord deposit ಮಾಡಿರೋದೇ ಅಷ್ಟು ಬಂದ್ಬಿಟ್ಟಿರುತ್ತೆ ಅವರಿಗೆ. That my lords, they have to give clarification. The complaint has to give clarification, my lords, what is the amount they have deposited.
ಅದನ್ನ ಕೆರಳ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಸರ್.
And my lords, before this court, whether they have preferred an appeal, that they have to clarify.
ರಿವಿಷನ್.
ಹೌದು, ರಿವಿಷನ್ ಹಾಕಿದಾರೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ. No, my lords, whether they have deposited, that is also no clarification.
ಇಲ್ಲಿ ಯಾವ್ದು ರಿವಿಷನ್ ಇಲ್ಲ ಸರ್. ನೋ ರಿವಿಷನ್ ಇಸ್ ಪೆಂಡಿಂಗ್. Some other two accused person.
ಯಾಕಂದ್ರೆ ಇವ್ ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡಿ, my lords, if they are also deposited, my lords, again it will, my lords, double triple amount.
ನೀವು ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ?
Now I have deposited 50%. Now 20 lakh ಮಾಡಿದ್ದಾರೆ. 10 double the check amount ಮಾಡಿದ್ದಾರೆ.
ಈಗ ಅಲ್ಲಿ 10 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೀರಾ?
10 ಲಕ್ಷ ಅಲ್ಲಿ 20%.
ಏನ್ ರಿಕವರಿ ಏನಾರು ಆಗಿದೇನ್ರಿ ಅವ್ರ ಕಡೆಯಿಂದ? ಅವ್ರ
ಇನ್ನು ಆಗಿಲ್ಲ ಸರ್.
ಅವ್ರ ರಿವಿಷನ್ ಏನಾರು ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಸರ್.
ಅವ್ರು ಯಾವ ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
ನೋಡಿ, This matter is listed for admission. I heard the counsel for the petitioner and also the counsel for the respondent. Records ಇದೆಯಲ್ಲ ಮೇಡಮ್?
Records ಬಂದಿಲ್ಲ.
Records ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್ ಬಂದಿಲ್ಲ.
Call for records. Call for records and.
My lords, meanwhile, my lords, the directed complainant to my lords and secure whether they have deposited, they have recovered or not, because my lords, they have not.
ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ರಿ
ಅಲ್ಲ,
ಯಾವ್ದು
ಅವ್ರು
petition ಹಾಕಿಲ್ಲ ಅಂತ.
ಅದನ್ನ ಅವ್ರು ಹೇಳಿ, ಅವ್ರ affidavit ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ, my lords, they are record, my lords, that may be recorded.
For the code itself, I'm
My lords,
submitting.
kindly record that, my lords, because I have to get, my lords, the information whether they have deposited or not. My lords, my client is saying, my lords, ಅವ್ರ ಹತ್ರನು ಅವರು they are also deposit 20%, ಅದು 40% ಆಗೋಗುತ್ತೆ. My lords, almost 8 lakh they have deposited.
ಅವ್ರಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಕಟ್ಟಿದಾರನ್ರಿ?
ಅಲ್ಲೂ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ನಾವ್
ಅಪೀಲ್ ಹಾಕಿದಾಗ
ಇನ್ನ ಇಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕೆ ಯಾವ್ದು ಇನ್ನ ರೀಫಂಡ್ ಹೋಗಿ ರೀಫಂಡ್ ಹೋಗೇ ಇಲ್ಲ ನಾವು.
ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ಲ ಅವಾಗ
ಅಪೀಲ್ ಹಾಕಿದ್ರು, ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದೇನು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ.
20% ಏನು ಕಟ್ಟಿಲ್ಲ.
ಅದಕ್ಕೆ ಅವ್ರು
ಏನು
ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಗೊಳ್ಳಿ, ಅದನ್ನ ಹಾಕ್ಬಿಡ್ಲಿ ಅವರು.
ಸ್ಟೇನು ಕೊಡ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ.
ಹಾ?
ಸ್ಟೇನು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಲ್ಲಿ.
ಏನ್ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲೇನು ಸ್ಟೇ ಮಾಡ್ಲಿಲ್ಲ ಅಲ್ಲಿ.
ಸೆಂಟೆನ್ಸ್ ಏನ್ ಸಸ್ಪೆಂಡ್ ಆಗಿಲ್ಲ.
ಏನಿಲ್ಲ
ಅಲ್ಲಿ.
ಅಲ್ಲ, ಸೇಮ್ ಮೇ ಬಿ ರೆಕಾರ್ಡೆಡ್, my lords, with the effort not deposited that record ಆಗಲಿ.
Counsel for the respondent submits that the other partners have not deposited any money.
And they have not executed
Also
that.
not executed the warrant against them for recovery of the money, recovery of the compensation as ordered by the trial court. ಅದ್ನ ಹಾಕ್ಬಿಡಿ order sheet ಅಲ್ಲಿ. Call for records and list the matter on 22.
Please.
36.
36 Sampath Bapat, Ashwath CM.
That's what CM. 6 months with 4,10,000. ಹೇಳಿ.
We will make an effort for settlement. 2.5 ಲಕ್ಷ ಕೊಡ್ತೀವಿ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಂದ್ಸಲ ಹೇಳಿದ್ವಿ. ಅದಕ್ಕೆ ನಾವು ಒಪ್ಲಿರ್ಲಿಲ್ಲ. ನಾವು ದ ಸೇಮ್ ಆಫರ್.
Both counsel submit that there is an element of settlement and hence this matter on 22. ಅವ ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಪ್ಲೀಸ್ 22 to
22 22 22 ಬೇಕಾ? ಸಾಟರ್ಡೆ ಅಂತೆ.
ನೆಕ್ಸ್ಟ್ 25th.
ಇಲ್ಲ 21.
ಪ್ಲೀಸ್
21 ಆಗುತ್ತಲ್ಲ?
ಪ್ಲೀಸ್.
37
37.
ಏನ್ ರಾಧಾಕೃಷ್ಣ?
279. 348. 2 years ಮಾಡಿದಾರ?
2 years, 2 years ಇದೆ. 2 years ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾರೆ ಸೆಷನ್ ಜಡ್ಜ್ ಕೂಡ.
2 years?
Passed by the Leonard magistrate, 2 years. Same has been confirmed in the criminal appeal. ತಿಳ್ಕೊಂಡು
ಅದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
ಅದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ, ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಹ್ಯಾಸ್ ಬೀನ್ ಡಿಸ್ಮಿಸ್ by confirming the sentence award. Leonard session magistrate convicted and sentenced to undergo 2 years
ಅಂತ ಮಾಡಿದ್ದಾರೆ.
appeal also it has not been modified. Same is confirmed. ನನಗೇನಂದ್ರೆ ಅವ್ರು ತಿಳಿಸ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೇಳ್ಬೇಕು.
ಏನ್ ತಿಳಿಸೋದೇನು?
I will.
ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆನೆ ನೀವು ರಿವಿಷನ್
ಗೊತ್ತು ಸ್ವಾಮಿ, ಗೊತ್ತು. Now I have to inform because MVC ನಲ್ಲಿ
ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದ್ರಿ ನೀವು?
MVC ನಲ್ಲಿ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಳ್ಳಿ ಬಿಡಿ.
ಕೇಳ್ಬಿಟ್ಟು
ಸಂಬಂಧ
2
ವರ್ಷ ಯಾಕೆ ಮಾಡಿದಾರ್ರಿ? ಡೆತ್ ಎಷ್ಟು?
only one death. ಅದು
ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಕ್ವಿಟ್ ಮಾಡೋಣ. ಎವಿಡೆನ್ಸ್
ಎರಡೆರಡು ಪಾಯಿಂಟ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೇಳ್ತೀನಿ.
PW 1 and 2 are the eyewitness the incident. 1 and 2 are the eyewitness.
ಮರಳು ತುಂಬಿದ ಲಾರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಮರಳು ತುಂಬಿದ ಲಾರಿ ಅಂತಾರೆ. P6 ಪ್ರಕಾರ ಮರಳು ಈಗ ಟ್ರಾಕ್ಟರ್ ಬಿದ್ದೋಯ್ತು ಅಂತಾರೆ. ಮರಳು ಬಿದ್ದಿದ್ದು ಏನಿಲ್ಲ. ಅಂದ್ರೆ ಅದು ಎಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಎಲ್ಲಿ ಡಿಸೀಸ್ ಹೋಗ್ತಾ ಇದ್ಲು ಅಂತ P6 ನಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಸ್ಕೆಚಲ್ಲಿ. ಅದು ನಾನು ಹೇಳ್ತೀನಿ ಸುಮ್ಮನೆ. ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಸೆಂಟೆನ್ಸ್ ಆಲ್ಸೋ ಸುಮ್ಮನೆ.
ಆಯ್ತ್ರಿ. Petitioner counsel 6 time. HCGP present. This matter on 22. ಮತ್ತೆ ಡೇಟ್ ಕೊಡಲ್ಲ ಅವತ್ತು. 38.
BM
ಸಿದ್ದಪ್ಪ BM EC Act Section 7 3 months 10,000 420 registration 511 1 year 3,000.
Kindly pass over now. Senior head another.
Pass over. ಆಯ್ತು. 39. ರಾಮಚಂದ್ರ ಏನು ಹಾಲಿನ ತೋಟನ? 38. ಹೇಳಿ.
ಚೆಕ್ ಇಸ್ 4 lakhs.
4.25 ಲಕ್ಷ ಮಾಡಿದ್ದಾರೆ. ಲೀಲಾರಾಜ್ ಇದಾರ?
4.25 ಮಾಡಿದ್ದಾರೆ. But on the contrary, we need to assess the evidence of the complaint and admitted facts in the class.
ನೋಡಿ. 22ರಿಂದ ಮತ್ತೆ ಬಂದಿಲ್ಲ. Petitioner counsel present, respondent counsel absent. If respondent counsel doesn't appear in the next date of hearing, revision will be heard in the absence of the respondent counsel. List this matter on 22. 22. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮನ್ನ ಕೇಳಿ ಆರ್ಡರ್ ಬರೆಯೋಣ. 40 ರುದ್ರಪ್ಪ ಪಿ, ಪವನ್ ಕುಮಾರ್ YN
For petition,
ಇಬ್ರು ಇದೀರಲ್ಲ.
Lordship may kindly records may be called for the note.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ವಾ?
Yes, ಬಂದಿಲ್ಲ.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22. ಯಾವ ಊರಿಂದ ಬರ್ಬೇಕು? ಯಾವ ಊರಿಂದ ಬರ್ಬೇಕು?
ಹುಣಸೂರಿಂದ sir.
ಹುಣಸೂರ್.
Please.
ಆಯ್ತು. 22.
Oblige.
41.
For the petitioner,
ಹಾ.
the lords, a deposit was kept with the petitioner firm. Subsequently, a check was issued for the payment of the amount. And during the pendency of the check, a part payment was made, about 5 lakhs and not change. In spiting of it, they have presented the check. Part payment, in the evidence in the cross-examination, they have admitted, yes, you have received the money after the issuance of the check.
After the issuance of the check.
Part payment section 56, your lords, complaint itself was not maintainable. In spite of it, an order was passed. Anyway, I have deposited 50% of the amount as terms of the order of this court.
ನೋಡ್ರಿ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ? ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ.
Records ಬಂದಿಲ್ಲ.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಆಗಿದೆಯಾ ಅಥವಾ ಇಲ್ವಾ?
ಕಾಲ್ ಆಗಿಲ್ಲ. Records ಬಂದಿಲ್ಲ.
ಕಾಲ್ ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22. ನಿಮ್ ಪ್ರಕಾರ ಏನು ಅಡ್ಮಿಷನ್ ಇದೆ ಅಂತಿರಲ್ಲ ಪಾರ್ಟ್ ಪೇಮೆಂಟ್? ನೋಡ್ ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ.
22nd of this month, your lords.
22.
42. PS Prasad.
42. Prasad BS. DV allowed 2,000, 5,000.
Maintenance award, my lord, we are not challenging, only insofar as the, not to sell the property. That extent.
ಆಯ್ತು. ನೀವೀಗ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಆಗಿರುತ್ತೆ, ದುಡ್ಡು ಕಟ್ಟಲ್ಲ, ಆಸ್ತಿನೂ
ಅಲ್ಲ,
ಮಾರಿಬಿಡ್ತಾರೆ.
ನಾನು ಇದು ಇವರೆಗೆ ಕಟ್ತದೆ, ಒಂದು ರಾಜಿ ಆಗಂತ ಚಾನ್ಸಸ್ ಇದೆ ಅಂದ್ರೆ kindly have 10 days time may be granted.
Issue notice ಅಂತ ಮಾಡಿರ್ತೀರಿ.
Please,
Issue notice against the respondent and list this matter on 22. You issue emergent notice.
please.
43.
Case. Trial court acquitted. Appellate court convicted. Fine amount deposit ಮಾಡಿದ್ದಾರೆ. Suspension of sentence ಆಗಿದೆ.
Appeal allowed.
Appeal is allowed and
ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದಿರಾ?
ಕಟ್ಟಿದ್ದೀವಿ.
ಯಾವಾಗ?
ಅಂದಿ
1.5 ಲಕ್ಷ ಇದೆ ಒಟ್ಟಿಗೆ.
ಕಟ್ಟಿದ್ದೀವಿ.
ಪೂರ್ತಿ. Heard on IA number 2 of 24 for suspension of sentence and on perusal of the records, trial court acquitted the petitioners and the same is reversed.
Receipt ಮೇಲಿದೆ ಸಮಯ.
In the appellate court. Receipt ಏನಿದೆ?
1,50,000 ಮೇಲಿನ receipt ಇದೆ.
ಯಾವಾಗ ಈಗ ಕಟ್ಟಿದ್ದೀರಾ? ಯಾವಾಗ?
ಅಲ್ಲ ಅವತ್ತೇ ಕಟ್ಟಿದ್ದೀವಿ. ಅಲ್ಲೇ
ಮತ್ತೆ ಅಂದ್ರೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕಟ್ಟಿದ್ದೀವಿ.
ಸಸ್ಪೆಂಡ್ ಮಾಡಿದಾರ ಅವರು? ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ತಾನೆ ರಿವರ್ಸ್ ಆಗಿರೋದು?
ಅದೇ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ we have deposited 1,50,000.
ಅಲ್ಲೇ ಕಟ್ಬಿಟ್ರಾ?
ಅಲ್ಲೇ ಕಟ್ಟಿದ್ದೀವಿ.
And also considering the grounds urged in the revision petition as well as the application and affidavit. And also counsel for the petitioner submits that already deposited the fine amount of rupees 1,50,000 before the appellate court. On 26/10/2024 and having considered the said submission, sentence is suspended subject to executing a bond for rupees 1 lakh with one surety before the trial court within 4 weeks. Call for records. List the matter. Record
A1 for stay.
HCCP is directed to take notice.
A1 for stay, my lords, in view of suspected, stay does not survive for taxation.
IA1 needs to be
May be dismissed.
Sentence
suspend ಆದ್ಮೇಲೆ IA1 for stay.
Sentence ಅವರು ಇದು ಬರೀ ದುಡ್ಡು ಬರೀ ಫೈನ್ ಹಾಕಿಲ್ಲ ರೀ, ಸೆಂಟೆನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಏನೋ ಟೈಮ್ ಪೀರಿಯಡ್ ಇದೆ ನೋಡಿ.
A1 ಸ್ಟೇ ಅಂತ ಹಾಕಿದ್ವಿ, ಅದು ನಾಟ್ ಸರ್ವೈವಲ್ ಅಂತ ಹೇಳ್ತೀರಾ ಸರ್.
ಅಲ್ಲಲ್ಲ, ನಿಮಗೆ ಪನಿಷ್ಮೆಂಟ್ ಬೇರೆ ಇದೆ ಅಲ್ವಾ?
ಹೌದಾ?
1 year ಇದೆಯಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲೂ.
ಅದು ಇನ್ ವ್ಯೂ ಆಫ್ ವಿ ಆರ್ ಅಂಡರ್ಗಾನ್ ದಿ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಡ್ಯೂರಿಂಗ್ ದಿ.
ಅದೇ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಆಲ್ರೆಡಿ ಆಗಿದೆಯಾ? ಸೆಟಪ್
ಆಗಿದೆ.
ಸೆಟಪ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಸೆಟಪ್ ಕೊಟ್ಟಿದೆ.
ಇಲ್ವಲ್ರಿ, ನಾನು ಓದ್ದಾಗ ಕಾಣ್ಲಿಲ್ವಲ್ಲ, ಇಲ್ಲಲ್ಲ ಸೆಟಪ್. The period of detention from Sonsons already undergone by the accused appellant in judicial custody considered as set up. Under more than 1 year idra?
More than.
It ಬರೋದಿಲ್ಲ, only.
Then appeal, my lords, revision does not survive for consideration also.
ಫೈನ್ ಕಟ್ಟಿರೋದ್ರಿಂದ ಮೋಸ್ಟ್ಲಿ ಅವ್ರ ಫೈನಿಗೆ ಫೈಟ್ ಮಾಡ್ತವ್ರೆ. ಆಲ್ರೆಡಿ 1 year ಸೆಟಪ್ ಆಗಿದೆ,
ಸೆಟಪ್ ಮಾಡಿದ್ದಾರೆ,
ಫೈನ್ ಕಟ್ಟಿದಿರಿ. ವಾಟ್ ಇಸ್ ನೌ ಚಾಲೆಂಜ್?
ಇದು ಸೆಂಟೆನ್ಸ್ ಹೋಗ್ಬೇಕು ಅಂತ ಫೈನ್ ಅಮೌಂಟ್ ಬಗ್ಗೆ. ಸಿನ್ಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಫೈನ್ ಅಮೌಂಟ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದೌದು,
ಅದೇನೆ ಫೈನಿಗೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಆಲ್ರೆಡಿ. ಮಾತ್ರ ಅಷ್ಟೇನೆ. ಏನಾಯ್ತು ಸ್ಟೇ ಕೇಳಿದಾರಲ್ಲ ಇವರು? ಇದೇನ್ ಕೇಳಿದ್ರಿ?
ಸ್ಟೇ ಬರೋದಿಲ್ಲ, ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ, ಅದಕ್ಕೆ IA1 is not survey. In view of IA number 2.
ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ A number 2 ನೇ ಮಾಡಿ.
ಅದೇ.
Therefore, IA1 does not survive for consideration.
ಆಯ್ತು, ಅದು ತೊಳಿ ಏನಾಯ್ತು ಮೇಡಮ್? ಅಂಡ್ ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡೆಡ್ ಅಂತ ಬಂತಲ್ಲ, ಅಂಡ್ ಆಲ್ಸೋ ಅಮೌಂಟ್ ಆಲ್ರೆಡಿ ಬಿನ್ ಪೇಯ್ಡ್, ಅದನ್ನು ಹೇಳಿದ್ದೀನಿ. ಆಯ್ತು. And IA number 1 of 24 doesn't survive for consideration since already setup was given. Call for records, list the matter in the second week of March.
44, I am for the petitioner, my lord. It is on 138 of NI Act. It is for suspension of sentence. Check amount is 5 lakhs and the punishment is compensation is 5.
Heard on IA 1 of 25 and also considering the grounds urged in the revision petition as well as the affidavit in support of this application. Sentence is stayed subject to depositing of 50% of the amount inclusive of the amount already been deposited within 4 weeks, and also directed to execute a bond for rupees 1 lakh with 1 surety before the trial court within 4 weeks. Issue notice against respondent and list the matter on.
Records may be called.
I call for 7-3.
Yes.
Issue notice.
Publish.
Reporting settlement 45.
Reporting settlement 45.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
Matter I am for the respondent.
2020 3,95,000 18,725 ಡಿಪಾಸಿಟ್ ಆಗಿದೆ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಆಯ್ತು.
ಸೇಮ್ ಚೆಕ್ ಅಮೌಂಟ್ ಆಲ್ರೆಡಿ ಡಿಪಾಸಿಟ್ ಆಗಿದೆ, ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಕೂಡ ಆಗೋದು. ನಾವು ಈ ಪಿಟಿಷನ್ಸ್ ಇನ್ಫ್ರಕ್ಷನ್ಸ್ ಆಗಿದೆ, ಯಾಕೆಂದ್ರೆ ಪಿಟಿಷನರ್ ಕಂಪನಿ ವೈಂಡ್ ಅಪ್ ಆಗಿ SBI ಅವರು ಟೇಕ್ ಓವರ್ ಮಾಡಿ ಕ್ರೆಡಿಟರ್ಸ್ಗೆಲ್ಲ ಅವರು ಏನೇನು ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕಾಗಿದೆಯೋ ನಮ್ಮ ಕಂಪನಿಯಿಂದ ಎಲ್ರಿಗೂ ಪೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇವಾಗ ಇದು
ಮೆಮೊ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕಿರೋದಾರ ನೀವ ಅಥವಾ ಬೇರೆ?
ಅಲ್ಲ, ಬೇರೆ MV ಹಿರೇಮಠ್ ಅಂತ ಸರ್.
ಅವ್ರು ಈಗ ರಿಟೈರ್ ಆಗ್ಬೇಕು.
ರಿಟೈರ್ ಆಗ್ಬೇಕು.
ತೊಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ MV ಹಿರೇಮಠ್ ಫೈಲ್ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ.
Matter for respondent, my lord.
ಆಯ್ತು. ಇನ್ ವ್ಯೂ ಆಫ್ ಕೌನ್ಸಿಲ್ ಡಾಕ್ಟರ್ B ಮಂಜುನಾಥ.
ಹೌದು ಸರ್.
ಅದೇನ ಪಿಟಿಷನರ್ಸ್ ಅಂತ ಇದೆಯಲ್ರಿ? 2 and 4 ಅಂತ ಇದೆ.
ಇನ್ನಿಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್, ಅವ್ರಿಲ್ಲ.
ಈಗ ನೀವು NOC ಒಕ್ಕಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಸರ್, ಇಬ್ಬರಿಗೆ ಮಾತ್ರ ಹಾಕಿದ್ವಿ.
2 and 4 ಮಾತ್ರ?
ಹೌದು ಸರ್.
ವಾಟ್ ಅಬೌಟ್ 3?
ಇಲ್ಲ ಸರ್,
ತೀರ್ಕೊಂಡಿದ್ದಾರ?
ಹೌದು.
ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ 2 and 3 ಅಪಿಯರ್ ಆಗ್ತಾರೆ, 1 ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ. 2 and 4 ಅಂತ ಹಾಕೋರೆ. ನೀವ್ ಹಾಕಿರೋ 2 and 3 ಹಾಕಿದಿರಿ?
ಹೌದು ಸರ್, 2 and 3.
ತೀರ್ಕೊಂಡಿರೋದು ಯಾರು?
3 and 4 ಇರ್ಬೇಕು. ಅಲ್ಲ, 1 ಬಂದು ಕಂಪನೀಸ್.
ಆಯ್ತು. ಅವ್ರು ರಾಜಲಕ್ಷ್ಮಿ ಸೈನ್ ಮಾಡೋರಾ? ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ 4 ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ. ಆಯ್ತು ಆಯ್ತು. ಈಗ 4 ಅವರು. ಇನ್ನೊಬ್ರು 2 and 4 ಹಾಕಿದ್ರು.
2 and 4 ಹಾಕಿದೀನಿ ಸರ್.
ಅದೇ ಕೌನ್ಸಿಲ್ ಏನು ಹೆಸರೇನು? ಡಾಕ್ಟರ್ B ಮಂಜುನಾಥ. ಡಾಕ್ಟರ್ B ಮಂಜುನಾಥ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಫಾರ್ ಪಿಟಿಷನ್ ನಂಬರ್ 2 and 4. The council submits that petition number 3 is no more.
ಹೌದು ಸರ್.
ಅದಕ್ಕೆ ಏನಾದ್ರು ಇದನ್ನ ಹಾಕಿದಿರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ ಅವರು. ಯಾಕಂದ್ರೆ ಕಂಪನಿ
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕಲ್ಲ?
ಅಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ, ಪ್ರೊಕ್ಯೂರ್ ಮಾಡ್ತೀನಿ ಸರ್.
R1 is ಕಂಪನಿನ?
ಕಂಪನೀಸ್.
ಹಾ
ವೈಂಡ್ ಅಪ್ ಆಗೋಗಿದೆ ಸ್ವಾಮಿ. 2020 ವೈಂಡ್ ಅಪ್ ಆಗೋಗಿದೆ. SBI ಅವರು ಸ್ವಾಮಿ ಟೇಕ್ ಓವರ್ ಮಾಡಿ ಕ್ರೆಡಿಟರ್ಸ್ಗೆಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರೇನೆ.
ಯಾರು SBI ನವರು?
My lord, SBI has not taken over, my lord. What has happened is,
ಇಲ್ಲಿ
we have filed a case against SBI and the petitioner for certain amount of damages, my lord.
ಡಿಪಾಸಿಟ್ ಮಾಡಿರೋದಕ್ಕೆ ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿರೋದಕ್ಕೆ on
Last
same cause
time
of action.
also they filed a memo stating that they have deposited the amount with the bank anta.
My lord, bank, I am no way concerned, my lord. I have filed a case against the SBI for damages. Based on that, I have got a decree for some 8 crores. They have deposited 3 crores in the court.
Oh, that is separate.
Separate, my lord. Separate, that is against the bank.
ಇದು totally
this is the
wrong
special act, my lord. They have to
ಸೂಟ್
give me the-
ಹಾಕಿರೋದು ಇಲ್ಲಿ ಏನ್ ನಾನು LC ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅದ್ರ ಮೇಲೆ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಯಾವ LC ನಾನು ಕೊಡ್ಬೇಕಾಗಿರೋದು ಸ್ವಾಮಿ 29/6/2011, 29/6/2011, 30/6/2011 4 LC 4 ಚೆಕ್ ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ. ಅದರ ಅಮೌಂಟ್ ಬಂದು 3,20,074,748 ಅವ್ರು ಸೂಟ್ ಹಾಕಿದ್ದು ಕಮರ್ಷಿಯಲ್ OS. ಅಲ್ಲಿ ಡಿಕ್ರಿ ಆಗಿ ಡಿಕ್ರಿಯಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು SBI ಅವರು ಆನ್ ರೆಕಾರ್ಡ್ ಬಂದ್ರು. ಯಾಕಂದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ವೈಂಡ್ ಅಪ್ ಆಗೋಗಿದ್ರಿಂದ SBI ಟೇಕ್ ಓವರ್ ಮಾಡಿದ್ರಿಂದ ಅವ್ರು ಬಂದು ಕೋರ್ಟ್ ಮುಂದೆ ನಾನು ಮೆಮೊ ಹಾಕಿ ನಾವು ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ. ಇವರು ವಿತ್ಡ್ರಾ ಮಾಡಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
The deposit was made.
ವಿತ್ಡ್ರಾ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಡ್ಬೇಡಿ, ನಾವು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕಿದೀವಿ ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದ್ರ ಮೇಲೆ ಅಲ್ಲಿವರೆಗೂ ವಿತ್ಡ್ರಾ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಡ್ಬೇಡಿ ಅಂತ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ. ಆ ಮೆಮೊ ತಮಗ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಕಂಪನಿ ವೈಂಡ್ ಅಪ್ ಆಗಿದೆ. ಕಂಪನಿ ಇಲ್ವೇ ಇಲ್ಲ ಇವರು. ಇವಾಗ ಇವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರು ಕೂಡ ಯಾರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ. ಕಂಪನಿನೇ ಇಲ್ಲ.
No, we'll go after the directors, my lord.
ನೀವು ಇದಿರಲ್ಲ?
ಅಲ್ಲಲ್ಲ
Directors are
ಕೂಡ
there.
ಇವಾಗ ನಾವು ಕೂಡ ಅದನ್ನ ವೈಂಡ್ ಅಪ್ ಆದ್ಮೇಲೆ ನಾವು ಬರ್ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ ಸರ್. ಕಂಪ್ನಿ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ. SBI ಟೇಕ್ ಓವರ್ ಮಾಡಿ ವಾಟ್ ಎವರ್ ದಿ ಬ್ಯಾಲೆನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪೇಡ್ ಬೈ ದಿ ಚದಲ್ವಾಡ ಕಂಪನಿ ಈಸ್ ಬೀಯಿಂಗ್ ಪೇಡ್ ಬೈ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 SBI.
No, that is not true, my lord. My lord, the SBI is
ತಾವು
a
ಮೆಮೊ
separate
ನೋಡಿ.
case. They are a separate case. My lord, because of they have filed an appeal, the condition for filing appeal is to deposit this amount in the court. Till now, I have not got this amount. See, SBI has filed an appeal on the commercial suit order of Hyderabad court.
That I will consider on merits now settlement ಅಂತಿತ್ತು ನೋಡೋಣ.
No settlement, my lord. I have not got any money.
Petition number 3 ಅಲೈವ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಹೇಳಿ.
I will have to check, my lord. I am not aware of that.
ನೋಡಿ. Petitioner counsel for the petition number 2 and 4 submits that petition number 3 is no more and hence directed to produce the death certificate of petition number 3. And also counsel for the respondent is also directed to verify whether petition number 3 is alive or not. List this matter on 22. First ಅದನ್ನ
Oblige, my lord.
3ನೇ ತಾರೀಕು ಅಷ್ಟೊಳಗೆ ನಾನು ಪ್ರೊಕ್ಯೂರ್ ಬಾಂಬೆಗೆ
3 ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 3 ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಮಚ್ ಒಬ್ಲಿಜ್.
Oblige.
Parted in hearing matter 46. ಏನ್ ರಾಧಾಕೃಷ್ಣ?
ಏನಾಯ್ತು?
ರಿಗಾರ್ಡಿಂಗ್ ಇದು
ಏನಕ್ಕೆ ಅರ್ಜರ್ನ್ ಆಯ್ತು?
ರಿಗಾರ್ಡಿಂಗ್ ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ. ಈಸ್ ಏಜ್ಡ್ ಅಬೌಟ್ 70 years.
70 years.
70 years. And suffering from heart ailment. And he had one son. ಅವನು ತೀರೋಗ್ಬಿಟ್ರಂತೆ. And keeping this as situation, I have requested your lordships to consider for 50,000 ಇದು ಮಾಡಿ ಅಂತ. ಈಗ ನಾನು ಅವ್ರು ಕೇಳಿದ್ರೆ 50,000 ಕಷ್ಟ ಸ್ವಾಮಿ ಅಂತ ಅಂತಾರೆ. I leave it to this is the position. Mitigating circumstances, my lord. They have also filed MEC case before the motor.
MEC is no way concerned with this.
KSRTC ಬಸ್
ಎದುರುಗಡೆಯಿಂದ ಬಂದು ಬೈಕಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದಿರ್ತದೆ ಬೈಕ್. ಯಾರು ಹುಡುಗ ತೀರ್ಕೊಂಡ ಅಂತ.
ಬ್ರದರ್ ಆಫ್ ದಿ PW1
ರೈಡರ್ ಸತ್ತೋಗಿದ್ದಾನೆ.
ರೈಡರ್ ಪಿಲಿಯನ್ ರೈಡರ್.
ವಿಟ್ನೆಸಸ್ ಯಾರು? ಐ ವಿಟ್ನೆಸಸ್
PW1 and 5.
PW1 and 5.
ಹೌದು ಸರ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಯು ಲಾಟ್ಸ್ PW2 and PW2
ಪಿಲಿಯನ್
PW5.
ಪಿಲಿಯನ್ ರೈಡರ್.
PW2 is pillion raider.
ಹೌದು ಸರ್.
ಅವಂದು ಎವಿಡೆನ್ಸ್ ಇದೆ.
ಹೌದು.
ಐ ವಿಟ್ನೆಸ್ ಇದೆ.
PW1,
PW2, PW5.
Come on, sir.
One is not the eyewitness. It was told by the PW2.
One only about the accident.
After he came to know the
Complaint ಕೊಟ್ಟಿದ್ದಾನೆ
death,
ಅಷ್ಟೇ.
ಹೌದು, death of his brother, he went to the hospital, and then he lodged the complaint. Medical certificates all ಇದೆ.
ಏನು sentence ಏನಾಗಿದೆ?
2 years ಕೊಟ್ರು, ಅದನ್ನ 1 year ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿಫೈ ಮಾಡಿದಾರಾ?
ಮಾಡಿಫೈ ಮಾಡಿದ್ದಾರೆ.
ಹಾ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಎಷ್ಟು ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಂಪೆನ್ಸೇಷನ್ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳ್ರಿ, ಟ್ರೈ ಟು ಲುಕ್ ಇನ್ ಟು ಅಂತ ಅಂದ್ರಿ.
ಏಜ್ ಏನ 71 ಅದಕ್ಕೆ ನೋಡಿ ಕೇಳೋಣ ಅಂತ.
ಅದೇ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಇದಾವೆ, ಮೆಡಿಕಲ್
2011.
He took treatment, ಹೌದು ಸ್ವಾಮಿ, 2000.
ಅದನ್ನೆಲ್ಲ ನಾನು ಈಗ ನೋಡಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ, ಐ ಆಮ್ ಬ್ರಿಂಗಿಂಗ್ ಟು ದಿ ಮಿಟಿಗೇಟಿಂಗ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಟು ದಿ ನಾಲೆಡ್ಜ್ ಆಫ್ ದಿ ಸಮ್ ಕೋರ್ಟ್.
ಇವನ್ ಡ್ರೈವರ್ ಆಫ್ ದಿ KSRTC.
ಡ್ರೈವರ್
KSRTC. Third, heard the petitioner, counsel, and also the counsel appearing for the state. And this court also heard the matter in part earlier. And at the request of the counsel for the petitioner, matter was deferred. This revision petition is filed against the concurrent finding of trial court and confirmation, convicting the petitioner for the offence punishment of section 279 and 304A. And imposing fine of rupees 338 ಇದೆಯಾ?
ಅವ್ರಿಗೆ ಇಂಜುರಿ ಆಗಿತ್ತು ಅನ್ಸುತ್ತೆ, PW2
279, 338, 304A. ಅವನು ಪಿಲಿಯನ್ ರೈಡರ್ಗೂ ಇಂಜುರಿ
ಆಗಿದೆ.
For the offence punishment of section 279, 6 months sentence with fine of rupees 500 was imposed, and in respect of 338, 1 year with fine of rupees 500, and in respect of 304A, 2 years with fine of rupees 500 was imposed. Accepting the case of the prosecution that PW 2, 3 and 5, that is injured witness and also the eyewitnesses evidence were considered while convicting and sentencing. Being agreed by the said order, an appeal is filed in criminal appeal number 167 of 2014. Appeal was allowed in part and confirmed the conviction for the offence punishment section 279, 338 and 304A. However, ಅಂದ್ರೆ 279, 338 ಎರಡಕ್ಕೂ
500 ರೂಪಾಯಿ
6 months.
ಅಲ್ಲ, ಫೈನ್ ಇದೊಂದು ಸೆಂಟೆನ್ಸ್ ನ ರದ್ದುಪಡಿಸಿದ್ದಾರೆ.
ಹೌದು ಸರ್.
ಇನ್ ಅಪೀಲ್
500 rupees each ಅಂತ
sentence of 6 months and 6 months for the offence 279 and 1 year for 338 was set aside. And the sentence for a period of 2 years is reduced to 1 year. And remaining sentence is unaltered. ಅಂದ್ರೆ ಈಗ 500 ರೂಪಾಯಿ ಹಾಕಿರಲ್ಲ, ಅದು 279 ಅದು ಕೊಡ್ಬೇಕಾ?
ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
ಆರೋಪಿ ಭಾರತ ದಂಡ ಸಂಹಿತೆಯಲ್ಲಿ ಅಪರಾಧ ತನ 200 ರೂಪಾಯಿ ದಂಡ ಹಾಗೂ and one ಏನಾಯ್ತು reduced to 1 year and fine imposed for the offence punishment section 279 and 338 is confirmed, and also the fine in respect of 304A is also confirmed, and default sentence of 3 months is imposed. Being agreed by the said order, the present revision petition is filed. The main contention of the counsel appearing for the petitioner before this court is that both the courts have committed an error in accepting the evidence of PW 1, 2 and 5. Counsel also would vehemently contend that PW 1 and 2 fails to The trial court and appellate court fails to consider the admission given by injured villain rider, the motorcycle, PW2, and so also PW1 clearly stated that bus dashed right side of the motorcycle, and towards the left side of the motorcycle there was a lot of place. These sole circumstances clearly discloses that it is the negligence on the part of the rider of the motorcycle, even though there was a space on the left side of the same. He drew the vehicle in a rash and negligent manner. The council also vehemently contend that PW4 has turned hostile. The observation of the trial court that PW5 is an independent witness to the accident, and also along with injured PW2. But in his chief, he says that road was very wide, and at the time of the accident place, he admits that he could not say the bus hit which part of the bike, and hence it is clear that his evidence is unnatural. And he did not make any efforts to shift the injured to the hospital. The PW6 is the conductor of the bus. Trial court also fails to take note of the sketch, which is marked as exhibit. Sketch history P2. P2 na? Exhibit P2 sketch. P2 sketch already Majar, Stala Majar.
Sketch is P13, Malad.
13.
P13.
ಯಾವ್ದು ಇಲ್ಲಿ ನೋಡ್ರಿ
ಅಲ್ಲಿ ಇದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ನೋಡಿದ್ರಿ.
Exhibit P13. And also clearly discloses that there was a space on the left side of the motorcyclist, about 4 feet. The same has not been properly appreciated. And hence it requires interference of this court. For contra, the counsel appearing for the state would vehemently contend that the bus came in the opposite direction, and that too came on the wrong side, on the extreme right side of the road. And also the injured witness PW2 categorically deposes the manner in which the bus came and dashed against him. Dashed against both of them. And also other witnesses are PW5. PW3 and 5 are the eyewitnesses, and their evidence corroborates each other that they have witnessed the accident. And even taking into note of exhibit 13 also very clear that which depicts the place of accident, and bus went on the wrong side and dashed against the cyclist who were coming on the left side of the road. Hence, this court cannot find fault with the finding of the trial court as well as the first appellate court. Having heard the petitioner counsel and also the counsel appearing for the respondent, and also taking the material on record, the point that would arise for the consideration of this court are whether both the courts committed an error in convicting and sentencing and confirming the same, and whether it requires interference of this court exercising the revisional jurisdiction, and both the order suffers from its legality and correctness. Having considered, and what order? Having considered the submission of the petitioner counsel and also the counsel for the respondent, particularly the document of exhibit P10 clearly depicts that the bus went on the wrong side of the road. And also on the extreme side of the road. Extreme right side of the road. And the motorcyclists are coming in the proper direction on the left side of the road. And no doubt counsel appearing for the respondent, petitioner would submit that there was 4 feet of space. The said contention cannot be accepted for the reason that the bus was proceeding. ಈ ಕಡೆಯಿಂದ HD ಕೋಟೆ ಕಡೆಯಿಂದ ಮೈಸೂರು ಕಡೆ ಹೋಗ್ತಾಯಿತ್ತಲ್ಲ?
ಹೌದು. HD ಕೋಟೆ towards to.
The driver of the bus was proceeding from HD ಕೋಟೆ towards the Mysore side. A motorcyclists are coming from Mysore side to HD ಕೋಟೆ road. And almost on the extreme right of the road, accident was occurred. And mere 4 feet of space on the left side of the motorcycle cannot be a ground to come to a conclusion that accident was occurred on account of negligence on the part of the motorcyclist. It is also important to note that what made the driver of the bus to take the extreme side of the right side of the road, no explanation, either in the 313 statement and also not let any defense evidence. Apart from that, injured eyewitness PW2 categorically deposes the manner in which the bus was driven. And apart from that, PW3 and PW5 are also the eyewitnesses.
Three eyewitnesses.
3 and 5.
3 is not the eyewitness.
Okay?
Was told hearsay. He is not the eyewitness. PW2 and 5 only.
The position ಏನು ಹೇಳಿದಾರೆ PW?
Hearsay something. The brother of the.
ನಾನು ಯಾರೋ ಹೇಳಿದ್ರು ಬಂದು ಹೇಳಿದ್ರು.
ಹೌದು.
ತಿಳಿದು ಬಂತು ಅಷ್ಟೇ.
ಹೌದು ತಿಳಿದು ಬಂತು.
PW3 is not the eyewitness. He categorically says that he came to know about the bus came on the right side and dashed against him. And hence PW3 cannot be treated as an eyewitness. But PW2
is the owner of the
who was the villain raider categorically says that he came in a rash and negligent manner and dashed against the motorcycle. And the rider of the motorcycle died at the spot and he had sustained the injuries. And he also gave the statement before the police. In the cross-examination, even the defense also elicited that the bus came on the right side and dashed against the motorcycle. Though PW2 says that some space was there on the left side of the motorcycle, the same cannot be a ground. When the driver of the bus went on the extreme side of the right side of the road and dashed against him, but he categorically says that on account of the impact of dashing against the motorcycle, both of them fallen on the left side of the road. The other witness, PW5, also speaks the vehicle moving in the opposite direction and bus driver drove the way same in a rash and negligent manner and dashed against the motorcycle. And he also categorically says that on the left side of the bus, even other bus also can move. And that much space was there on the road. In the cross-examination of this witness, he categorically says that he saw the accident at the distance of 150 feet. But he cannot say to which part bus dashed against the motorcycle, but he can say that the same is dashed against the motorcycle. Having taken note of evidence of PW2 and PW5, the evidence is consistent. Apart from that, documentary evidence also discloses the place of accident, and sketch exhibit P13 depicts the place of accident. And when the driver of the bus went and dashed against the motorcycle on the extreme side of the road, right side, we do not find any error committed by the trial court as well as first appellate court in appreciating the evidence available on record, and there is no any perversity in the finding of the judgment of the trial court, also appellate court. It is also important to note that though the trial court convicted and imposed the sentence for all the offences and sentence of 2 years, and the same is reduced to 1 year by the appellate court. It is also important to note that accident was taken place in the year 2011. And also counsel appearing for the petitioner who submits that appellant is aged about 70 years. ಯಾವಾಗ ಹಾಕಿರೋದ್ರಿ ನೀವು ರಿವಿಷನ್ 16
16
and at the time of filing of the revision his age is shown as 61 and ಈಗ ಎಷ್ಟಾಗುತ್ತಲ್ಲ 16 ಅಂದ್ರೆ
70
and now he is aged about 70 years. And taking into note of the factual aspects of it was an accident.
heart ailment.
And also considering the age and also petitioner's counsel submits that he is suffering from heart ailment also. And when such being the case, it is appropriate to reduce the sentence from 1 year to 6 months. And directed to pay fine amount of rupees 25,000. ಹುಡುಗ ಎಷ್ಟು ವರ್ಷ ಅವ್ನು ಸತ್ತಾನ್ಗೆ?
ವಯಸ್ಸು.
Directed to pay fine of rupees 50,000. ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು, ತಾಯಿನ?
ಹೌದು, ಅವರ ಅಣ್ಣ ಇದ್ದಾರೆ. PW1 is the complainant, brother of the deceased.
ಬ್ರದರ್ ಬೇಡ, ಮದರ್ ಇದಾರೇನ್ರಿ?
ಆಯ್ತು, ಅದು ಬೇರೆ ಹೆಂಗಪ್ಪ ನಿಮ್ಗೆ ಇದು ಗೊತ್ತಾಗ.
ಅವ್ನಿಗೇನು ಏಜ್ ಸತ್ತವನಿಗೆ ಏನು ಬರೀ ಮೋಸ್ಟ್ಲಿ 27-28 ವರ್ಷ ಇದ್ದಂಗಿತ್ತು.
But it has come in the evidence they have filed MEC case.
Same report. ಇದೆಯಲ್ಲ?
ಬಂದೆ
30 years. And hence directed to pay the fine amount of rupees 50,000 as against the 1,500 in respect of all the offences. Out of the 50,000, 40,000 is payable to the parents, if any alive, of the deceased. And if no parents, payable to the PW1, who is the brother of the
deceased,
on proper identification.
Amount
Identification. The sentence imposed, conviction and sentence in respect of 279 is set aside since the ingredients of the offence under section 279 merges with the severe offence of 304A. ಹೇಳಿ ಏನೇನು?
6 months ಅಮ್ಮ ಬದಲು because of his
ಮಾಡಿದೀವಲ್ಲ.
age, heart ailment,
ಏಜ್ ಮಾಡಿದ್ವಲ್ಲ.
and he lost his son also, mitigating circumstances.
ಆಯ್ತು.
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ
ಅದಕ್ಕೆ 6 ವರ್ಷಕ್ಕೆ ಇಳಿಸಿ 50,000 ಮಾಡಿದೀನಿ ಫೈನ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡಿರಿ ಸ್ವಲ್ಪ
ವೆಸ್ಟ್ ವಿತ್ ಸ್ಟೇಟ್ ಅದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡಿರಿ ಅಮೌಂಟ್ ಇನ್ ಸ್ವಲ್ಪ ಇದ್ ಮಾಡ್ತೀನಿ,
ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ, ಫುಲ್ ಕೊಡ್ತೀನಿ, ಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ.
ಸೆಂಟೆನ್ಸ್
ನೀವು 50,000 ರೂಪಾಯಿಗೆ ತಂದ್ರೆ ಜೀವ that to the parents have lost the
true my lord, I am not disputing
son
that.
who is aged
I am
about
not
30 years.
disputing. Mitigating circumstances will lordship kindly consider.
KSRTC ಬಸ್ ಡ್ರೈವರ್
ಹೌದು,
ರೋಡ್ ನಲ್ಲಿ ಓಡಿಸ್ಬೇಕು ಗಾಡಿ, ನಾನು ತಗೊಂಡೋಗ್ಬಿಟ್ಟು ರೈಟ್ ಸೈಡ್ ಗೆಲ್ಲ ಇಡೀ ರಸ್ತೆ ಎಲ್ಲ ನಂದೇ ಅಂತ ಓಡಿಸಿರ.
ಅದಕ್ಕೆ ಅದನ್ನ ರಿವಿಷನ್ ಅಲ್ಲಿ ಇವತ್ತು ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ.
ರಸ್ತೆ ಎಲ್ಲ ನಂದೇ ಅಂತ ಓಡಿಸಿರ ಹೆಂಗ್ರಿ?
ದೇರ್ ಇಸ್ ಎ ಮೆಟೀರಿಯಲ್, ಅದನ್ನ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ. ಅದನ್ನ ಸ್ಕೆಚ್ ನೋಡಿ,
ದಟ್ಸ್ ಆಲ್.
ಅದೇ ಸೆಂಟೆನ್ಸ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ
2 ಲಕ್ಷ ಕೊಡ್ತೀರಾ, ಅದನ್ನು 6 ಲಕ್ಷ 6 ತಿಂಗಳು ಕಡಿಮೆ ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ ನೀವು ಕೇಳ್ಕೊ ಬನ್ನಿ ಅಂತ. ಲಾಸ್ಟ್
ಬಡವರಂತ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಕೇಳಿದ್ರೆ ಸುಮ್ಮನೆ
ಬೇಡ್ಬಿಡಿ ಇರ್ಲಿ. ಅದಕ್ಕೆ 6 months ಮಾಡಿ ಕಡಿಮೆ ಮಾಡಿದ್ ನಾ ಇನ್ನೂ.
ಸೀರಿಯಲ್ ನಂಬರ್ 30.
ಸೀರಿಯಲ್ ನಂಬರ್
30
ಏನಾಗ್ಬೇಕು? ನೀವಿಲ್ಲ ಅಂತ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Please, my lords. My lords, the issue at hand, my lords, is my lords have already passed an order which the counsel for the petitioners are relying on, saying that it's abuse of process given the fact that there's a second FIR registered as such. Now, the only issue other remains, my lords, currently the petitioners again in these petitions before this one, accused number 1, my lords have already passed an order. And that order we have, the Lokaयुक्त has challenged in SLP. Now, in as much as other accused are concerned, it's a case, my lords, being made out that it's exoneration in departmental inquiry proceedings. In our statement of objections, my lords, we have said.
ಆಯ್ತು ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರಿ?
ಇಲ್ಲ, only 2 point ತೋರಿಸ್ಬಿಟ್ಟು ಅಷ್ಟೇ ಅದನ್ನ
ಹೇಳ್ತೀನಿ. ಎಷ್ಟು ಟೈಮ್ ನೋಡಿ?
I do agree.
ಹಾ, ಮತ್ತೆ ಮಧ್ಯಾಹ್ನ ಕ್ಲಿಯರ್ ಮಾಡ್ತೀನಿ.
It's 2:30.
ನಾನೇ ನೀವು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರೇನ ಅಂತ ಅನ್ಕೊಂಡೆ.
ಹೇಳಿ, ಒಂದ್ 5 ನಿಮಿಷ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಲಿ ಅವ್ರೆ.
ಇಲ್ಲ, 2:30ಗೆ
ಹೇಳಿ.
2:30ಗೆ?
With the deepest of respects, my lords, we have a part had at 2:30, my lords. Even my learned friends said.
ಮುಗಿಸ್ಕೊ ಬನ್ನಿ.
ಆಮೇಲೆ ಹೋಗಿ
ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ ಅದನ್ನ. ಅದನ್ನ ಮುಗಿಸ್ಕೊ ಬನ್ನಿ.
Please.
ಹೊಸವ್ರು ಮಾಡೋಣ.
ಅಲ್ಲ, ಇದೇ ಫಸ್ಟ್ ಮುಗಿಸ್ಬೋದು ಸ್ವಾಮಿ. ಅವ್ರೇನ್ ಜಾಸ್ತಿ ಹೇಳೋಂಗಿದ್ರೆ ಹೇಳಿ, ಕಡಿಮೆ
ಇಲ್ಲ,
ಹೇಳಂಗಿಲ್ಲ.
ಜಾಸ್ತಿ ಹೇಳಕ್ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ 2 ಚಾರ್ಟ್ ಹಾಕೊಟ್ಟಿದ್ದೀನಿ.
ನೀವು ಅಷ್ಟೊಂದು ಇಟ್ಕೊಂಡಿದ್ದೀರಿ ಮತ್ತೆ?
No, my lords. ಅಲ್ಲ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಷ್ಟೇ. 3 ಪೆಟಿಷನ್ ಇವೆ ಅಲ್ಲ. 3 ಪೆಟಿಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಟ್ಕೊಂಡು
ಬೇರೆ ಕಡೆ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಬನ್ನಿ ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ ಏರ್ ಮಾಡೋಣ.
ಪ್ಲೀಸ್.
ಇಲ್ಲೇ ಬಂದ್ರೆ ಅವ್ರ ಏನ್ 5 ನಿಮಿಷ ಹೇಳಿ, ಇಲ್ಲೇ 2:15 ಬನ್ನಿ. ಇಲ್ಲೇ ಬಂದ್ ಇಲ್ಲೇ ಫಸ್ಟ್ ಬಂದು ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಲಿ.
ಪ್ಲೀಸ್. I'll be there at 2.
ಆಯ್ತು.
56, 57.
ಇದೀರಾ? ಬೋತ್ ಸೈಡ್ಸ್ ಇದೀರಾ? ಬೋತ್ ಸೈಡ್ಸ್ ಇದೀರಾ? ಇದ್ರ ಮಾತ್ರ ಇಬ್ರು ಇದ್ರು ಕೇಳ್ತೀನಿ.
ಇಬ್ರು 2 ಸೈಡ್ ಇದ್ರೆ ಕೇಳ್ತಾರಂತೆ. 2 ಸೈಡ್ ಇದ್ರೆ ಕೇಳ್ತಾರೆ. Lord, serial number 52.
ಇದೀರಾ ಇಬ್ರು?
ಅಲ್ಲ, other side is not coming from last Lord 10 Lord hearings.
ನಿಮ್ಮನ್ನ ಕೇಳೋದ್ ಬಿಡಿ ಮಧ್ಯಾಹ್ನ.
ಅಲ್ಲ, Lord, with the deepest respect, Lord, I have Lord 4 Lord parted matter. ಸ್ವಲ್ಪ ಲೇಟ್ ಆದ್ರೂ ತಾವು ದಯವಿಟ್ಟು ನಮ್ಮ ಜೂನಿಯರ್ ಏನು ಲಾಸ್ಟ್
ಅದರ್ ಸೈಡ್ ಇಲ್ವಲ್ಲ?
ಅದರ್ ಸೈಡ್ ಇಲ್ಲ.
ನೀವು ಬಂದಾಗ ನಾವು ತಗೋಬಹುದು.
ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಮ್ಮ ಕಲೀಗ್ಸ್
ಬರ್ಲಿಲ್ಲ.
ನಾನ್ ಬಂದಿರ್ಲಿಲ್ಲ.
ನೀವು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಅದೇ ರಿಸಲ್ಟ್.
ಅದಕ್ಕೆ ಸ್ವಾಮಿ, I just wanted to request my lords.
ಅದಾ ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಗಿದೆ. ಆರ್ಡರ್ ಆಫ್ ಸಸ್ಪೆನ್ಷನ್ PF ಕಟ್ಟಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ 1 ವಾರ. ಕೊಟ್ಟಿ ಆರ್ಡರ್ ಆಫ್ ಸಸ್ಪೆನ್ಷನ್ ರೀಕಾಲ್ ಆಗಿದೆ. ರೀಕಾಲಿಂಗ್ ಮತ್ತೆ ಹಾಕಲಿ. ಇದೊಂದು ರಿಸರ್ವ್ ಅಲ್ಲಿ ಬರದ್ರ ಹೆಸರಿದು R2ಗೆ ಇನ್ನೊಂದು ರಿಸರ್ವ್ ಆಯ್ತಲ್ಲ ಅದು. ಬರ್ದಿಲ್ವಾ? ಸುಮಂತ್ ಎಂ ಹೆಗ್ಡೆ. ಇದಿಷ್ಟು ಪಾಸ್ ಅವರು.
ಪಾಸ್ ಓವರ್ ಇದಾವೆ ತುಂಬಾ. ಫಸ್ಟ್ ತಗೊಂಡ
You have come to a wrong code. It is not CPC code.
CPC. What made you think I voted for CPC?
Yes, sir. Over pass over ಕರೀತಾರೆ ಇಲ್ಲೇ. ಸಾರಿ ಎಷ್ಟು ನಾಟಕ ಕೊಡ್ತೀರಾ? ಒಂದೇ ಕೇಸ್ ಎಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. The thing is, we are not seeing the conflicts.
Here you are not seeing. Other places don't ask.
All these guidelines.
One hour, 2 hours, not that now, of course, it's much better. We'll probably start again. Once we finally see what the ones are.
Oh, Monday they start.
No, that's a today only the next one. So, Monday we'll have to become police. We'll have to notice what to by you don't want to leave.
Monday India.
But they're all very hopeful it's going to be further post. I just said, I think all of us will have to say namaskar.
ಬರ್ತೀನಿ ಅದೇ ಬರ್ತೀನಿ.
ನೀನ್ ಹಾಕಿಲ್ವಲ್ಲ ಇಲ್ಲಿ ಅಲ್ಲ ಕಾಸ್ಟ್ ಇಲ್ಲ ಇದ್ದಿದ್ರೆ ಇದ್ದಿರೋದಿಲ್ಲ ಬರೀ ಇದನ್ನ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಹುಡುಗಿಗೆ. ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಕಟ್ಟಿಲ್ಲ. ಇಲ್ಲ ಯಾವ ಇಯರ್ ಅದು? 1417 of 21 state. 417 of 21. ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಅದು. ಅದ್ರ ಜೊತೆ ಕಟ್ಟಿಟ್ಟಿದ್ದಾರೆ ಇದ್ರ ಜೊತೆಗೆ. ಅಲ್ಲ ಫೈಲೇ ಇಲ್ಲ. ಅಲ್ಲ ಫೈಲ್ ನಮಗ್ ಬಂದಿಲ್ಲ, ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಪೋಸ್ಟ್ ಆಗಿದ್ರೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Submission. In the permission of the court, I am submitting a memo for being spoken to in criminal revision petition 18. Where the respondent's memo of calculation has been allowed in toto. There is one substantial payment which has been left out in that for 2.20 lakhs. So that has to be.
You already moved memo?
I'm submitting it now.
Now you are moving memo?
Yes.
You would have moved the memo in the early morning, not in the 2:30.
Missed the call with permission. Yeah.
Yes. Select ಮಾಡ್ಕೊಂಡು ಕೊಡಿ madam, note cards.
Keep your eyes.
Yesterday argued the matter, senior counsel engaged, no? Producing citations, not for judgment.
ಸಾಯಂಕಾಲ.
Citations. ಆಯ್ತು ಕೊಡಿ.
Other side WhatsApp ಮಾಡಿದ್ದೀನಿ.
ಫೈಲ್ ಹಾಕ್ತೀವಿ ಮೇಡಮ್.
ಆಯ್ತು.
Number 47. The parted matter. Argued. The court of.
47.
47. Party ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತ ಇದೀನಿ ಅಂತ. ಅಮೌಂಟ್ ಏನೋ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು.
ಇವತ್ತು ಇದೆ ಅಲ್ವಾ ಈಗ?
ಇವತ್ತು ಇದೆ. ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ ಅವತ್ತಿನ ದಿವಸ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
ಅದರ್ ಸೈಡ್ ಇದಾರ ಯಾರು? ಇದಾರ? Both counsel submit that there is an element of settlement. And hence list this matter and ಯಾವಾಗ ಬೇಕು ಹೇಳಿ settlement? Parted ಇದೆ.
Parted ಇದೆ.
ಯಾವಾಗ? 19/2 ಆಯ್ತು.
ಅವತ್ತಿನ ದಿವಸ
19/2.
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರು.
ಪಾಸ್ವರ್ಡ್
matter seal number 30.
ಡೇಟ್ ನವರೇನೋ ಹೇಳ್ತೀನಿ.
ಅವರೇನೋ ಇರ್ತೀನಿ ಅಂದ್ರಲ್ಲ 2:30ಗೆ ಅಲ್ವಾ?
ಹೌದು.
ಅವಾಗ ಆಯ್ತು ನೀವ್ ಹೇಳಿ, ಅವ್ನು ಆಮೇಲೆ ನೋಡೋಣ.
Let's in the first petition, my lords, 591.
ನೋಟ್ಸ್ ಕಂಟಿನ್ಯೂಟಿ ಇದೆಯಾ ನೋಡಿ ಅಷ್ಟೇನಾ? ಆಯ್ತು ಬೇರೆ ತಗೊಳ್ಳಿ. ಫಸ್ಟ್ ಪಿಟಿಷನ್.
Your lordships kindly, my lords, there
5918.
are 3 petitions, my lords, listed today. And the first one is 5918. My lords, the common grounds which are urged in both all 3 petitions, I'll come to them one by one before I elucidate upon the common grounds. The common grounds, my lords, is that this honorable court has already taken a view in criminal petition number.
It depends upon each allegation, not generalize ಮಾಡಕ್ಕಲ್ಲ.
No, all of these
are
are
allegation against each of the accused. We have to see.
My lords, I'm telling their grounds. That is why I'm going to go and say that, my lords, may because that is already under appeal.
Ground ಅಂತ.
Common ground. That is one common ground.
ಒಬ್ಬರಿಗೆ ಬಿಟ್ಟಿದ್ದೀರಿ ಎಲ್ಲರಿಗೂ ಬಿಡಿ ಅಂತ.
Accused number 1 has already sought a quashment and secured a quashment at the hands of this honorable court, saying that it is abuse of process. That is the first ground. The second ground being, my lords, the fact that in as much as other accused are concerned, they have gone through the rigors of the departmental inquiry and there they have been exonerated, due to which the Ashu Tiwari judgment comes into play, due to which they should also be exonerated because at a higher degree of evidence, it can't be proved is their case. Now, my lords, first of the answers to that would be, my lords, the petition that this honorable court has already quashed, my lords, is based on abuse of process, saying this is a second FIR. As regards already an FIR that has been registered. The facts of the case, my lords, are simple. During COVID, a certain individual is allegedly selling two different cases, 2 FIRs are registered, selling masks and cigarettes. Masks and cigarettes illegally. One of them is masks, the other one is 2 FIRs are registered in 2 different crime numbers. Now, my lords, there is a CCB investigating team which unearths this, seizes that, and registers an FIR in relation to that person for having committed offences there under. CCB. Now, my lords, from there what happens is that the CCB allegedly, one of them gives a complaint that to close this and file a B report, the officers of the CCB or the police then have sought for bribe or have committed offences under the PC Act under Section 7, etc., etc. Now, based on that, my lords, there is an FIR registered under Section 384 of IPC by the jurisdictional police themselves, alleging that it constitutes extortion. Post that, my lords, the allegedly without any complaint, the IO himself under the ACB, the then ACB, goes and files another FIR for offences under 7A and 13.
Without any complaint.
Without any complaint.
Suo moto.
Now, my lords, if I would not venture into or adventure into dissecting the orders of my lords, but nevertheless, my lords, to mention about it, my lords were pleased to quash the FIR registered by the then ACB on the sole ground that this is a second FIR, because there is already a first FIR under Section 384. Now, incidentally, under 384 FIR also, my lords, I'm reliably told that even that is quashed because it doesn't constitute extortion.
It doesn't. Ingredients of Section 384.
384 illa. So now is the case, my lords, where allegedly whether there was a demand and that demand was made or no, in furtherance of the said demand, money is to be paid or no. All of that are an issue to be dealt in trial, is my respectful submission. Even it is espoused before this honorable court to go into the question as to whether there is demand and acceptance. With the deepest respect, I would say, my lords, that this honorable court lacks the wherewithal, or rather the full power to go into a full-blown trial, is my respectful submission. Now, my lords, the only ground on which it was quashed is it a second FIR? Now, my lords, we have my lords have my predecessor in special PP, Mr. Manmohan, as I've seen the order threadbare. He has relied on judgments of TT Anthony and Anju Chowdhury, which are, my lords, considered as a benchmark. Post that, there is another judgment of Amit Sharma. What they say is that even if there is another additional offense as such, a second FIR cannot be registered. Maybe they could probably make a requisite application in the trial proceeding.
Added along with
that.
Other.
Please. So what my submission would be, however, these are 2 domains of offences under 2 different provisions of law. At this juncture, my lords, I stop and ask this question unto myself, that if there is a proceedings happening under the Prevention of Corruption Act, would that preclude from initiating a proceedings under the PMLA Act? Though, my lords, I would respectfully submit that both of them come out of the same set of facts as against the same set of individuals, but 2 different offences under 2 domains of law. under two different penal provisions. Would that proceeding be considered a second FIR or bad at law, in as much as the offenses of the whole concept of the second FIR being bad at law is the protections given under articles of the Constitution, double jeopardy, the relevant section under the IPC, etc. You can't be tried for the same offense twice as such. But do these constitute, because my lords, here is a strange case where admittedly, my lords, there is an allegation explicitly made that there was a demand and acceptance. Though the demand was for an exorbitant amount of some 30 lakhs and a very small amount of 1 lakh was allegedly accepted, not accepted, etc. etc. Those are fact-based questions, can't be gone here, is my respectful submission. In as much as my lord's order is concerned, we have preferred an appeal as against it, and it is pending in Honorable Supreme Court. So, my lords, my respectful submission there would be that it would not constitute a second FIR, because, my lords, incidentally at this juncture 384 also is quashed, saying it doesn't constitute. And now, my lords, if parallelly this is also quashed, saying this is a second FIR, they are practically exonerated of everything they have committed, whatever it is. May be crime, may not be a crime, may be an abuse of process, etc. etc. Besides that, my lords, the petitioners herein which are before this honorable court, in as much as one petitioner is concerned, there is no departmental inquiry at all.
First, with regard to
Writ petition, petition number. Statement of objection. 4851.
ಒಬ್ಬರೇ ಪಿಟಿಷನರ್ ನೋಡಿಲ್ಲ. It is only one petitioner ನೋಡಿ all the petition.
ಎಲ್ಲದರಲ್ಲೂ ಒಬ್ಬರೇನಾ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಅಂದಾನ ಅಂದಂಗಿತ್ತು ನೀವು, ಹೌದಲ್ಲ? A2.
My lords, even otherwise, my lords may have the statement of objections that I have filed. I will take one of them. In criminal petition 622 of
first one ಇದೆಯಾ ಹೇಳಿ. First one 5918 ಹೇಳಿ.
Cause list ಕೊಡ್ರಿ. What will be?
One by one.
5918. ಎಲ್ಲಿದೆ objection 5918?
What is the allegation against him? Now charge sheet is also filed?
No, my lords. The whole investigation doesn't seem to have taken off at all.
Like, if it is passed against one accused, what prevented you in filing the charge sheet in respect of other accused? This is the crime of 2020. Crime of 2020.
My lords, we are on the verge of filing. I think, if I'm not wrong, my lords, the last I interacted with the IO, when it came up for last date of hearing, they have sent it for section 9.
Stay in illalla?
Stay, it's not there.
Illa.
Please.
Illu illa, Supreme Court allu illa.
Supreme Court allu illa.
Illa.
Notice agide very Supreme. ಈಗ ನಾವು ಸ್ಯಾಂಕ್ಷನ್ ಕಳಿಸಿದ್ದೇವೆ. ನಮಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಗೆ we are awaiting. This was the last instructions I had. Pursuant to receiving the
sanction ನೀವು
lords, within the last 1 or 2 months ಅಲ್ಲೇ ಕಳಿಸಿದ್ರು. Last date month ಅಲ್ಲಿ ತಾವು hearing ಬಂದಾಗ I had interacted with the IO, and my IO had reliably.
Now only FIR is there before the court. ಹೌದಾ?
Now, my lords, but I would respectfully submit that the investigation is complete. We have sent it for section 19 permission. My investigation is complete and the charge sheet is ready. This is an essential factor that needs to be reasoned. Now, my lords may have 5918.
First, you go to the charge FIR.
Please, my lords.
Against this petitioner, what is the allegation? This is in respect of PC Act.
Please, my lords.
Page 28.
Page
28 ಅಲ್ಲಿ, that's the
20.
first FIR.
20.
Well, this is the 28 is copied, my lord, now. 28 is the first FIR. Here, my lord, I had read to your lordships. Para 10.
7A, 13(1)A and 13(2), page number 20. Annexure A. Washment also is being sought of that only.
20.
17 of 2020.
7A, 13A.
So 7A, 13(1)A, 13(2).
Crime number ಏನಿದು?
17. There is, my lord, 6 crime numbers totally here.
6. Okay.
ಯಾಕಂದ್ರೆ first 2
ಒಬ್ರ ಮೇಲೆ 6
ಇಲ್ಲ my lords. First 2 ಅವು ಅವರು
CCB
ಅವ್ರು ಹಾಕಿರೋದು. ಅದಾದ್ಮೇಲೆ 384 ಕೆಳಗಡೆ ಹಾಕಿರೋ 2.
ಮತ್ತೆರಡು.
ಇಲ್ಲಿ ಟೋಟಲಿ ಮತ್ತೆ 2.
ಮತ್ತೆ ಎರಡನೇ ಸರಿ ಮತ್ತೆ 384 ಎರಡಕ್ಕೆ ಫಸ್ಟ್ CCB 2 ಆಮೇಲೆ
384 ನವರು
ಸ್ಟೇ ಕೊಟ್ರಿ.
ಫಸ್ಟ್ 384
ಆಮೇಲೆ ಇಲ್ಲಿ 7A 13A
ಮೊದ್ಲು ಫಸ್ಟ್ 2 ಆಮೇಲೆ 2 ಆಮೇಲೆ 2 ಅಂದ್ರಿ. ಫಸ್ಟ್ 2 ಹಾಕಿದ್ ಯಾವ ಅಫೆನ್ಸ್?
ಅದು ರೆಗ್ಯುಲರ್ ಇವ್ರ ಮೇಲೆ ಅಲ್ಲ, ಅದು
ಬೇರೆಯವ್ರ ಮೇಲೆ.
ಅವರು ಸಿಗರೇಟ್ ಮತ್ತೆ ಮಾಸ್ಕ್ ಮಾರೋರ್ ಮೇಲೆ ಹಾಕಿರೋ 2 ಕ್ರೈಮ್ ನಂಬರ್. ಅವು 2 ಕ್ರೈಮ್
ಬೇರೆನಾ?
ಅಲ್ಲಿ ಅವ್ರು ಮತ್ತೆ ಅವ್ರು ಯಾರು ಮಾಡ್ತಿರ್ತಾರೆ ಅವ್ರು ಇರ್ತಾರೆ ಅಕ್ಯೂಸ್ಡ್. ಇವ್ರು ದೀಸ್ ಪೀಪಲ್ ವಿಲ್ ಬಿ ದ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ಸ್ ಅಲ್ಲಿ. ಅಲ್ಲಿ ದಟ್ ಇಸ್ ವೈ ಐ ಗೇವ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್. ಅಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲಿ ಸೀಜರ್ ಆದ್ಮೇಲೆ ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ ಅಂತ ಅಲೆಜಿಡ್ ಆಫೆನ್ಸ್.
ಕ್ಲೋಸ್ ಮಾಡಕ್ ಸಲಕ್ಕೆ ಈ ದುಡ್ಡು
ಕೇಳಿರೋದು. ದಟ್ ಇಸ್ ದ ಅಲಿಗೇಷನ್.
ಆಯ್ತು 13(1). ಅದಕ್ಕೆ ಈ 2 ಕೇಸು ಐವೋಗಳೇ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರು ದುಡ್ಡು.
ಅಕ್ಯೂಸ್ಡ್ ಹಿಯರ್ ಇನ್ ಆರ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ ಓನ್ಲಿ.
ಆಯ್ತು.
ಆಮೇಲೆ the other thing is, my lords, the grounds that was urged before this honorable court where my lords have quashed it was that the 384 proceedings, section 384 ಅಲ್ಲಿ ಏನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇದು FIR ರಿಜಿಸ್ಟರ್ ಆಗಿರುತ್ತಲ್ಲ ಅದನ್ನ ತಾವು ಸ್ಟೇ ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ before this honorable court. Obviously, my lords, on the ground that extortion is not constituted. ಅದಕ್ಕೆ ಅದನ್ನ ಸರ್ಕಮ್ವೆಂಟ್ ಮಾಡಕ್ಕೆ ಸ್ಟೇನ ಅಂತ ಇವರು ACB ಅವರು ಈ ಫ್ರೆಶ್ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಗ್ರೌಂಡ್. ದಟ್ ಇಸ್ ಒನ್ ಆಫ್ ದ ಗ್ರೌಂಡ್ಸ್ ವೇರ್
ಅಲ್ಲಿ ಸ್ಟೇ ಸಿಕ್ತು ಅಂತ ಇಲ್ಲಿ
ಇನ್ನೊಂದು FIR ಮಾಡಿದ್ದಾರೆ.
ನಮ್ ಗ್ರೌಂಡ್ ಅಲ್ಲ, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಅಬ್ಸರ್ವೇಷನ್.
ಅಲ್ಲ, ಮೈ ಲಾರ್ಡ್ಸ್ ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ಇಟ್ ಆಸ್
ಮೋಸ್ಟ್ಲಿ AG ಬಂದು ಹಿಯರ್ ಮಾಡಿದ್ರು. ನನ್ ಮುಂದೆ ಸ್ಟೇ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಅಂತ ಸ್ಟೇ ಒಪ್ಕೊಬಿಟ್ರು. ಆಮೇಲೆ ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ಏನ್
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ SLP ಹಾಕಿದ್ರು, SLP ಸ್ಟೇ ಆಯ್ತು, ಆಮೇಲೆ SLP ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಇದೇ ಕೇಸು.
ಆಮೇಲೆ AG ನನ್ ಚೇಂಬರ್ ಓಡ್ ಬಂದು ಇಲ್ಲ ತಪ್ಪಾಗ್ಬಿಡ್ತು, ಹಿಂಗ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ಹೇಳಿ ಬಂದಿರು.
ಎಕ್ಸಾಕ್ಟ್ಲಿ ದಿಸ್
AG
ದಿಸ್ ವೆರಿ ಕೇಸ್.
ಏನಾಯ್ತು, ಇಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ವಿ,
ಅಲ್ಲಿ SLP
ಅದನ್ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದಾಗ ಅವರು ದೇ ಕನ್ಸಿಡರ್ಡ್ ಟು ಗಿವ್ ಎ ಸ್ಟೇ. ಕೇಸ್ ಏನು ಇಲ್ಲ
ಅಂತೇಳಿ
ಸ್ಟೇ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು AG. ಆಮೇಲೆ ಬಿಹೈಂಡ್ ದಿ ಬ್ಯಾಕ್ ದೇ ವೆಂಟ್ ಟು ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಆಮೇಲೆ ಅಲ್ಲಿ ಸ್ಟೇ ಹೋಗ್ಬಿಟ್ರು ಇಲ್ಲಿ ನಮ್ಮ ಆರ್ಡರ್ನ. ಆಮೇಲೆ ಲೇಟರ್ ಅಲ್ಲೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಎಕ್ಸಾಕ್ಟ್ಲಿ ದಿಸ್ ವೆರಿ
ಇದೇ ಕೇಸ್
ದಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾವ್ ರೆಕಾರ್ಡೆಡ್ ಇಟ್ ಇನ್ ದ ಆರ್ಡರ್ ಶೀಟ್. ನಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿದಿರಿ ತಾವು.
ನಾವೇ ರೆಸ್ಟ್ ಟು ಮೈ ಚೇಂಬರ್ ನಾನು ಹೇಳಿದೆ ಅಲ್ಲ ರೀ, ನೀವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡಿದ್ಮೇಲೆ ಯು ಓನ್ಲಿ ಕನ್ಸಿಡರ್ಡ್ ಟು ಗ್ರಾಂಟ್ ಸ್ಟೇ, ದೆನ್ ಹೌ ಯು ಕ್ಯಾನ್ ಮೂವ್ ದಿ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತ ಕೇಳಿದೆ ನಾನು. ಅವಾಗಿಲ್ಲ ಇಲ್ಲ ನಮ್ ಕಡೆ ತಪ್ಪಾಗಿದೆ ಅದು ಇದು ಅಂತಂದ್ರು. ಮೋಸ್ಟ್ಲಿ ಮನಮೋಹನ್ ಅಂಡ್ AG ನಾವಡಿಗೆ ಯಾರ ಇದ್ರು,
ಮನಮೋಹನ್
ಅಲ್ಲ,
ಈಗ
ಮುಂದೆ ಕ್ವಾಶ್ ಆಗಿ
ಪೊನ್ನಣ್ಣ ಅವರು ಪಿಟಿಷನರ್ ಅಪಿಯರ್ ಆಗಿದ್ರು. My learned friend is now arguing against the findings given by your lordships in the petitions. Ground ಅಂತಾರೆ, ಗ್ರೌಂಡ್ ಅಲ್ಲ, that they are all the findings.
ಅವ್ರ ಗ್ರೌಂಡ್ ಏನಂತ
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾರೆ
ಅವ್ರು ತಮ್ಮ ಮುಂದೆ ಹಾಕಿರೋ ಪೆಟಿಷನ್.
ನಾವು ಯು ಹ್ಯಾವ್ ಟು ಸ್ಪೆಸಿಫೈ ಕೇಸ್ ಏನು. A1 ಮೇಲೆ ಇದ್ದಿದ್ದ ಗ್ರೌಂಡ್ ಅನ್ನು ಹೇಳಿ, ಈ A2 ಮೇಲೆ ಇರ್ತಕ್ಕಂಥ ಅಲಿಗೇಷನ್ ಏನು ಅಂತ ಹೇಳಿ. ವೆದರ್ A1 ಅಲಿಗೇಷನ್ A2 ಅಲಿಗೇಷನ್ ಸಿಮಿಲರ್ ಇದೆಯೋ ಅಥವಾ ಡಿಫರೆಂಟ್ ಇದೆಯೋ, ಅಕ್ಯೂಸೇಷನ್ ಏನಿದೆ, A1 ಏನ್ ಮಾಡ್ದ, A2 ಏನ್ ಮಾಡ್ದ, ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಿ ನೀವು
ಅದಕ್ಕೆ ಪೇಜ್ 28 ಸ್ವಾಮಿ ಒಂದೇ ಪ್ಯಾರಾ ನಾನು ತೋರಿಸ್ತೀನಿ.
ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. ಇಲ್ಲಿ
ಪೇಜ್ 28 ಅಲ್ಲಿ ಒಂದೇ ಪ್ಯಾರಾ ಓದ್ರೆ not you not will be able to not appreciate what is the allegation. ಪೇಜ್ 28 just one
ಬಟ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅಕ್ಯೂಸ್ಡ್ ಇದ್ರು?
3 ಜನ ಇದ್ದಾರೆ. A1 A2 A3. A1 ಗೆ A3 ಗೆ ತಾವು ಕ್ವಾಶ್ ಮಾಡಿದಿರಿ.
A3 ಗೂ
ಕ್ವಾಶ್ ಆಗಿದೆ. ನಾನು A2
ಉಳಿದಿರೋದು A2.
Your lordship will find page 28 not just few lines of page 28. The first case registered 28 ಅಲ್ಲಿ ಕಾಲಮ್ 10 ಮೇಲೆ ದಿನಾಂಕ 12/5/2020 ಶ್ರೀ ಸೋನ್ಸೋ DCP ಅಪರಾಧರವರು ಫಿರ್ಯಾದಿಯಾದ ಆದಿಲ್ ಅಜೀಜ್ ಅವರ ಹೇಳಿಕೆ ಪ್ರತಿಗಳನ್ನು ಲಗತ್ತಿಸಿ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಜರುಗಿಸುವಂತ ಪತ್ರ ಬರೆದಿದ್ದು, ಪತ್ರದ ಸಾರಾಂಶವೇನೆಂದರೆ ಫಿರ್ಯಾದಿಯವರಾದ ITC ಕಂಪನಿಯ ಸಿಗರೇಟ್ ಆಗಿರುತ್ತಾರೆ. ಅವರ ಬಳಿ ಸುಮಾರು 100 ಜನ ಸೈಕಲ್ ಮೇಲೆ ಸಿಗರೇಟ್ ಸರಬರಾಜು ಮಾಡುವ ಜನರಿದ್ದು ಅವರ ಜೀವನಕ್ಕೆ ತೊಂದರೆಯಾಗುತ್ತಿದ್ದು ಫಿರ್ಯಾದಿಯವರು ತಮ್ಮ ಪರಿಚಯದ ಬಾಬು ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ರವರನ್ನು ಸಂಪರ್ಕಿಸಲಾಗಿ ಸದರಿ ಬಾಬು ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ರವರು CCBI ACP ರವರಾದ ಪ್ರಭುಶಂಕರ್ ವಾಶ್ಮೆ ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಅಲಿಗೇಷನ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ಪ್ರಭುಶಂಕರ್ ಅವರ ಪರಿಚಯವಿದ್ದು ತಮ್ಮ ಪರಿಚಯದ ಭೂಷಣ್ ಅವರೊಂದಿಗೆ ಹೋಗಿ ACP ರವರನ್ನು ಭೇಟಿ ಮಾಡಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ
ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ಡೈರೆಕ್ಟೆಡ್ ACP let him go and meet
ACP ಅಂತ ಹೇಳ್ತಾರೆ. ನಮ್ಮ ಪರಿಚಯದ ಭೂಷಣ್ ಅವರೊಂದಿಗೆ ಹೋಗಿ ACP ರವರನ್ನು ಭೇಟಿ ಮಾಡಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ನಾನು CCB ಕಚೇರಿಗೆ ಹೋಗಿ ಪ್ರಭುಶಂಕರ್ ಹಾಗೂ PIಗಳಾದ ಅಜಯ್ ಮತ್ತು ನಿರಂಜನ್ A3, ಅಜಯ್ ಮಿಲಾಡ್ ಇಸ್ ಅ ಪಿಟಿಷನರ್, ಪ್ರಭುಶಂಕರ್ A1 ಅವುಗಳನ್ನು ಭೇಟಿ ಮಾಡಿದ್ದು. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತುಕತೆಯಲ್ಲಿ ಪ್ರತಿ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟರ್ಗಳಿಗೆ ತಲಾ 14 ಲಕ್ಷ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದು. ಅದರಂತೆ ಏಪ್ರಿಲ್ 30ರಂದು 32.5 ಲಕ್ಷ ಹಾಗೂ ಮೇ ಮೊದಲ ವಾರದ 30 ಲಕ್ಷ ಒಟ್ಟು 62.5 ಲಕ್ಷ ಹಣವನ್ನು ಫಿರ್ಯಾದಾರು CCB ACP ರವಾದ ಪ್ರಭುಶಂಕರ್ ಹಾಗೂ ಇನ್ನಿಬ್ಬರು PIಗಳು ನೀಡಿರುತ್ತಾರೆ. ದಿನಾಂಕ 7/5/20ರಂದು
ಮಾಡಿದವರು ಯಾರು?
ಪ್ರಭುಶಂಕರ್ ಫಸ್ಟ್
ಮಾಡಿದ್ರು ಅಂತ
ಆಯ್ತು. ಸೊ ಇಟ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ನಾಟ್ A1. ಪ್ರಭುಶಂಕರ್ ಹಾಗೂ ಇನ್ನಿಬ್ಬರು PIಗಳು ನೀಡಿರುತ್ತಾರೆ. ದಿನಾಂಕ 7/5/20ರಂದು ACP ಹಾಗೂ ಇಬ್ಬರು PIಗಳು ತಮ್ಮ ತಪ್ಪನ್ನು ಒಪ್ಪಿಕೊಂಡು ರವಿಕುಮಾರ್ DCP ರವರಿಗೆ 25 ಲಕ್ಷ ಹಣವನ್ನು ತಮ್ಮ ಸಮಕ್ಷಮ ನೀಡಿದ್ದು ಹಣ ಹಾಗೂ ಹಣದ ಬ್ಯಾಗ್ ಅನ್ನು ಫಿರ್ಯಾದಿ ಗುರುತಿಸುತ್ತಾರೆ. ಲಾಕ್ಡೌನ್ ಅವಧಿಯಲ್ಲಿ CCB ಅಧಿಕಾರಿಯಾದ ಪ್ರಭುಶಂಕರ್ ಹಾಗೂ PI ಅಜಯ್ ಮತ್ತು ನಿರಂಜನ್ ಅವರುಗಳು ಬಾಬು ರಾಜೇಂದ್ರ ಪ್ರಸಾದ್ ಮತ್ತು ಭೂಷಣ್ ಅವರಿಗೆ ಸೇರಿಕೊಂಡು ಸಿಗರೇಟ್ ಅಕ್ರಮ ಮಾರಾಟ ದಂಧೆಯಲ್ಲಿ ತೊಡಗಿ ನಗರಾದ್ಯಂತ ಇರುವ ಸಿಗರೇಟ್ ವಿತರಕರಲ್ಲಿ ಲಕ್ಷಾಂತರ ಹಣವನ್ನು ಬಲವಂತವಾಗಿ ಸುಲಿಗೆ ಮಾಡಿ. ದಿಸ್ ಇಸ್ ನಾಟ್ ದ ಅಲಿಗೇಷನ್. ದಿ ಫೈಂಡಿಂಗ್ಸ್ ನಾಟ್ ಆಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ not page 58 onwards. 58 ಅಲ್ಲಿ relevant not from page 93 para 44 onwards. My learned friend said 91 in the second para 43 deals with second FIR.
para 43
is second FIR. Now kindly come to page para 44 page 93. On merits also you have lordship not was pleased to consider. My learned friend said illa second FIR ಅಂತ question ಆಗಿದೆ ಅಂತಂದ್ರು. ಅದಲ್ಲ. Not your lordship in threadbare considered, not para 44. It is important to note that in these petitions, first of all, there is no complaint as contended by the learned counsel for the petitioner, but the case is registered by the respondent number 3 DYSP, who is the complainant, and he himself requested the so-and-so learned so-and-so, and based on the said requisition made to the court, case has been registered. The aggrieved person have not given any complaint with regard to demand and acceptance, and the same is only registered by the respondent number 3. The apex court in the case of so-and-so categorically held that the demand and acceptance are sine qua non for initiating proceedings so and so. Then it is also important to note that this court granted stay in respect of the earlier cases registered for the offence punishable under section 384 IPC, and subsequently these two cases are registered. This your lordship not have recorded. It is not by contention. It is contention of the learned counsel for the petitioner that to overcome the interim orders granted by this court earlier, the cases have been registered. It is important to note it is important to note that there is delay in registering the case, and I have already pointed out that the incident are mentioned in the month of March and April, but the case have been registered in the month of May. This is non-contentional finding. No doubt. The principles laid down by the judgment referred to by learned counsel of the respondent in case of PP so and so, the apex court has held that if the court entertains 482 petition for quashing of the registration of the FIR, the same amounts to killing a stillborn child, and at the same time, it has to be noted that the said child should be born legally and not by creating documents with malicious intention. If the person is booked, it amounts to illegitimate child. No doubt, the investigating officer should be allowed to unearth the crime as held in the case of so and so, but complaint should disclose the cognizable offense. But in the cases on hand, no complaint at all except the requisition of the investigating officer, and the child is born at the hands of the investigating officer with malafide intention. If the complaint is manifest of malafide intention, the court has to take note of the same. The criminal prosecution must be without any manifest of malafides, and it is based on the malafide this court can exercise power under 482. I have already pointed out that the two cases are registered in the same amounts to second FIR. Since no complaint for second FIR, the earlier case has been registered for the offence punishable under section 384. No doubt, the learned counsel for respondent would contend that both offences are distinct. You really saw me distinct, and the earlier complaint IPC offences are invoked, and in these proceedings, Prevention of Corruption Act offences are invoked. I have already pointed out that in these cases, no complaint at all, and the respondent number 3, who is working as a deputy superintendent of police, he himself is a complainant in column number 5 of the FIR, and he himself, though claim in column number 9 that separate complaint has been enclosed, there is no such complaint, and apart from that, he himself has registered the case, giving requisition to learned so and so. And hence, the very contention of the learned counsel for petitioner is the very registration of case against the petitioner with malafides, manifest of malafides. The delay has not been properly explained, and apart from that, there is no demand and acceptance, which is sine qua non for registration of the case under PC Act, and the same is missing, and merely referred the name of the petitioner that illegal corrupt practice was made. In the absence of any demand and acceptance recovery, there cannot be any criminal prosecution, that too under PC Act. No doubt, in one case, it is contended that the recovery is made at the instance of the petitioner, and in order to 25 lakhs recovery adukku taa uttara kottidare sir. And in order to substantiate the same, there is no material at all except creation of documents. Though alleged that one Bhushan has handed over the amount to the petitioner, no material on record, and the petitioner is not part of the recovery proceedings except creation of measures at the instance of Panchas. But it is only creation of documents with the respondent, no recovery of any weight money at the instance of petitioner. Only an allegation is that he has proceeded, he has produced. Having perused the materials available on record, it is classic case of abuse of process. First of all, no complaint, and apart from that, no demand and acceptance. And that too, case has been initiated at the instance of respondent number 3 suo moto by giving requisition to the court. It is important to note that other cases also have been registered against the petitioner hearing, and this court has granted stay in respect of other proceedings in coming to conclusion that there is no prima facie material. Therefore, second FIR has been registered by the respondent in the absence of complaint, and no allegations of demand and acceptance by this petitioner, and only refer to the name of other accused who referred the name of the petitioner. Under these circumstances, the petitioner facing criminal prosecution, which is serious in nature, amounts to miscarriage of justice. This court earlier granted an order of stay in these proceedings also, in all the petitions, and the same has been challenged before the Honorable Apex Court in SLP number so and so. And those stay was granted at the first instance, where it order dated so and so. These SLPs are dismissed, confirming the order of stay granted by this court. When the matter was listed for hearing, the Apex Court comes to the conclusion that no ground to interfere with the impugned order passed by this court, and confirm the order of stay granted by this court. Having considered the material available on record, I have already pointed out that there is no any complaint, and also 2 petitions are arising out of second FIR, and very complainant himself has registered the case, making requisition to the court, and no demand and acceptance, which is sine qua non for registration of the case under PC Act. And when there is no demand and acceptance, the question of invoking PC Act, particularly Section 7A, 13(1)A PC Act, is nothing but an abuse of process of court. If this court fails to exercise the powers under Section 482 CRPC, when there is no complaint, demand and acceptance, and that too 6 cases are registered against this petitioner, in one or the other, either invoking IPC or PC Act, there is a prima facie emerge that it is a clear case of abuse of process and infringing between the infight, not your lordship, infight between officers of the very same department for the reasons best known to them, and booked the cases against the petitioner in one or other, and hence it is appropriate case to invoke 482. Then not your lordship was pleased to ultimately allow. It is not its contention. It is very second FIR Allah. Your lordship not, as your lordship not now remembers, not your lordship have considered everything. This has been challenged. There is no interim order, not since this is not 5th year. Not your lordship was kind enough to pass this order in 2021 September. Allegations not I brought to your lordship's kind notice. Allegations are in fact against A1, not against me. Our ಕೇಳಿದ್ರು ಅಂತಿದೆ. ಏನು ಕೇಳಿದ್ದಕ್ಕೆ ಡಿಮಾಂಡ್ ಆಕ್ಸೆಪ್ಟ್ ರಿಕವರಿ ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ ಅಂತ ಆಗಲೇ ಫೈಂಡಿಂಗ್ ಇದೆ. He may not go against the findings given by this honorable court. He may have to not go to the next court and challenge this, which they have done, and there is no order. And he may not be. My only request is not representing the same institution, maybe a different person, but he may not permitted to argue against this very order, is my humble submission. This has become final as on today.
It has not become final, my lord.
As on today.
Subject to finality by the Supreme Court.
ಅದಾಗ್ಲಿ ನೀವು ಮಾಡಿ ಎಷ್ಟು ವರ್ಷ?
I take exception.
ಎಷ್ಟು ವರ್ಷ? 5 ವರ್ಷ ಆಗಿದೆ. 5 ವರ್ಷ ಆಗಿದೆ. ಸ್ಟೇ ಇದೆಯಾ?
5 ವರ್ಷ ಆದ್ರೆ ನಾವೆಂತ
ತಗೊಳ್ಳಿ. ಅಲ್ಲ ಎಷ್ಟೊಂದು ಕೇಸಲ್ಲಿ ರಾತ್ರಿ ಆಗಿದ್ದಾದ್ರೂ ಬೆಳಗ್ಗೆ ಹೋಗಿ ಸ್ಟೇ ತಗೊಂಡ್ಬರ್ತಾರೆ. We have seen what state not does. Not in this kind of. 5 ವರ್ಷ ಆಗಿ ನನ್ನ ನೋಡ್ಬೇಕು.
ನಾನೇನ್ ಹೇಳೋದು?
ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಸ್ಟೇ ತಗೊಳ್ರಿ.
Ultimately what I am saying, my lord, is 384 ನ offense constitute ಆಗಲ್ಲ ಅಂತ ಅದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಡೋದು. ಇಲ್ಲಿ ultimately
this court granted stay that was challenged before the Supreme Court. Supreme Court again confirmed the order
of stay.
Then this court on merits considers the matter. If any exigency, you can move the matter and get it stay this order. Why you are not done from last 4 years? You would have moved the matter before the Supreme Court. Alva?
SLP is filed much after that, my lords, not 4.
21.
ತಮ್ಮ ಆರ್ಡರ್ 21 2021 ಸೆಪ್ಟೆಂಬರ್.
ಈ ಆರ್ಡರ್ ಯಾವಾಗ 21?
8 ಸೆಪ್ಟೆಂಬರ್ 20 ಪೇಜ್ 58.
ಅದಾದ್ಮೇಲೆ ACB ಇಂದ ನಮಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ಟ್ರಾನ್ಸಿಷನ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಇನ್ನೂ ಫೈಲ್ಸ್ ಅದೆಲ್ಲ ವಿ ಆರ್ ಕೋಆರ್ಡಿನೇಟಿಂಗ್ ಬಿಟ್ವೀನ್ ಒನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
5 ವರ್ಷ.
ಯಾವಾಗ ಹಾಕಿರೋದು?
ಅರೆ 5 ವರ್ಷ ಬೇಕೇ ಆಗುತ್ತೆ. ಲಾಸ್ಟ್ ಕೇಸ್
5 ವರ್ಷ.
ಇದ್ರ ಮೇಲೆ ಯಾವಾಗ ಹಾಕಿರೋದು ನೀವು?
Lords, I'll have to get the details.
ಆಗ್ಲೇ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲ ದೇ ಫೈಲ್ ಓನ್ಲಿ ಮಿಲಾಡ್. ಅವಾಗಲೇ ಆಗ್ತದೆ ಸ್ವಲ್ಪ
ಹಿಂದೆ ಲಾಂಗ್ ಬ್ಯಾಕ್
2022 itself they filed.
22 ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮತ್ತೆ
1522 of 2000.
But my only humble request is, not your lordship have already held passed an order which as on today have become final. But he cannot be permitted to, no, he cannot be permitted to dissent your lordship's order.
ಪೆಂಡಿಂಗ್ ಇದೆ ನೋಡಿ, ಮೂವ್ ಮಾಡಿ. ಇನ್ನೊಂದು 2 ವಾರ ಡಿಫರ್ ಮಾಡೋಣ. ನಮ್ಮ ಆರ್ಡರ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡೋದಾರ ತಪ್ಪೈತೆ ಮತ್ತೆ.
ಅಲ್ಲ ಅದನ್ನ 12 ಸಲ ಹೇಳಿದ್ದು. ದಿಸ್ ಇಸ್ ಥರ್ಡ್ ಅಮಲಾಡ್ 13th hearing date.
ಇಲ್ಲ ಇದು ತಪ್ಪಿದು. ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಬೇಕು ಅಂತ ಟೈಮ್ ಮೊದಲು ಫಸ್ಟ್ ದೇ ಕೇಮ್ ಬಿಫೋರ್ ದಿಸ್.
This is
we have
saying it is exonerated in departmental proceedings. ಇವಾಗ ಇದನ್ನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
we have adversarial system
ಅಷ್ಟೇ.
ನಮ್ಮ ಆರ್ಡರ್ ಏನ್ ಫೈನಲ್ ಅಲ್ಲ, ಮೇಲ್ಗಡೆ ಇರುತ್ತೆ. ಅವ್ರೇನಾದ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಾವ್ ಆರ್ಡರ್ ಬರ್ದಿರೋ ತಪ್ಪು ಅಂತ ಅಂದ್ರೆ ಲೆಟ್ ದಮ್ ಸ್ಟೇ ಇಟ್. ಅಟ್ ಲೀಸ್ಟ್ ಡಿಸ್ಪೋಸಲ್ ಬೇಡ, ಸ್ಟೇ ಏನಾದ್ರು ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
we will endeavor to that. We'll endeavor to that.
ಅಲ್ವಾ?
we will endeavor to that.
ಅಲ್ಲ 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಇನ್ಫ್ಲುಯೆನ್ಸ್ ಮಾಡಬಾರದು ಅಷ್ಟೇ ಪಿಟಿಷನ್.
ನೀವು ಈಗ ಬಂದು ಇಲ್ಲ
ಎಲ್ಲಿ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಆಗುತ್ತೆ? why will it become infructuous? I don't understand.
just not read the latest order. ಅವರೇ ಟೈಮ್ ಕೇಳಿದ್ರೆ SLP ಯಾವಾಗ ಅಂದ್ರೆ ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸ್ವಾಮಿ. 3/2/25ಕ್ಕೆ
ಅಲ್ಲ ಅವರೇ
ಅವ್ರ ಟೈಮ್ ಕೇಳ್ತಾರೆ, ಇಲ್ಲೊಬ್ಬನ್ ಟೈಮ್ ಕೇಳ್ತಾರೆ.
ನಾನೇನೀಗ ಟೈಮ್ ಕೇಳಿಲ್ಲ. ನಾನು ಇವಾಗ ಹೇಳ್ತಾನೂ ಇಲ್ಲ. My lord said we'll defer it by 2 weeks. I said I'll take it.
ಅಲ್ಲಿ ಅವರೇ 3/2ಕ್ಕೆ ಮೊನ್ನೆ
ನಾನು ಈಗೂ ಟೈಮ್ ಕೇಳಲ್ಲ.
3/2 ಮೊನ್ನೆ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ ಪಿಟಿಷನರ್ ಪ್ರೇಸ್ ಟೈಮ್ for 4 weeks.
There might be some. I'll follow it up myself, my lords. That is a different issue.
22
to now accommodate. I'll follow it up myself.
ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿದಿದೆ. your lordship not kindly not consider our
ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ ರೀ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್. 5918 ಅಲ್ಲಿ ಅವರು ಇನ್ನು
ಅಲ್ಲ ಇನ್ನು ಇವಾಗ ಈ ಮೊನ್ನೆ ಲಾಸ್ಟ್ ರೌಂಡ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಬಂದಾಗ ಇವ್ರದ್ದು ಆಸ್ ರಿಗಾರ್ಡ್ಸ್ 1 ಕ್ವಾಶ್ ಆಗಿ ಹೋಗಿದೆ. ನಾವು 2 ಏನ್ ಕೇಸ್ ಅಂದ್ರೆ ನನ್ನ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಎಕ್ಸಾನರೇಟ್ ಮಾಡಿದ್ದಾರೆ.
ನಾನು ಅದು ಹೇಳಿಲ್ಲ. ಈಗ ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿದಿನಲ್ಲ. ಈಗ 1 2 3 ಮೇಲೆ ಅನಾಲಿಗೇಷನ್ ಅಂತ ತೋರಿಸಿದ್ದೀನಿ.
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಅವ್ರೇನ್ ಹೇಳಿದ್ರು, ನನ್ನ ಸಬ್ಮಿಷನ್ ಮುಗ್ದಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ಹಳೆ ಡೇಟ್ ಅಲ್ಲಿ ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು? ನಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ನಾನು ಎಕ್ಸಾನರೇಟ್ ಆಗಿದ್ದೀನಿ. ಆಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್ ಐ ಶುಡ್ ಬಿ.
ನೋ that is an additional ground ಅಷ್ಟೇ.
ಇವಾಗ
only an additional ground.
ಮತ್ತೊಂದು ಅಡಿಷನಲ್ ಗ್ರೌಂಡ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ.
that is only an additional ground.
ಅವ್ರು ಒಂದ್ ಬಾರಿ ಎಲ್ಲ ಹೇಳ್ಬಿಡ್ಲಿ, ಆಮೇಲೆ ನಾನು ಹೇಳ್ತೀನಿ.
ಅವ್ರಿಗೆ ಎಲ್ಲಾನು ಹೇಳ್ಬಿಟ್ಟಿದಾರಂತ. ಈಗ ನಿಮ್ದು ಹೇಳ್ಬಿಟ್ಟು
ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರ, ಬೆಳಿಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ರು, ಇವಾಗ ಎದ್ದು ಬಿಟ್ಟು ಮತ್ತೆ ಹೇಳ್ತಾರೆ. ಈಗ ನಾನು ಹೇಳಿದ್ಮೇಲೆ ಮತ್ತೊಂದು ರೌಂಡ್ ಹೇಳ್ತಾರೆ. ಇದು ultimately, my lords, the fulcrum of this entire proceedings is my lord's order. Because if my lord's order is upheld in the Supreme Court, practically nothing survives it. There is no doubts about it. If that is upset there, my lords, the whole things might have.
But again, it will reopen.
It will reopen.
Even against A1 and A3 and also
A1, A3 and A2 also. Now the complaint averment there, my lords, is in a 384 al my learned friend read it. Chamber ಕರ್ಸಿದ್ರು, ಅಲ್ಲಿ 3 ಜನ ಇದ್ರು.
ಆಯ್ತ್ರಿ. ವಾಟ್ ಮೇಡ್ ಯು ಟು ರಿಜಿಸ್ಟರ್ ದಿ ಕೇಸ್ ವಿತೌಟ್ ದಿ ಕಂಪ್ಲೇಂಟ್? ಅದಕ್ಕೆ ಐ ಮೇಡ್ ಅನ್ ಅಬ್ಸರ್ವೇಷನ್.
I know.
It is an infighting between the officers in the department.
I know, my lords. I am not debating on merits for my lords.
That is the reason I observed in the order itself that it appears to be infighting between the very same department ಅಂತ.
My lords, the anomaly.
Previous round ಅಲ್ಲಿ ವಾರಗಟ್ಟಲೆ ನಡೀತು ಸ್ವಾಮಿ. Previous round ಅಲ್ಲಿ ವಾರಗಟ್ಟಲೆ ನಡೀತಿದೆ ಕೇಸು.
Allah, my respectful submission is that the crux of the anomaly of the whole mischief is registering under 384. Demand and acceptance ಯಾರು extortion ಅಂತಾರ.
ಅಲ್ಲ ಸರಿ, ಬೇಸಿಕ್ ನಿಮ್ಗ್ರಿ ನೀವು ಒಂದ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ there must be a complaint ಅಲ್ವಾ?
No, my lords.
Why register the case without any complaint on
with the deepest respect
representation to the court?
My lords, with the deepest respect, ಎಲ್ಲದರಲ್ಲಿನೂ ಕಂಪ್ಲೇಂಟ್ ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. Sometimes suo moto ಮಾಡಬಹುದು.
ನೋಡ್ರಿ, suo moto ಯಾವಾಗ ಬರುತ್ತೆ ಅಂದ್ರೆ ಫಸ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ಕಲೆಕ್ಟ್ ದಿ ಸೋರ್ಸ್ ರಿಪೋರ್ಟ್. ಅಂಡರ್ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಸೋರ್ಸ್ ರಿಪೋರ್ಟ್ ತರಿಸ್ಕೋಬೇಕು. ಅವಾಗ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಬೇಕಾಗಿಲ್ಲ. ಸೋರ್ಸ್ ರಿಪೋರ್ಟ್ ಮೇಲೆ ನಿಮ್ ಸೋರ್ಸ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಇವನು ಮಾಡಿದಾನೆ ಅಂತಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಇದು ಹಂಗಲ್ಲ. ಇದು ಇಲ್ಲಿ ಆಕ್ಚುಲಿ ಟ್ರಾಪು ಇಲ್ಲ. ಇಲ್ಲಿ ಟ್ರಾಪು ಇಲ್ಲ, ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಆಫ್ ಕೇಸು ಇಲ್ಲ. ಹೌ ಕ್ಯಾನ್ ಯು ಇನ್ವೋಕ್ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಕೇಸ್?
My lords, there is demand and acceptance.
Here there is no trap. ಕಂಪ್ಲೇಂಟ್ ಅವನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡಲ್ಲ. ಇವ್ನ್ ಯಾರೋ ಒಂದ್ ಮಿಡ್ಲಮನ್ ಹತ್ರ ಹೋಗ್ತಾನೆ
annexure R1
ಅಂತ ಅವನು ಹೇಳ್ತಾನೆ, ಇನ್ನೊಬ್ಬ ಯಾರೋ ಭೂಷಣ್ ಹತ್ರ ಹೋಗು ಅಂತಾನೆ.
ಅಲ್ಲ annexure R1 ಅಲ್ಲಿ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಅಂತ
On
ಇದೆ.
the earlier occasion,
ಇವ್ರು
your lordship was also pleased to suggest the other side. ನಾವು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಪಿಯರ್ ಆಗೋರು ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ, ನೀವು adversarial ತರ ಮಾಡಕ್ ಹೋಗ್ಬಿಡಿ ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ. ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ, ಕೋರ್ಟ್ ವಿಲ್ ಡಿಸೈಡ್.
ಅವ್ರು ಏನ್ ಹೇಳಿದಾರೆ
ಅಲ್ಲ ನನ್ಗೂ ತಾವು ಹೇಳಿದಿರಿ, ನೋಡಿ your lordship has advised me also, not I have said.
ನಾಳೆ ಇದನ್ನ ಹೇಳಿಲ್ಲ ಅಂತ ನನ್ ಮೇಲೆ ಬರಬಾರ್ದು ಅಂತ ನಾನೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನನಗೇನು ಹೇಳ್ಬೇಕಂತ ಇಲ್ಲ. I am here to assist this honorable court with the best of my abilities and I am doing that. ನನಗೇನು ಇದನ್ನ ಹೇಳ್ಬೇಕು ಅದನ್ನೇ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಹೇಳ್ಬಾರ್ದು ಅದೇನು ಇಲ್ಲ. ಏನಿದೆ ಎಲ್ಲಾನು ಹೇಳ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸೇ ತಂದು ಕೊಡ್ತೀನಿ. ಐ ಹ್ಯಾವ್ ನಥಿಂಗ್ ಹಿಯರ್. annexure R1 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕಾಪಿ ಇದೆ. ನಾನು ಇವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾವಾಗ ಅದು
ಕಂಪ್ಲೇಂಟ್ 5-1 ಅಲ್ಲಿ
ಅರೆ ಯಾವ
2020
ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಬಂತು?
1/6/2020
ಪಾಸ್ ಆದ್ಮೇಲೆ
ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡುವಾಗ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ರಿ. ಯು ಹ್ಯಾವ್ ಗಿವನ್ ರೆಕ್ವಿಸಿಷನ್ ಟು ದಿ ಜಡ್ಜ್. ನಿವೇದನೆ ಅಂತ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೋಡಿ.
ಹೌದೌದು.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ಗೆ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ಗೆ, ವಿತೌಟ್ ದಿ ಕಂಪ್ಲೇಂಟ್. ದಟ್ಸ್ ವಾಟ್ ಐ ಅಬ್ಸರ್ವ್ಡ್ ಇನ್ ದಿ ಆರ್ಡರ್. ಯಾರನ್ನೋ ಒಬ್ಬನ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡಕ್ಕಾಗಲ್ಲ ಹಂಗೆ.
ಅಲ್ಲ FIR ಆದ್ಮೇಲೆ ಒಂದು ಫಾರ್ಮಲ್ ಕಂಪ್ಲೇಂಟ್ ತರ ತಗೊಂಡಿದ್ದಾರೆ.
FIR ಆದ್ಮೇಲೆ ಹಂಗೆ ಫಾರ್ಮಲ್ ಕಂಪ್ಲೇಂಟ್ ತಗೊಳಕ್ಕಾಗುತ್ತೆ? ಅದ್ಯಾವ ನೋನ್ ಟು ಲಾ ಅದು.
That fortifies your lordship's observation that
Even
they did
otherwise,
fight.
no, my lord, sir.
That fortifies your
It
lordship's
goes
observation.
back to the germane question is, in the absence of complaint, can there be an FIR? Not only in PC offenses. Would that vary in terms of different offenses? The law would be different if the contentions of the learned counsel for the petition is to be
ಈಗ
accepted.
sometimes if judicial notice is taken by the court,
Please.
ಅವಾಗ ಆಗ್ತದೆ, ಕಂಪ್ಲೇಂಟೇ ಬೇಕಾಗಿಲ್ಲ.
ಹೌದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಕ್ಚುಲಿ ನಾನೇ ಒಂದು ನನ್ನ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ಯಾರೋ ದುಡ್ಡು ಕೇಳ್ತಾವ್ರೆ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ ಯಾರೋ ಬಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಟ್ಕೊಂಡು ಹೇಳಿದ್ರು. ಅಕ್ಯೂಸ್ ತಾಯಿ ಬಂದು, ಐ ಟುಕ್ ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್.
Yes.
ಐ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗಿವ್ ಎ ಕಂಪ್ಲೇಂಟ್ ಅಂಡ್ ರಿಜಿಸ್ಟರ್ ದಿ ಕೇಸ್ ಅಂತ. ಏನ್ ಮಾಡೋದು ಈಗ? ಲಾಯರ್ 1.5 ತಿಂಗಳಾಯ್ತು ಕದ್ದೋಡಾಗ್ಬಿಟ್ಟವ್ರೆ, ಇಬ್ರು ಸಿಕ್ಕಾಕೊಂಡವ್ರೆ, ಇಬ್ರು ಜೈಲಲ್ಲಿ ಅವ್ರೆ. ಲಾಯರ್ ಕದ್ದೋಡಾಗಿ ಊರು ಎಲ್ಲ ಸುತ್ತವ್ರೆ, ಆಫೀಸ್ ಮುಚ್ಕೊಂಡು ಎಲ್ಲ ಹೊರಗಡೆ ಹೋಗವ್ರೆ. ಮೊನ್ನೆ ಮೈಸೂರಲ್ಲಿ ಇದಾರೆ ಅಂತ ಹುಡ್ಕಾಕ್ ಹೋದ್ರೆ ಅವಳು ಸಿಕ್ಕಿಲ್ಲ. ಅವಮ್ಮ ಅವಳ ಅಣ್ಣನ ತಮ್ಮನ ಯಾರೋ ಡ್ರೈವರ್, ಅವ್ನ್ ಸಿಕ್ಕಿದ್ದಾನೆ, ಅವ್ನ ಅರೆಸ್ಟ್ ಮಾಡೋರು. ಈಗ 3 ಜನ ಅರೆಸ್ಟ್ ಮಾಡೋರು. ಲಾಯರ್ ಎಲ್ಲೋ ನಾಪತ್ತೆ. ಈಗ ಏನ್ ಮಾಡೋದು? ಕುಂಭಮೇಳಕ್ಕೆ ಕಳ್ಸಿರ್ಬೇಕೇನ?
ಅಲ್ಲ ಅವರು ಒಂದು ಅಕ್ಯೂಸ್ಡ್ ಇದ್ದಾರೆ.
ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್
ಇವರೆಲ್ಲ ಅಕ್ಯೂಸ್ಡ್ ಇರೋರು.
ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಈಗ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಳಕ್ 3 ಇದೆ 190 ನಲ್ಲಿ. ABC, ಒಂದು ಕಂಪ್ಲೇಂಟ್, ಒಂದು ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್, ಇನ್ನೊಂದು ಅದರ್ ದೆನ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಬೈ ಟೇಕಿಂಗ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಟೇಕ್ ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್ ಆಲ್ಸೋ. ದಟ್ ಐ ಡಿಡ್ in my when the accused mother came and cried before the court. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತ್ರ ನೀವು ವಿತೌಟ್ ಕಂಪ್ಲೇಂಟ್ you can register the case.
Even if my lords were to give a finding based upon the strength of my lord's earlier finding, I would be but constrained to challenge it because there is already a pending order. That is why
ಅಗೇನ್ ನೀವು ಆಲ್ರೆಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದ್ರಿಂದ ಇಲ್ಲೇನ್ ಆರ್ಡರ್ ನಿಮ್ ಪರವಾಗುತ್ತೋ ಅವ್ರ ಪರವಾಗುತ್ತೋ, ದಟ್ ಅಗೇನ್ ವಿ ಹ್ಯಾವ್ ಎನ್ ಅಡ್ವರ್ಸರಿಯಲ್ ಸಿಸ್ಟಮ್ ಟು ಅಪ್ರೋಚ್ ದಿ ಹೈಯರ್ ಕೋರ್ಟ್. ದಟ್ಸ್ ಆಲ್. ನೋಡಿ ಏನ್ ಬೇಗ ಈಗ ಈಚ್ ಕೇಸ್ ವೈಸ್ ಹೇಳಿದ್ರೆ ನನ್ಗೆ ಬರ್ಕೊಳ್ತೀನಿ. ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಮೆರಿಟ್ಸ್. ದಟ್ಸ್ ಆಲ್. ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸ್ಟೇ ತಗೊಂಡ್ರೆ ತಗೊಳ್ಳಿ, ನಮ್ದೇನಿಲ್ಲ.
ಒಂದ್ 2 ವಾರ ಟೈಮ್ ಕೊಡಿ. ನಾನು ಅಲ್ಲಿ ಸುಪ್ರೀಂ
ಆಲ್ರೆಡಿ 22 ಇಂದಲೂ ಇದೆ ಅಲ್ರಿ.
ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರೆ ನನಗೊಂದು ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ, ಅಷ್ಟೇ. ನಾನು ಅವ್ರ ಟೈಮ್ ಯಾವಾಗ್ಲಾರ ಮಾಡ್ಲಿ, ನನಗೆ ಅಲ್ಲಿವರೆಗೂ ಎಂಟ್ರಿ ಮಾಡೋ ಪ್ರೊಟೆಕ್ಷನ್ ಇರಲಿ. ಅವ್ರು ಅಲ್ಲೂ ಟೈಮ್ ಕೇಳಿ, ಇಲ್ಲೂ ಟೈಮ್ ಕೇಳಿ, ಆಮೇಲೆ ಇಲ್ಲಿ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡು ಮಾಡೋದ್ ಬೇಡ. ಅಲ್ಲ, he must be fair. No, he must be fair to the court. My only request is he must be fair to the court. He must be fair to the court. ಏನು 2 ಕಡೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳೋದು ಫೇರಾ?
He has not got an interim protection till today. Why does he need the interim protection?
ಯಾಕೆ ಅಂದ್ರೆ ನೀವು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ 4 ವರ್ಷದಿಂದ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದಾರೆ.
Then why, when the charge sheet is ready, then why you have not sought permission, sanction?
It is what, my lords.
ಯಾವಾಗ? ಈಗ ಮೊನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ಮೇಲೆ
ಮೊದ್ಲೇ ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ.
ಅಲ್ಲ, ಕೇಳಿದಾರೆ ಆಲ್ರೆಡಿ.
ಅವ್ರು ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ.
2 ತಿಂಗಳ ಮೇಲಾಗಿರ್ಬೋದು.
ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್ ಲೆಟ್ ಹಿಮ್ ಆರ್ಗ್ಯೂ.
ಲಾಸ್ಟ್ ವೀಕ್ ಏನೋ ಬಂದಿತ್ತಲ್ಲ
3-2 ಅದನ್ನೇ ಓದ್ದೆ ನಾನು. 3/2/25
ಡೇಟ್ ಯಾವತ್ತು ಹೋಗಿದೆ?
ಅದು ಅರ್ಜೆಂಟ್ ಅಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಬೈ 4 weeks.
4 weeks.
ಅವರೇ 4 ವಾರಕ್ಕೆ ಕೇಳಿದಾರೆ.
4 weeks ಆದ್ರೆ ನೀವು ಇಮಿಡಿಯೇಟ್ 2 ವಾರದಲ್ಲೂ ಮೂವ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಗುತ್ತಾ?
ಆಗಲ್ಲ, ಅವರೇ ಟೈಮ್ ಕೇಳಿದಾರೆ.
It is not possible also because mentioning is no more permissible in Supreme.
ಅದೇ ಈಗ ಆಲ್ರೆಡಿ ಯು ಟುಕ್ ಟೈಮ್ ಫಾರ್ ಪೀರಿಯಡ್ ಆಫ್ 4 weeks.
ಅಲ್ಲೊಂದು 15 ಸಲ ಬಂದಿದೆ. ಮೊನ್ನೆದಷ್ಟೇ ಹೇಳ್ತಾ ಇದೀನಿ, 15 ಸಲನೂ ಅವರೇ ಟೈಮ್ ಕೇಳಿದಾರೆ.
I am only saying that this would be a waste of time, because my lords, the whole thing will, my lords would invariably base the order of merits here on the earlier order. Why waste the time?
ಒಂದೇನಂದ್ರೆ ಈಗ ಈ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಮಾಡಿ ಮತ್ತೆ ಅಲ್ಲಿ ಹೋಗಿ ಏನೋ ರಿವರ್ಸ್ ಆದ್ರೆ ಎಲ್ಲಾನು ವಾಪಸ್ ಬರುತ್ತೆ, ಎಲ್ಲ ಬರುತ್ತೆ. ಅದಕ್ಕೆ
Therefore, not my humble request is, can you protect my interest? Still may not, he moves SLP and may not gets an order.
ಪ್ರೊಟೆಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ, ಇಷ್ಟು ಜನ ಚೆನ್ನಾಗಿದ್ರು, ಇವತ್ತೇ
ಅಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗಲಿ.
anyhow they are not filing any charge sheet.
ಅಲ್ಲ ಅದು ಅವ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅನ್ನ ಕೊಟ್ಟು ಬರ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ, ಏನಾದ್ರು
ಇದೆಯಂತಲ್ಲ.
ಅಲ್ಲ ಅದು ಕೊಟ್ಮೇಲೆ ಬಂದ್ ಆಗುತ್ತೆ ಅಷ್ಟರೊಳಗಡೆ.
Heard the matter in part of the counsel appearing for the respondent, and counsel for the respondent would submit that they have sought for sanction and not yet obtained this action, and also the similar order has been challenged before the apex court, and the same is also pending for consideration, and counsel appearing for the petitioner also brought to notice of this court that the matter was listed on 3/2/2025. At the instance of the respondent only, matter was adjourned for 4 weeks, and hence in view of the submission of both the counsel and also not yet sanction is granted in favor of the petitioners also, it is adjourned by 4 weeks. And list this matter ಮಾರ್ಚ್ ಅಲ್ಲಿ ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡಿ, 3ನೇ ತಾರೀಕು ಆದ್ಮೇಲೆ.
ಅಷ್ಟು ಒಳಗಡೆ ಅವ್ರು ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡು ಹಾಕ್ಬಾರ್ದು ಅಂತ ಒಂದು ಹೇಳಿ. ಅಲ್ಲ ಅದೊಂದು ಹೇಳಿ ಅಂತ ಅವ್ರು ಹಾಕೊಂಡು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಒಂದು ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಅಂತ ಹೇಳ್ಬಾರ್ದು ಅಂತ ಅಲ್ಲಿ ಟೈಮ್ ಕೇಳೋದು. ಅಲ್ಲ ಹೇಳಿ ಅವರು ಏನಂತ ಏನಾರು ಒಂದು ಹೇಳಿ ಸ್ವಾಮಿ. ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್,
ಸರ್ಕಾರ ಇಷ್ಟು ಬೇಗ ಸ್ಯಾಂಕ್ಷನ್ ಕೊಡುತ್ತೆ
ಅಲ್ಲ ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್, ಅಲ್ಲ ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್ ದಿಸ್, ಅಲ್ಲ not I am not seeking time, but I am not seeking time, he is seeking time, saying that SLP is pending. My only request is kindly protect my interest till then.
ಕೊಡಿ ಮೇಡಮ್, ಫಸ್ಟ್ 10th ಕೊಟ್ಬಿಡಿ, 10/3 list this matter on 10/3.
Not to precipitate ಅಂತ ಹೇಳಿ, I'm not otherwise, not if they may not file the charge sheet, not to precipitate further. ಈಗ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ,
ಅವ್ರು ಹೇಳಿದಾರೆ ಈಗ not yet received the sanction.
ನಾನು ಅಷ್ಟೇ ಹೇಳಿದ್ದೀನಿ, ನಾನು ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಬಂದ್ ಪಾಟೀಲ್ ರಾಮಲ್.
ನಾನು ಏನು ಹೇಳಿಲ್ಲ, ನಾನು ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿಲ್ಲ.
ನೋಡಿ ನಾನು ಅದು ಇವತ್ತೇ ಆಗ್ಲಿ ಹೇಳ್ತಾನೆ ಹಾಕ್ತೀನಿ ಅಂತಾನು ಹೇಳಿಲ್ಲ ಅಂತ. Therefore, my only request is not
this matter on 10/3.
ನೋಡಿ ask me kindly protect my interest till then.
ಏನ್ ಮಾಡ್ತಿರೋ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಸ್ಟೇನಾರು ತಗೋಬನ್ನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ I will pass orders on merit.
Please.
Not till then, may not, if they file charge sheet not.
ಎಲ್ಲರೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹೆಂಗ್ರಿ ಹಾಕ್ತಾರೆ ಈಗ ವಿತೌಟ್ ಸ್ಯಾಂಕ್ಷನ್?
ಅಲ್ಲ ಅದನ್ನೇ ಅದನ್ನ ಅಲ್ಲ ಅಷ್ಟೊಳಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಬಂದ್ರೆ ಅಂತ
ಸರ್ಕಾರ PC ಆಕ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್ ಕೊಡಕ್ಕೆ
ಅಲ್ಲ ಓಡಾಡಿ ತರ್ತಾರ ಆಮೇಲೆ ಅಂತ
ಯಾಕೆ ಕೂತಿರ್ತಾರೆ ಅಂತ ಅನ್ಕೊಂಡಿದೀರಾ?
Not my only request is not let. Not my only request is not.
ಸರ್ಕಾರ ಏನ್ರಿ ಬೇಗ ಕೊಡ್ತಾರೇನ್ರಿ? ಈಗ ನಾನೇ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 2020ದು
ಅಲ್ಲ ಒಂದೊಂದು ಕೇಸಲ್ಲಿ ಒಂದೊಂದು ಮಾಡ್ತಾರೆ.
ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿದು
not my only request
ಆಗಿರ್ಲಿಲ್ಲ, ನಿನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ನಿನ್ನೆ ಸ್ಯಾಂಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ.
ಅಲ್ಲ ಇದು ಹಂಗೆ ಮಾಡೋ ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ,
ಬಂದವ್ರೆ
ಇದು ಹಂಗೆ ಮಾಡೋ ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ. But my only request is,
ಅದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅದು ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ,
only request is
IAS
ಆಫೀಸರ್ ಆಗಿ
let it not become not infructuous. ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ ತಾ ಮಾಡೋದು ಇದೆ, ಅದೇನು ಸ್ಟೇ ಇಲ್ಲ. My only request is not
even if they files the charge sheet also, you have a right to challenge the charge sheet also ಅಲ್ವಾ? ಹೆಂಗಿರು ಈಗ ಇದುವರೆಗೂ ಇಲ್ಲ ನಿಮ್ಗೆ ಸ್ಟೇ.
ಅಲ್ಲ ಅವರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ,
ಸ್ಟೇ ಕೊಡೋದ್ರಿಂದ ಪರ್ಪಸ್ ಏನ್ ಸರ್ವ್ ಆಗುತ್ತೆ ಹೇಳಿ? ಅವ್ರು ನಾವು ದೇ ಕೆನಾಟ್ ಫೈಲ್ ಎನಿ ಚಾರ್ಜ್ ಶೀಟ್ ವಿತೌಟ್ ದಿ ಸ್ಯಾಂಕ್ಷನ್.
ಅಲ್ಲ ಅದನ್ನೇ ಒಂದ್ಸಲ ಹೇಳಿ ಸ್ವಾಮಿ ಅಂತ ಅಷ್ಟೇ, ಬಂದು ನಾನೇನು ಕೇಳ್ತಾ ಇಲ್ಲ, ಈಗ ಅಷ್ಟೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದು.
ಡೈರೆಕ್ಟ್ಲಿ ನಾನು ಅದನ್ನೇ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಎಟ್ ಟು ಗೆಟ್ ದಿ ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ಡರ್.
ಅಲ್ಲ ತಾವು ಎಟ್ಟು ಗೆಟ್ ಬರ್ದಿದ್ದೀರಿ, ನನಗೆ ಬಂದ್ಬಿಡ್ತು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೆ ಅಂತ ಹೇಳೋದು ಬೇಡ ಅಂತ ಅಷ್ಟೇ. ಆಮೇಲೆ
ಇಲ್ಲ ನಾನು
ನೋಡಿ ಎಫರ್ಟ್ಸ್
ಆಯ್ತು. ನೀವು 10/3 ನಿಮ್ಗೆ 3ನೇ ತಾರೀಕಿಗೆ ನೆಕ್ಸ್ಟ್ ಮಂತ್ಗೆ 4 weeks ಆಗುತ್ತೆ, ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಏನಾದ್ರು ಮಾಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್.
ಮೋಹನ್ ಪೀಸ್
ಇದು ಪಾಟರ್ಡ್.
Order 9, Rule 13. The petition filed under Order 9, Rule 13 was dismissed by the
ಅಯ್ಯ ಹಾಕಿದಾರೆ. ಏನ್
IA filed under Order 41, Rule 27.
ಇದನ್ನ ಅಲೋ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ ಅವರು. ನೋಡಿ, Order the appellant counsel and also the counsel appearing to the respondent, and IA is filed under Order 41, Rule 27 ಅಲ್ಲ? This will be considered along with main appeal ಅಷ್ಟೇ. ಈಗಲೇನು ಅಲೋ ಮಾಡಕ್ ಬರಲ್ಲ. ಅಪೀಲ್ ಅಲೋ ಮಾಡುವಾಗ ಮಾತ್ರ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು ಈ ಗ್ರೌಂಡ್ ಏನ್ ಹಾಕಿರ್ತೀರಿ ಅದನ್ನ. ಅಂದ್ರೆ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನಾವು ಫಸ್ಟ್ ಟೈಮ್ ಯು ಆರ್ ಪ್ಲೇಸಿಂಗ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಹೌದಾ? ಆಯ್ತು. ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಓರಲಿ ಅಬ್ಜೆಕ್ಟ್ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಹಾಕೋಬಿಡಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. ಈಗ ಹೇಳಿ ಪಾರ್ಟ್ ಇದೆ ಏನ್ ಫರ್ದರ್? ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟ್ಸ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್? ಇಲ್ಲ, ಫ್ರೆಶ್ ಆಗಿ ಹೇಳಿ. ರೀಕಲೆಕ್ಟ್ ದಿ ಮೆಮೊರಿ. Court will recollect the memory. ಏನು against the order?
A suit for specific performance is filed
ಹಾ
by the respondent herein.
ಹಾ
The suit is declared ex parte
ಹ್ಮ್
and the defendant filed the
miscellaneous
miscellaneous petition order 9 rule 13 and that is also dismissed.
ಹಾ ಹ್ಮ್
The appellant is the defendant before this honorable court.
ಹ್ಮ್
No summons was served, duly served in the original suit.
ಹ್ಮ್ ಸಮಸ್ಯೆ ಸರ್ವಾಗಿಲ್ವಾ?
ಹೌದು. The
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಬರ್ದಿದ್ದಾರೆ ಅರ್ಲಿಯರು?
postal shara not claimed ಅಂತ unserved not claimed ಅಂತ ಬಂದಿರೋದ್ರಿಂದ
ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಅಂತ
not
ಬಂದಿದೆಯಾ?
claimed ಅಂತಂದ್ರೆ refused ಅಂತ ಬಂದಿರೋದ್ರಿಂದ ಹಾಗಾಗಿ deemed to be served ಅಂತ ಹೇಳ್ಬೋದು.
ಹ್ಮ್
We examined the postman as well as the bailiff.
ಇದರಲ್ಲಿ miscellaneous proceedings ಅಲ್ಲಿ. ಹಾ
Postman ಮತ್ತೆ bailiff cross examination ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. When they went to the house of the defendants, it was locked.
ಹಾ
No one is there ಅಂತ ಹೇಳಿ.
ಲಾಕ್ಡ್
It was locked ಅಂತ ಹೇಳಿ.
ಹಾ ಕೊಡಿ ಎವಿಡೆನ್ಸ್
ಮತ್ತೆ bailiff ಹೇಳಿದ್ದಾರೆ
miscellaneous
ಮನೆ ಒಳಗಡೆ ಯಾರೋ ಮಕ್ಕಳು ಮಾತಾಡ್ತಾ ಇರೋದು ಕೇಳಿಸ್ತು ಅಂತ ಹೇಳಿ.
ಲಾಕ್ ಆಗಿರೋ ಮಕ್ಳಾಗಿರಿ ಮಾತಾಡ್ತಾರ?
ಕ್ಲೈಮ್ಡ್ ಅಂತ ಹೇಳಿ ಬರೋದಕ್ಕೆ ಚಾನ್ಸ್ ಇಲ್ಲ.
ಅಲ್ಲ ಮನೆ ಲಾಕ್ ಆಗಿರೋ ಮಕ್ಳ ಹೆಂಗ್ ಮಾತಾಡ್ತಾರೆ ಅಂದೆ?
ಅಲ್ಲ ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ಹೇಳಿರೋದು ಮನೆಗೆ ಹೋದಾಗ ಯಾರು ಇರ್ಲಿಲ್ಲ.
ಪೋಸ್ಟ್ ಮ್ಯಾನೇ ಹೇಳಿರೋದು ಮತ್ತೆ ಬೇಲೀಫ್ ಹೇಳದ?
ಬೇಲೀಫ್ ಆಮೇಲೆ ಇನ್ನೊಂದು
ಬೇಲೀಫ್ ಹೋಗಿದ್ದ ಪೋಸ್ಟ್ ಮ್ಯಾನ್
ಹೋಗಿದ್ದಾರೆ.
ಎರಡು
ಹಾ ಬೇಲೀಫ್ ಹೋದಾಗ್ಲೂ ಅದೇ.
ಬೇಲೀಫ್ ವಾಟ್ ಇಸ್ ದಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್? ಬೇಲೀಫ್
ಅಷ್ಟೇ ಅವ್ರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು, ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತನಾ?
ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅವಾಗ ಮನೆಗೆ ಹೋದಾಗ ಅಂತ.
ಎಲ್ಲಿದೆ ಬೇಲೀಫ್ ಎವಿಡೆನ್ಸ್ ಓದ್ಬಿಡಿ ಸ್ವಲ್ಪ.
CW2.
Two-na?
CW3, CW1 is the bailiff.
ಕೋರ್ಟ್ ವಿಟ್ನೆಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಬೇಲೀಫ್. ಹಾ ಇದು ನಾನು ಸುಮಾರು 31 ವರ್ಷಗಳಿಂದ ಹಾಸನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬೇಲೀಫ್ ಆಗಿ ಕಾರ್ಯ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಇದೇನ್ ಬಹಳ ಇಯರ್ ಮಾಡಿದ್ವಲ್ವ ಈ ಮ್ಯಾಟರ್ನ?
ಹೌದು ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್
ನಾನೇ ಹೋಗಿರುತ್ತೇನೆ. ಸಾಕ್ಷಿದಾರರು ನಿಶಾನೆ ಪಿ 5 ಮತ್ತು 6 ಗುರುತಿಸಿ ಅದರ ಹಿಂಬದಿ ಪುಟದಲ್ಲಿ ತಮ್ಮ ಸಹಿಯನ್ನು ನೋಡಿ ಗುರುತಿಸಿದ್ದು ಅದು ನಿಶಾನೆ ಪಿ 5 ಎಂದು ಆಯ್ತು. ಯಾವ ರೀತಿಯಲ್ಲಿ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡಬೇಕೆಂಬ ನಿಯಮ ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಸಮನ್ಸ್ ಅನ್ನು ಜಾರಿ ಮಾಡುವ ಕಾಲಕ್ಕೆ ಯಾರನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೀರಾ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ವಿಳಾಸ ಸರಿಯಾಗಿದ್ದಲ್ಲಿ ನಾವೇ ಹೋಗಿ ಜಾರಿ ಮಾಡುತ್ತೇವೆ. ವಿಳಾಸ ಸರಿಯಾಗಿರದೇ ಇದ್ದಲ್ಲಿ ವಾದಿಯನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅವರ ಸಹಾಯದಿಂದ ವಿಳಾಸವನ್ನು ಪತ್ತೆ ಮಾಡಿ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡುತ್ತೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸಾಮಾನ್ಯವಾಗಿ ವಾದಿಯ ಸಹಾಯವನ್ನು ಪಡೆದಾಗ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಸಮನ್ಸ್ ಮೇಲೆ ನಾವು ವಾದಿಯ ಸಹಿ ಪಡೆಯುವುದಿಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ಪಕ್ಷಗಾರನು ಸಮನ್ಸ್ ಅನ್ನು ತಿರಸ್ಕರಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ತಿರಸ್ಕರಿಸುತ್ತಾರೆ ಎಂದು ಹಿಂಬ ಬರೆಯುತ್ತೇವೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಅಕ್ಕಪಕ್ಕದವರು ಸಹಿ ಪಡೆದಿರುತ್ತಾರೆ ಎನ್ನುವ ಪ್ರತಿ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಹಿ ಮಾಡಲು ಯಾರು ಮುಂದೆ ಬರುವುದಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ತಿರಸ್ಕಾರದ ಸಂದರ್ಭದಲ್ಲಿ ಸಮನ್ಸ್ ಮೇಲೆ ವಾದಿಯ ಸಹಿಯನ್ನು ನಾವು ಪಡೆಯುವುದಿಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ಸಮನ್ಸ್ ಜೊತೆ ವಾದ ಪತ್ರದ ಪ್ರತಿ ಇದ್ದಲ್ಲಿ ಅದನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗುತ್ತೇವೆ. ಸಮನ್ಸ್ ಜೊತೆಗೆ ವಾದ ಪತ್ರವನ್ನು ಸಹ ನೀಡಬೇಕು ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ ಪಿ ಹಿಂಭಾಗದಲ್ಲಿ 3 ಬಾರಿ ಎಂದು ನಮೂದಿಸಿದ್ದು ಯಾವಾಗ ಹಾಗೂ ಯಾವ ಸಮಯದಲ್ಲಿ ಹೋಗಿರುತ್ತೇನೋ ಅದನ್ನು ನಮೂದಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಮುಂದುವರಿದು ಪ್ರತಿವಾದಿಯ ಸಮನ್ಸ್ ಅನ್ನು ಸ್ವೀಕರಿಸಿದ ಅಥವಾ ತಿರಸ್ಕರಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತ್ರ ಅದನ್ನು ನಮೂದಿಸುತ್ತೇವೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ 6ರ ಹಿಂಭಾಗದಲ್ಲಿ ಚೆಕ್ ಬಂದಿಯನ್ನು ನಮೂದಿಸಿದ್ದು ಅದರಲ್ಲಿ ಯಾರು ಇರುತ್ತಾರೆ ಎಂದು ಅವರ ಹೆಸರನ್ನು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ವಾದಪತ್ರದ ಪ್ರತಿ ಅಥವಾ ಮಧ್ಯಂತರ ಅರ್ಜಿಯ ಪ್ರತಿಯ ಬಗ್ಗೆ ಸರಾದಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ತಿರಸ್ಕಾರ ಮಾಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಮನೆಯ ಮುಂಬಾಗಿಲು ಅಥವಾ ಮನೆಯ ಬಳಿ ಎದ್ದು ಕಾಣುವ ಸ್ಥಳದಲ್ಲಿ ನಾವು ಸಮನ್ಸ್ ಅನ್ನು ಅಂಟಿಸುವುದಿಲ್ಲ ಎಂದರೆ ನ್ಯಾಯಾಲಯದ ಆದೇಶವಿದ್ದಲ್ಲಿ ಮಾತ್ರ ಆ ರೀತಿಯಾಗಿ ಮಾಡುತ್ತೇವೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ ಸಮನ್ಸ್ ಅನ್ನು ತಿರಸ್ಕರಿಸಿದ ಸಮನ್ಸ್ ಹಾಗೂ ವಾದಪತ್ರದ ಪ್ರತಿಯನ್ನು ಮನೆಯ ಮುಂಬಾಗಿಲನ್ನು ಅಂಟಿಸಬೇಕು ಎನ್ನುವ ನಿಯಮ ಇರುತ್ತದೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಿಂದ ನಾವು ನಡೆದುಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಈ ಪ್ರಕರಣದ ಸರಿ ದಾವೆಯಲ್ಲಿ ನಾವು ಯಾವುದೇ ಮಾಡಿರುವುದಿಲ್ಲ, ಕಾರಣ ಅಫಿಕ್ಷರ್ ಮಾಡಿರುವುದಿಲ್ಲ, ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಇರುವುದಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನ ವಿಭಾಗದಲ್ಲಿ ವಾದಿಯ ಸಹಿಯನ್ನು ಪಡೆದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾವು ಪ್ರತಿವಾದಿಯ ಮನೆಗೆ ಹೋದಾಗ 3:40 ಆಗಿತ್ತು ಎಂದು ನಮೂದಿಸಿದ್ದ ಆ ಸಮಯದಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಮನೆಯಲ್ಲಿ ಇರದೆ ವಾದಿಯ ಜೊತೆ ಶರೀಕಾಗಿ ಆ ರೀತಿ ಹಿಂದೆ ಇವರು ಬರೆದಿರುತ್ತೆ ಸರಿ. ಅಕ್ಕಪಕ್ಕ ಯಾರನ್ನು ಬರೆದಿರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದೆ ಅಕ್ಕಪಕ್ಕ ಸಂಘರ್ಷ ಇದ್ದ ಕಾರಣ ಇವತ್ತು ಇದ್ದವರು ನಾಳೆ ಇರುವುದಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಮನೆಯ ಅಕ್ಕಪಕ್ಕದ ಮನೆಗಳು ಇದ್ದವು. ಪಕ್ಕದ ಅಡಿಯವರನ್ನು ನಾನು ವಿಚಾರಿಸಿರುತ್ತೇನೆ, ಅವರಾದರೆ ಅವರ ಹೆಸರನ್ನು ನಮೂದಿಸಿಲ್ಲ. ಮಧ್ಯಂತರ ಆದೇಶದ ಅರ್ಜಿಯ ಮೇಲೆ ಬರೆದಿದೆ ಎಂದರೆ ಸರಿ. ತಾವ ಸಮನ್ಸ್ ಬೇರೆ ಹಾಗೂ ಮಧ್ಯಂತರ ಆದೇಶದ ಅರ್ಜಿಯ ನೋಟಿಸೇ ಬೇರೆ ಎಂದರೆ ಸರಿ. ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ನಾವು ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡಲು ಹೋದಾಗ ತಿರಸ್ಕಾರ ಮಾಡಿದಾಗ ಚೆಕ್ ಬಂದಿಯನ್ನು ನಮೂದಿಸುತ್ತೇವೆ ಎಂದರೆ ಸರಿ. ಪ್ರತಿವಾದಿ ಪ್ರಮೋದಾ ದೇವಿಯನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಗುರುತಿಸಬಹುದಾ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ತುಂಬಾ ವರ್ಷಗಳಾಗಿದ್ದು ನೋಡಿದ್ದಲ್ಲಿ ಗುರುತಿಸುವ ಪ್ರಯತ್ನ ಮಾಡುತ್ತೇನೆ ನೋಡಿದ್ದಾರೆ. ನ್ಯಾಯಾಲಯದ ಸಮನ್ಸ್ ಅನ್ನು ಪ್ರತಿವಾದಿಗಳು ಪಡೆದುಕೊಳ್ಳದೇ ಇರುವ ಕಾರಣ ನಾನು ಕಾನೂನುಬದ್ಧವಾಗಿ ಹಿಂಪರ ಬರೆದಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ಇನ್ನೊಬ್ರು ಯಾರು?
ಇನ್ನೊಬ್ರು ಪೋಸ್ಟ್ ಮ್ಯಾನ್ CW.
ಅವನೇನ್ ಹೇಳ್ತಾನೆ?
ಅವರು ಪ್ಯಾರಾ 2 ಅವ್ರದ್ದು ಪ್ಯಾರಾ 2 ಆಫ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ವಿಳಾಸದಾರರ ಮನೆಯಲ್ಲಿ ಇಲ್ಲದ ಪಕ್ಷದಲ್ಲಿ ಹಾಗೂ ಸದರಿ ಮನೆಯಲ್ಲಿ ಬೇರೆಯವರು ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ನಾವು ಅಂಚೆ ಬಗ್ಗೆ ಮನೆಯವರಿಗೆ ಮೌಖಿಕವಾಗಿ ಸಲ್ಲಿಸುತ್ತೇವೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಂದರೆ ದಾವೆಯಲ್ಲಿ ನಾವು ಲಕೋಟೆ ಜಾರಿ ಮಾಡಲು ಹೋದಾಗ ಮನೆಯಲ್ಲಿ ಮಕ್ಕಳ ಶಬ್ದ ಮಾಡುತ್ತಿದ್ದು ನಾನು ಬಾಗಿಲು ಬಡಿದರೂ ಸಹ ಬಾಗಿಲನ್ನು ಯಾರು ತೆಗೆದ ಕಾರಣ ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅನ್ನು ಮನೆಯ ಬಾಗಿಲು ಇಟ್ಟಿರುತ್ತೇನೆ. ಮನೆಯೊಳಗೆ ಮಕ್ಕಳು ಶಬ್ದ ಮಾಡುತ್ತಿದ್ದು ಅವರು ಯಾವ ವಯಸ್ಸಿನಿರುತ್ತಾರೆ ಎನ್ನುವ ಬಗ್ಗೆ ನೀವು ಪರಿಶೀಲಿತರ ಪ್ರಶ್ನೆಗೆ ಇಲ್ಲ ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅನ್ನು ಮನೆಯ ಬಾಗಿಲು ಅಂಟಿಸಬಹುದಿಲ್ಲವೇ ಪ್ರಶ್ನೆಗೆ ಆ ರೀತಿ ಅಂಟಿಸಿದಲ್ಲಿ ಅದು ಹರಿದು ಹೋಗುತ್ತದೆ ಎಂದು ಸಾಕ್ಷಿಗಳು ಉತ್ತರಿಸುತ್ತಾರೆ. ನಾನು ಮೊದಲ ಬಾರಿಗೆ ಸದರಿ ವಿಳಿಸಿದ ಸೆರೆಮನೆಯಲ್ಲಿ ಒಬ್ಬ ಹೆಣ್ಣು ಮಗಳು ಇದ್ದು ಅಂಚೆ ಲಕೋಟೆಯ ಬಗ್ಗೆ ಅವರಿಗೆ ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿರುತ್ತೇನೆ. ಮರುದಿನವಾಗಿ ಇಂಟಿಮೇಷನ್ ಅನ್ನು ಇಟ್ಟು ಬಂದಿರುತ್ತೇನೆ. ಸದರಿ ವಿಚಾರವಾಗಿ ನೀಪಿ 1 ಅಂಚೆ ಲಕೋಟೆಯಲ್ಲಿ ನಮೂದಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸದರಿ ಹೆಣ್ಣು ಮಗಳು ಯಾರು ಏನು ಹಾಗೂ ಮದುವೆ ಸಂಬಂಧ ಇಲ್ಲವೋ ಅದನ್ನು ವಿಚಾರಿಸುವುದಿಲ್ಲ. ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅನ್ನು ಇಡುವ ಕಾಲಕ್ಕೆ ನಾವು ಮಹಜರ್ ಮಾಡಬೇಕು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅನ್ನು ಬೀಟ್ ನಂಬರ್ ಹಾಗೂ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ನಮೂದಿಸುತ್ತೇವೆ. ಸದರಿ ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಲಕೋಟೆ ಎಲ್ಲಿಂದ ಬಂದಿರುತ್ತದೆ ಎಂಬುದರ ಬಗ್ಗೆ ನಮೂದು ಇರುವುದಿಲ್ಲ. ನಾನು ಯಾವುದೇ ಇಂಟಿಮೇಷನ್ ಸ್ಲಿಪ್ ಅನ್ನು ಇಡದೆ ನಮ್ಮ ಅನುಕೂಲಕ್ಕೆ ಲಕೋಟೆಯ ಮೇಲೆ ಸಾರ ಬರೆದಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 26/2/2021 27 ನಂತರ 5 ದಿನಗಳ ಕಾಲ ಸದರಿ ಅಂಚೆ ಲಕೋಟೆಯನ್ನು ನಮ್ಮ ಕಚೇರಿಯಲ್ಲಿ ಇಟ್ಟಿದ್ದು ಆ ಅವಧಿಯಲ್ಲಿ ವಿಳಾಸದಾರರು ಸದರಿ ಅಂಚೆ ಲಕೋಟೆ ನೀಸಿ 1ರ ಪ್ರಕಾರ ದಿನಾಂಕ 5/3/21 ಸಂಚೆ ಲಕೋಟೆಯನ್ನು ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಎಂದು ಹಿಂಬರ ಹಾಕಿ ವಾಪಸ್ ಕಳಿಸುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ಮನೇಲಿ ಯಾರು ಇಲ್ಲ ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಹೇಳಿ ಬರೆದು ಹಾಕಿದ್ದಾರೆ. ಸದರಿ ಹಿಂಬರದ ಕೆಳಗೆ ಡೆಲಿವರಿ ಕ್ಲರ್ಕ್ನ ಸಹಿ ಇರುತ್ತದೆ. ನಮ್ಮ ಅಂಚೆ ನಮೂನೆಯ ಪ್ರಕಾರ ನೀಪಿ 1ರ ಹಿಂಬರದಂತೆ ಸದರಿ ಲಕೋಟೆ ಜಾರಿಯಾಗಿದೆ ಎಂದು
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ ಈಗ?
ಹೌದು. ಎಕ್ಸಿಬಿಟ್ P5 and P6 ಆರ್ ಮಾರ್ಕ್
ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ.
ಎಕ್ಸಿಬಿಟ್ P4 ಬದ್ರಿ ಪ್ರಸಾದ ಪಾರ್ಟಿ ಹೆಸರು ಪ್ರಮೋದಾ ಪ್ರಸಾದ್. ವಾದಿಯರ ಜೊತೆ ಸುಮಾರು 3 ಬಾರಿ ಹೋದಾಗ ಪ್ರತಿವಾದಿ ಊರಿನಲ್ಲಿ ಇಲ್ಲವೆಂದು ಮನೆಯವರಿಂದ ತಿಳಿದು ಬಂದಿದ್ದರಿಂದ ಜಾರಿಯಾಗದೆ ವಾಪಸ್ಸು ಮಾಡಿರುತ್ತೇನೆ. ತಿಳಿಸಿ ಸರಿಯಾದ ಸರಿ ಮಾಡಿ ಪ್ರತಿವಾದಿಯವರು ಈ ದಾವೆಯು ನಮಗೆ ಯಾವುದೇ ಸಂಬಂಧವಿಲ್ಲವೆಂದು ತಿಳಿಸಿ ನಾನು ಸಹಿಯನ್ನು ಮಾಡುವುದಿಲ್ಲ, ನಾನು ತೆಗೆದುಕೊಳ್ಳುವುದಿಲ್ಲವೆಂದು ತಿರಸ್ಕಾರ ಮಾಡಿ ನೀವೇನಾದರೂ ಬರೆದುಕೊಳ್ಳಿ ಎಂದು ತಿಳಿಸಿದ್ದರಿಂದ ನಾನು ಸ್ಥಳೀಯರು ತಿರಸ್ಕಾರ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ಸಹಿ ಮಾಡಿ ಉಳಿಯುವುದನ್ನು ಯಾರು ಸಹ ಸಹಕರಿಸದ ಕಾರಣ ಇದ್ದ ಸಂಗತಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿರುತ್ತೇನೆ. P6 ಪೋಸ್ಟ್ ಆಫೀಸ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಪೋಸ್ಟಲ್ ಎಲ್ಲಿದೆ?
ಎಕ್ಸಿಬಿಟ್ P6
ಎಷ್ಟು ಸರಿ ಹೋಗಿದನ್ರಿ ಮನೆ ಹತ್ರ?
ಒಂದೇ ಸಲ ಹೋಗಿರೋದವ್ರು 4 ಸಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಂಡಾರ್ಸ್ಮೆಂಟ್
And PW2 is a working woman. Now exhibit P3 you have produced exhibit P3 to show that she is working woman.
(28-1) ಪೋಸ್ಟಲ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ? ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀರಾ?
ಎಕ್ಸಿಬಿಟ್
ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿದೆ? ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಿರಿ? ಅವನಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆ ಇದೇನು? ಫಸ್ಟ್ ಒನ್ ಎಕ್ಸಿಬಿಟ್ P4
P4 exhibit P4 is not the signature of the appellant. ಬೇರೆ ಯಾರೋ ಸಿಗ್ನೇಚರ್.
ಯಾರ ಸಿಗ್ನೇಚರ್ ಬೇರೆ ಇದೆ?
ಹೌದು, ನಮ್ಮ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅದು.
ಪ್ರಮೋದಾ ಪ್ರಸಾದ್. ಅದ್ ವೈಫ್ ರೀ, ಇಬ್ರು ಇದಾರ ಡಿಪೆಂಡೆಂಟ್ಸ್.
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್.
RB ಅಂತೇನೋ ಇದೆಯಲ್ಲ, ಪ್ರಮೋದ ಪ್ರಸಾದ್. ಯಾರಿಗೋ ಜಾರಿ ಆಗಿದೆಯಲ್ರಿ?
ಇಲ್ಲ ನಮ್ಗೆ ನಮ್ದಲ್ಲ ಸಿಗ್ನೇಚರ್ ಅದು. ವಿ ಆರ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್ ಸಿಗ್ನೇಚರ್, ನಮ್ದು ಅಲ್ವೇ ಅಲ್ಲ.
ಹ್ಮ್ ಹ್ಮ್
Exhibit P7 postal.
ಆಯ್ತು, ನಿಮ್ ಪ್ರಕಾರ ನೋ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್, ನೋ ಸರ್ವಿಸ್ ಆಫ್ ಸಮನ್ಸ್.
In 2021, we filed the mispetition. The judgment passed in 2021. So immediately within limitation period, we filed the mispetition. Yeah, after appearance in the mispetition, they filed the execution petition in 2022.
ಅಲ್ಲ, ಡಿಗ್ರಿ ಆಗಿದೆ ಯಾವಾಗ? ಸ್ಪೆಸಿಫಿಕ್
2021. 2020 suit.
ಡಿಗ್ರಿ 2020 suit.
2020.
21 ಡಿಗ್ರಿ.
ಹೌದು. In 21 ಅಲ್ಲೇ ನಾವು mispetition filed within limitation.
Immediate.
In 2021-22, they filed the execution petition.
Execution.
Before the same court.
ಆಯ್ತು, ನಿಮ್ miscellaneous ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ
ಆಗಿತ್ತು.
ಯಾವಾಗ ಸರ್ವಿಸ್ ಆಗಿದ್ದು ಅಂತ ಕೇಳಿ.
After appearance.
Date of service.
Date of service is 17-11-21.
17-11-21.
2021.
21. Our execution
petition filed on 12/8/2022.
12/8/22. ಈ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ನಿಮಗೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗ್ಲಿಲ್ಲ?
No, execution ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ. Execution ಅಲ್ಲಿ when the as per the order sheet it clear shifts and the matter is for steps. They filed the application on order 26 rule 10 for appointment of commissioner. And the draft steps
ಗಿದ್ದಾಗ
ಅಂತ ಇದ್ದಾಗ trying to see the order sheet in execution petition. Execution.
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಮೇಲೆ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಎಲ್ಲಿ ಸರ್ವಿಸ್ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇತ್ತು ನಮ್ದು.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ JDR. Notice to JDR 1 and 2 unserved. Notice to JDR 1 and 2 unclaimed. ಇದು ಇಲ್ಲೂ ಕೂಡ ಅನ್ಕ್ಲೈಮ್ಡ್ ಅನ್ನೆ.
ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಹಾಗೆ ನಾಟ್ ಸರ್ವ್ಡ್ ಅಂತ ಬಂದು ಸ್ಟೆಪ್ಸ್ ಅಂತ ಹೋಯ್ತು ಆನ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ. ಸ್ಟೆಪ್ಸ್ ಅಂತಾನೆ
ಸ್ಟೆಪ್ಸ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇರುತ್ತೆ.
ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇತ್ತು. They filed application and order 26 rule 10 for appointment of commissioner.
CHR and so and so absent. Steps. Then next time application ಹಾಕಿರು.
And immediately the sale deed was executed in favor of the decree holder.
Right, next.
In mispetition, these facts have been suppressed by the respondent. The execution of the sale deed. Missal. ನಮಗೆ ಪೊಸಿಷನ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಅಂತ ಬಂದಾಗ we have come to know that already they have filed the execution petition and the sale deed was executed. So immediately we appeared before the executing court. Same court ane the execution petition we filed the wakalat.
ಈಗ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ವ ಇನ್ನು?
They have not taken the possession. And the execution petition itself is not maintainable. Why I am submitting this? The suit is decreed on 27/9/2021. Original suit, order sheet code OS. Kindly see the and the
as per the judgment and decree dated 27/9/2021, the decree was signed on 4/10/2021. But the execution petition was filed on 12/8/2020 based on the decree.
12/8/2022.
Based on that decree. In the decree, by mistake or oversight or a typographical whatever, there is no schedule. But they have mentioned the schedule in the execution petition. They have also filed a draft sale deed mentioning the schedule in 2023. And thereafter, on 14/2/2023. Judgments okay.
ಡಿಕ್ರಿನಲ್ಲಿ ಇದೆಯಲ್ರಿ? ಡಿಕ್ರಿನಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ, ಆಮೇಲೆ the decree is modified.
ನಂತರದಲ್ಲ?
And thereafter an amendment application is filed under section 152 and 153.
Modified and suit schedule property is included as follows ಅಂತ. 14/2/23 ನಲ್ಲಿ.
In 14/2/2023, amendment application was filed under 152 and 153 of CPC. And on 16/2/2023, the application was allowed and the decree was modified. I'm not disputing the court has inherent power under section 152 and 153. The decree may be modified at any time. The typographical error can be rectified at any time. I am not disputing that fact. But the execution petition was filed in the year 2022 based on the 4/10/2021 decree. So admittedly, there was no schedule on 4/10/2021 schedule decree. They have not amended the execution petition. They have not disclosed this filing of application, amendment application either in the mispetition or in the execution petition. The court commissioner was appointed without modifying the decree. In the same deed also, they have referred to execution petition 222 of 2022. So as per the execution 2022, there is no schedule also.
ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಯಾವಾಗ?
23.
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಆಗಿತ್ತು.
Sale deed was executed on
4/4/2023. 4/4/2023.
after modification of decree.
Modification ಆದಮೇಲೆ.
But modification is not rectified in execution petition. There is no such reference or no recited in the execution. First of all, they have no right to incorporate the schedule in the execution petition as per decree dated 4/10/2020. There is no schedule in the decree.
ಆಯ್ತು.
And no notice was served in the execution petition also. In collusion with the postal authority or I mean whatever.
ಏನ್ ಪ್ರಾಪರ್ಟಿ ಏನು?
It's a house property.
House property.
Any commercial and house properties. ಮೂರ್ ಕೆಳಗಡೆ ಮೂರ್ ಅಂಗಡಿ ಇದೆ.
So I have produced 2 documents.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಯಾವಾಗಿಂದು?
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ 4/10/4/5/2018. 2018 agreement, sale
agreement amount ಎಷ್ಟು?
Amount is shown as 37,50,000 and advance sale consideration was paid 35 lakhs.
ಅದು ಹೇಗೆ ಪೇಮೆಂಟ್ ಆಗಿರೋದು?
Paid through check ಕೊಟ್ಟಿದ್ದಾರೆ. Payment is not in dispute. The case of the defendant is it's a loan transaction. So in security of that loan amount, actually they have executed they have entered into a sale agreement. So in support of that contention, actually, I have produced 2 documents. So on the same day on 4/5/2018.
ಈಗ additional document ಹಾಕಿದ್ರಲ್ಲ ಅದು?
Between the same parties. On 4/5/2018, on the date of the same date of agreement, they have entered into ಒಂದು ಹಣ ಸಾಲ ಒಪ್ಪಂದ ಪತ್ರ ಅಂತ ಹೇಳಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅದು that is for 15 lakhs. So ಅದರಲ್ಲಿ 15 lakhs for 11 months ಅಂತ ಹೇಳಿ the repayment condition is for 11 months and they have taken one check.
ಅಂದ್ರೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ದಿವಸನೇ?
ಹೌದು. 15 ಲಕ್ಷ ತಗೊಂಡಿದ್ದಾರೆ, ಕ್ಯಾಶ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ 15 ಲಕ್ಷನ. ಅವತ್ತು it's in security of that amount they have taken one check bearing number, check number is also mentioned of Kanika Parameshwari. That is for 11 months. So after 11 months, they have entered into another agreement, that is document number 2, 24/6/2019. So adrallu they have shown 30 lakhs in cash. And another check was taken from the same bank. The next serial number is the check number. 2018 ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಚೆಕ್ ನ ಅದರ next serial number shown in 2019. So they have not mentioned what about the earlier check. Have they written or have they kept with them? Other we don't know. And this is for 30 lakhs. Second agreement. That is also for 11 months. So this 30 lakhs.
Was there any reference in the second agreement regarding earlier agreement?
ಏನು ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ.
ಇರ್ಲಿಲ್ಲ.
Earlier agreement, ಆಮೇಲೆ in sale agreement ಅಲ್ಲಿ 4/5/2000 agreement ಬಗ್ಗೆ there is no reference. In the sale agreement. So
sale agreement same day.
Same day. But there is no reference. So my respectful submission before this honorable court. All these documents and points show that the defendant has a prima facie material to defend his case. I am not asking for a dismissal of the suit right now. Just to provide an opportunity to defend his claim in the original suit. If really they have a good case on merits, let them come and witness box and depose and get the decree on merits. Now they are objecting to go on with the merits of the case. This is nothing, indirectly they are violating the right of the defendant. So defendant has prima facie documents, he can at least establish it during the trial. The trial court, after considering all these documents, may pass appropriate on merits.
Yes, yes, consulate.
This appeal is filed impugning, challenging the challenging the order passed by the trial court. Filed under order 9 rule 13 minutes. Where it provides for setting aside of ex parte judgment, my lord. Another option is regular appeal, my lord. Here the appellants have preferred the order 9 rule 13. Lords, if I may please reiterate the provision of 9 rule 13, my lords, with my lordship's kind leave. Lords, order 9 rule 13, my lords, of CPC says setting aside decree ex parte against defendant. Lords, it says in any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he satisfies the court that summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as cause so and so, my lord. But here the conditions are two conditions, my lords. One, in the pleadings, it has to be satisfied by the appellants that summons was not duly served on them. And second, my lords, there was a sufficient reason which prevented them from appearing before the court, my lords. These are the two ingredients that should be there in the pleadings, my lords. Now, my lords, if I may please take my lordship's kind attention to the pleadings, my lords. I have filed it with a memo, my lords. Pleadings there. Adralli, my lords, it is submitted in the open court, my lords. It is dated 12/11/2024.
12/11.
Please, my lords. Very index, my friend. Apologies. My lords, in that annexure A, my lords, it is the memorandum of miscellaneous petition which is filed by the appellant, my lords. My lords, in para 2, they say that the plaintiff in OS number so and so had filed a suit against the defendant seeking for relief of specific performance of the contract held dated so and so in respect of the sale of immovable property that belongs to the defendant. Further, the plaintiff was noted the address of the defendant is at Hassan. But the defendant number 1 is residing at Bangalore. As per the contents in the plaint, the address mentioned in the same but residing in Bangalore along with the so and so. The address of the last line, my lords, the address of the defendant in the suit is incorrect. My lords, here, my lords, if I may please take to the cause title of the very same application, my lords. ಅಲ್ಲಿ ಯಾವ ಅಡ್ರೆಸ್ ಅನ್ನು ಅವರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾರೋ ಅದೇ ಅಡ್ರೆಸ್ ಅನ್ನ ಇಲ್ಲಿ ಬಳಸ್ತಾರೆ. Even in this MFA, my lords, they use the very same address. They dispute the address here. But the very same address is used everywhere by the appellants, my lords. My lords, further, my lords, in the next para, adರಲ್ಲಿ in the 6th line, my lords, if I may please take. Further, the defendants were not aware of the paper publication as stated. As such, my lords, that is a misleading statement because no paper publication was taken. It was only a summons through court, my lords. My lords, adadmele para 6 ಅಲ್ಲಿ, my lords, if I may please. The petitioners most respectfully submit that the petitioners were not put their appearance and this court was pleased to pass ex parte decree. The petitioners were not aware of the proceedings. In the month of September, the plaintiff, that is the respondent in this case, openly said that he has obtained the decree against him. The petitioners could not approach their advocate due to lockdown. Lords, ನಾನು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಅವರನ್ನ ಅಪ್ರೋಚ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. However, if I may take my lordship's kind attention to the ink page 41 of the appeal itself, my lords, that is the seal of the certified copy. ಅದರಲ್ಲಿ, my lords, the judgment is dated plus the judgment of the trial court is dated 4/10/2019, my lords. Now, if I may
19 decree.
Sorry, 21
27/9/21 ಇರ್ಬೇಕು.
27/9/2019, my lords. My apologies. 27/9. My lords, in para ink page 41, my lords. My lords, apologies. Ink page 36, my lords, of the appeal. My lords, adರಲ್ಲಿ 27/9 is the judgment, my lords. In the recital, they said that ಅವರು ಅಡ್ವೊಕೇಟ್ ನ ಅಪ್ರೋಚ್ ಮಾಡಕ್ಕಾಗಲಿಲ್ಲ, ಲಾಕ್ ಡೌನ್ ಆಗಿತ್ತು, ನಾನ್ ಬಂದ್ ಹೇಳ್ದೆ ಅಂತ. My lords, if they were not aware of the proceedings, my lords, how could they file these certified copies for the very next day? 28/9, my lords, the seal 28/9/2021. 27 is the judgment. 28, the very next day, they filed for certified copy, and they obtained the certified copies on 7/10/2021, my lords. And after obtaining, my lords, they filed this miscellaneous application on 8/10/2021, my lords. My lords, in the miscellaneous application now, in para 8, my lords, in page 4, my lords, of my documents, what they say is, para 7, my lords, the petitioner most respectfully submit that on 3/10/2020, he approached their advocate and verified the case initiated against him. 3/10ಕ್ಕೆ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ರೆ, how did he file a certified copy on 28/9 itself? And further, my lords, in para 8, the petitioner most respectfully submit that the petitioner has filed an application to get the certified copy of the judgment and decree and the entire order sheet. Till today, the court has not issued the copies. That is a blatant lie, my lords. In fact, they received the certified copies the very previous dates. My lords, this is the contentions that is taken by them. My lords, nowhere they have pleaded the two conditions that is required by order 9 rule 13, my lords. None of the pleadings show that ಎಲ್ಲೂ notice serve ಮಾಡಿಲ್ಲ ಅಂತ ಎಲ್ಲೂ pleadings ತಗೊಳ್ಳೋದಿಲ್ಲ. ಮತ್ತೆ what prevented them? Nothing, my lords. There is no pleadings at all. My lords, now, my lords, my lords, in the cross examination, my lords, when it comes to cross examination, my lords, I have filed the evidence affidavit along with my index, my lords. That is that my lordship will find it at in page 20. My lord, that is the evidence affidavit. And the cross examination, my lordship will find it from in page 25, my lords. Adralli from the bottom, my lords, 7th line, my lords, if I may. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಕವರ್ ಬಂದಿರುತ್ತದೆ ಎಂದು ಆ ಕಾಲಕ್ಕೆ ಪೋಸ್ಟ್ಮನ್ ತಿಳಿಸಿದ್ದರು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ನೋಟಿಸ್ ಬ್ಯಾಂಕಿನಿಂದ ಬಂದಿರಬಹುದು ಎಂದು ತಿಳಿದು ಅದನ್ನು ಪುನಃ ವಾಪಸ್ಸು ಬರಬಹುದು ಎಂದು ತಿಳಿದು ಮತ್ತೆ ನಾನು ಪೋಸ್ಟ್ಮನ್ ರನ್ನು ವಿಚಾರಿಸಿರುವುದಿಲ್ಲ. My lords, they admit that they are in the same address. ಅದೇ ಇದ್ರಲ್ಲೇನೆ ಪೋಸ್ಟ್ ಆಫೀಸ್ ಬೇರೆ ಇದು ಬರ್ತಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. My lords, indirectly looking into, my lords, they have avoided even the notice which might have been sent by the bank also. ನನಗೇನ್ ತೊಂದರೆ ಮಾಡಿದ್ದಾರೆ ಅದೇ ತರ ಬ್ಯಾಂಕ್ಗೂ ಇದೇ ತರ ತೊಂದರೆ ಮಾಡಿದ್ದಾರೆ. ಅವಾಯ್ಡಿಂಗ್ ದ ನೋಟಿಸ್, then at the last moment coming and filing this petition, my lords, suppressing all the facts. My lords, in the next page, my lords, in page 26, in para 3 of the deposition, my lords, ಅದರಲ್ಲಿ 4ನೇ ಪೇಜ್ 4ನೇ ನಲ್ಲಿ ಮೂಲ ದಾವೆಯ ನಡವಳಿಕೆ ಬಗ್ಗೆ ನನ್ನ ಗಮನದಲ್ಲಿರುತ್ತದೆ ಸರಿ ಇಲ್ಲ. 2020ರಲ್ಲಿ ದಾವೆಯ ನಡವಳಿಕೆ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಾಗಿರುತ್ತದೆ. He admits, my lords, he admits that he was aware of the proceedings. And my lords, the notice sent to him is unclaimed, my lords. Unclaimed ಅಂತ ಆಗಿದೆ. Further, my lords, ಅದರ ಬಗ್ಗೆ ಗೊತ್ತಾದ ನಂತರ ನೀವು ಏನು ಕ್ರಮ ಕೈಗೊಂಡಿರ್ತೀರಾ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ಅಷ್ಟೊತ್ತಿಗಾಗಲೇ ಡಿಗ್ರಿ ಆಗಿದ್ದು ಅದರಂತೆ ಈ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ದಾವೆ ನಡವಳಿಕೆ ಬಗ್ಗೆ ನಮ್ಮ ಗಮನದಲ್ಲಿ ಸಹ ಆದೇಶ ಆಗಿರೋ ಕಾಯ್ದಂತೆ ಸರಿ ಇಲ್ಲ. My lords, if you had known about the case in the year 2020 itself, for 1.5 years he waited. He did not participate. My lords, next, my lords, in page 27, if I may please take para 4, my lords. My lords, this is the contrary statements between the wife, appellants are husband and wife, my lords. Your statement ಬೇರೆ ಕೊಡ್ತಾರೆ, ಇವರೇ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ. That I'll just bring it, my lords. My lords, ಡಿಗ್ರಿ ಆದ ಬಗ್ಗೆ ನನ್ನ ಸ್ನೇಹಿತರಾದ ರಾಕೇಶ್ ಎಂಬುವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ರಾಕೇಶ್ ಅವರು ಹಾಸನದವರೇ ಇರುತ್ತಾರೆ. ಸದರಿ ರಾಕೇಶ್ ಅವರು ನನ್ನ ಹಾಗೂ ಎದುರುದಾರರಾದ ಉಮೇಶ್ ಅವರ ಕಾಮನ್ ಫ್ರೆಂಡ್ ಇರುತ್ತಾರೆ. ಸದರಿ ರಾಕೇಶ್ ಅವರು ತಿಳಿಸುತ್ತಾರೆ ಎಂದು ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿಲ್ಲ. My lords, however, the pleadings says that I directly approached them. ಅಲ್ಲಿ ರಾಕೇಶ್ ಅನ್ನೋರ ಬಗ್ಗೆ ಮಾತೇ ಇಲ್ಲ. Here they take a different view, my lords. And contrary to this, my lords, PW2, my lords, in page 32, if I may take, my lords, ಅದರಲ್ಲಿ para 4, ದಾವೆಯ ಬಗ್ಗೆ ನಿಮಗೆ ಯಾವಾಗ ಗೊತ್ತಾಗಿರ್ತದೆ ಎಂಬ ಪ್ರಶ್ನೆಗೆ 2021ರ ಸೆಪ್ಟೆಂಬರ್ ಕೊನೆಯ ವಾರದಲ್ಲಿ ಉಮೇಶ್ ಅವರು, ದಟ್ ಇಸ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್, my lords, ನಾನೇ ಹೋಗಿ ಖುದ್ದಾಗಿ ಹೇಳ್ದಿ ಅಂತ ಹೇಳಿ. ಎರಡು ಕಾಂಟ್ರರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್. ಒಂದ್ ಕಡೆ ನನ್ನ ಕಾಮನ್ ಫ್ರೆಂಡ್ ಹೇಳಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಂದ್ ಕಡೆ ನಾನೇ ಹೇಳಿದೆ ಅಂತ.
ಪೇಜ್ 4 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಅಡ್ಮಿಷನ್?
My lords, in page 32 of my documents, my lords. 32. ಅದರಲ್ಲಿ PWT2, my lords, deposition of PWT.
ಎಷ್ಟನೇ ಲೈನ್?
para 4, my lords, first line.
para 4
ಪ್ಲೀಸ್, my lords. Lords, ಅದಾದ್ಮೇಲೆ ಅದೇ ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ಇನ್ ಪೇಜ್ 31, my lords, ಪಕ್ಕದ ಪೇಜ್, ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್, my lords, ಅದೇ ರೀತಿ ನನ್ನ ವಿಳಾಸಕ್ಕೆ ನನ್ನ ಯಜಮಾನರ ಹೆಸರಿಗೆ ಒಂದು ಪೋಸ್ಟ್ ಬಂದಿದ್ದು ಅದು ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಎಂದು ವಾಪಸ್ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. He admits. ಅದರಲ್ಲೇನೆ ಇನ್ ಪೇಜ್ 31, my lords. 31 in page 31 first ಪ್ಯಾರಾದಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್, my lords. She admits. She doesn't even deny that there was no notice. When there is a specific acceptance of notice by them.
ವಿಳಾಸಕ್ಕೆ ನನ್ನ ಯಜಮಾನರ ಹೆಸರಿಗೆ ಒಂದು ಪೋಸ್ಟ್ ಬಂದಿದ್ದು ಅದು ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಎಂದು ವಾಪಸ್ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಇದಾರ್ ವೈಫ್?
Wife, my lords.
PW2.
Please. Appellant number 2 in this case, my lords. My lords, they have accepted every notice, my lords.
Whether she has denied the signature available in the document?
My lords, there is no such pleadings as such in the.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಇವ್ರಿಗೆ ಜರಿಯಾದ ಬಗ್ಗೆ, ಅಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್. ಅಮೋದಾ ಪ್ರಸಾದ್.
ಪ್ಲೀಸ್, ನಾಟ್ಸ್ ಇನ್ ದ ಪ್ಲೀಡಿಂಗ್ಸ್ ಆತರ ಏನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ. Lords, this being the case, my lords, even I participate in the execution. I filed my objections, I contested, I did it everything, and honorable court dismissed their application. They are before this honorable court assailing the same, my lords. My lords, in the meanwhile, my lords, I filed execution. Execution, my lordship already saw that execution ಅಲ್ಲಿ ಕೂಡ ಅನ್ಸರ್ವ್ಡ್, ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ಆಗ್ತದೆ. ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ಆದ್ಮೇಲೆ ಅವರು ಅವರು ವಕಾಲತ್ ಹಾಕುದಿಲ್ಲ. Then I file an application for appointment of commissioner. Commissioner is appointed. ಆ 37.5 ಲಕ್ಷ consideration ಇತ್ತು, ಅದರಲ್ಲಿ I have already paid 35 lakhs, my lords. As on the date of agreement itself, I have completely shown my bona fide. In ಮಿಕ್ಕಿದ 2.5 ಲಕ್ಷ ಏನಿತ್ತು, deducting the same out of the court fees, I remit it before the honorable executing court, my lords. After doing that, honorable courts appoint one Mr. B.N. Sandesh, advocate, as commissioner, and even sale deed is executed in my favor. My lords, still today that sale deed stands firm, my lords. It has not been challenged.
What do you say with regard to the additional documents produced by him?
My lords, that won't, that is a different, I admit we executed that agreements, my lords.
Then why, if it is a real sale agreement?
ಇಲ್ಲ, my lords, sale agreement ಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. He asked for a loan, my lords.
Then why you have executed?
My lords, he asked for a loan, I gave the money, my lords. ಅದೇ ಅದು ಬಿಟ್ರೆ ಬೇರೆ ಏನು?
Other than ನೀವು ಈ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ 35 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದ ಅಲ್ದಲೇನೆ
Please,
ಮತ್ತೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತೀರಾ ನೀವು?
please, my lords. That is a separate transaction overall, my lords.
ಆಯ್ತು, ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸೂಟ್ ಹಾಕಿದಿರ ದುಡ್ಡು ವಸೂಲಿ ಮಾಡಕ್ಕೆ?
ಇಲ್ಲ, my lords.
ಮತ್ತೆ
We are deliberating, we have told our,
very same day sale documents are executed. What made you to execute those two documents?
lords, that was completely different transaction, my lord.
Maybe
Our Hanakas Ali,
according to both of you,
please, my lord.
once amount of rupees 15 lakh was paid in the first agreement on the same day of sale agreement, 4/5/2018, and once again in 2019, one more agreement for rupees 30 lakhs. In total, you have paid 45 lakhs. According to you, other than this sale consideration,
Please.
you have paid the amount of rupees 45 lakh. What steps you have taken? If
That's-
it is a separate transaction?
My lords, I admit that we have a check and till today we have not taken any action, my lords. I have already advised my clients to take
ಚೆಕ್
action.
ಎಲ್ಲ
accordingly.
ಟೈಮ್ ಬಾರ್ಡ್ ಅಲ್ವಾ ಈಗ?
My lords,
ಚೆಕ್ ಎಲ್ಲ ಟೈಮ್ ಬಾರ್ಡ್ ಅಲ್ವಾ ಈಗ? ಅದು
time
check
barred,
ತಗೊಂಡಿದ್ರಿ ನೀವು?
that we have to file only recovery of money.
That itself create the doubt with regard to the transaction between you and the petitioner about the sale transaction is concerned.
My lords, however, that is not in challenge before this honorable court, my lord.
Whatever it may be, but there are documents to show that financial transaction between both of you, that too on the very same date of the sale agreement.
Please, my lords. My lords, with respect to that, my lords,
Set aside ಮಾಡೋಣ, ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ.
my lords have already paid most of the amount, my lords.
Maybe.
Taken a notice issue ಆಗಿದೆ.
ನೀವು ದುಡ್ಡು ಕೊಟ್ಟರೆ ಎಲ್ಲಿಗೂ ಹೋಗಲ್ಲ, ದುಡ್ಡು ಅಲ್ಲೇ ಇರ್ತದೆ.
ಅಲ್ಲ, my lords, notice
If
is
you
complete.
succeeds in the sale transaction, you would get the property. If
Lords, it's a registered agreement, my lords. As on that day,
maybe there are two other agreements also. Now they have placed along with additional documents.
my lords,
It
there is
shows
no,
that it is not a sale transaction, it is a loan transaction.
my lords,
You are not disputing those two documents. Told.
my lords, if I may take the,
Counsel, I heard enough.
please,
You are not disputing those two documents. On the date of very sale agreement, one more document of sale loan transaction was there. Not only on that, even subsequent to the date also, in 2019 also, one more document. And also you managed to get the notice of service of notice. Allu not claimed, illu not claimed.
they agree that in the
execution
deposition
alone
they
not
agree, my
claimed. ಬಂದಿದೆ, ಬಟ್ ಇದಕ್ಕೆ ಬಂದಿದೆ ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ ಅವರಿಗೆ.
lords. Their own,
Execution allo not claimed.
their own
Procedural
admission
also
takes
not
away the
claimed.
entire case, my lord.
And also there are two documents. Told.
My lords, if I may just,
ಏನಾಗಲ್ಲ ರೀ, merit
judgments
ಮೇಲೆ
I'll just,
let the trial court decide on the merits, that's all. I will impose the cost,
I'll just,
I will impose cost on them, because we have got appointed the court commissioner and also obtained the sale deed. But that too, when the notice was served on you, miscellaneous only, on 17/11/21, after the service of notice, when they have filed a petition under order 9 rule 13, subsequently you have filed the execution petition and obtained the sale deed. Having the knowledge about, they have filed a miscellaneous petition under order 9 rule 13.
lords, if I may,
Huh?
miscellaneously, my lords, the order sheet,
Miscellaneous
like they themselves don't press on the stay in the miscellaneous.
ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲೇನ್ರಿ ನಿಮಗೆ?
Serve ಆಗಿದೆ. We
Now
have
you are
filed.
having the knowledge about, they have challenged the decree.
Please.
How could you can get the sale deed through a court?
My lords, but that is not challenge for
Conduct,
this
conduct
honorable.
also to be taken note of. Maybe there is an admission that they came to know, and they also committed a mistake. On the very next day, they applies for certified copy. Now they cannot contend that they are not having knowledge. Next day, judgment ಆದ next day ಹೋಗಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ.
That they don't disclose in the miscellaneous application. They
ಮಾಡೋದಿಲ್ಲ, ಅದೇನೆ.
suppress the fact.
ಆಮೇಲೆ
before
310
submit.
ಅಲ್ಲಿ ನಂಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತಾರೆ, ಬಟ್ ಕಾಪಿ ವಾಸ್ ಅಪ್ಲೈಡ್ ಆನ್ 28/9 itself.
Please.
ಇಬ್ರು ಛತ್ರಿಗಳು ಇದ್ದಂಗಿದ್ದೀರಿ, ನೀವು ಛತ್ರಿ ಅವರು ಛತ್ರಿಗಳು. ಅಲ್ಲ ರೀ, ಜಡ್ಜ್ಮೆಂಟ್ ಆದ ಮಾರನೇ ದಿವಸ ನೀವು ಹೋಗಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಕೋತೀರಿ. ಆಮೇಲೆ ನಿಮ್ ವರ್ಷನ್ ಡಿಫರೆಂಟ್ 310 ಅಲ್ಲಿ ನಂಗೆ ಹೇಳ್ದ ಅಂತ.
That is only the.
ದಟ್ ಈಸ್ ಓನ್ಲಿ ಅಲ್ಲ, ಹಲ್ವಾರು ಇದೆ. ನಿಮ್ ಹೆಂಡತಿ ಬಂದು ಒಪ್ಕೋತಾಳೆ ಏನಂತ ಹೇಳಿ, ಒಂದು ಪೋಸ್ಟಲ್ ಕವರ್ ಬಂದಿತ್ತು ಅಂತ. ನೀವು ಕೂಡ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 2020 ನಂಗೆ ಗೊತ್ತಾಯ್ತು ಸೂಟು ಅಂತೆಲ್ಲ ಹೇಳ್ತೀರಿ.
Evidence ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತು ಅಂತ.
ಆಯ್ತು, ಕೊಡಿ ಕಾಸು ಕಟ್ಟಿ ತಗೊಳ್ಳಿ. ಕೇಳಿದ್ದು ಇಬ್ರು ಕೋರ್ಟ್ ಬರ್ಡ್ ಆಗಿದ್ರೆ ಸರಿಯಾಗಿದ್ದೀರಿ. ಲಾಯರ್ಗಳಿಗೆ ಹೋಗಿ ತಿನ್ಸಿ ಅಷ್ಟು. ತಗೊಳ್ಳಿ, ಇನ್ನೊಂದು ರೌಂಡ್ litigation. Heard the petitioner, appellant counsel and also the counsel appearing for the respondent. And this court earlier heard the matter in part. And now heard the arguments of the appellant counsel and also the counsel appearing for the respondent. The factual matters of the case of the parties is that the respondent purchased entered into a sale agreement with the appellant herein for the sale consideration of rupees 37 lakh. 37 lakh,
37 lakh 50,000.
50,000.
Please.
50,000. And as on the date of the sale agreement, on 4/5/2018, made the payment of rupees 35 lakh through check.
RTGS.
RTGS. And thereafter, when the appellant herein did not come forward to execute the sale deed, filed the suit for the relief of specific performance. In the said suit, notice was ordered and notice was also sent through post as well as court. And endorsement was received that not claimed. And also endorsement by the bailiff that refused to receive the same. And hence he was placed ex parte and thereafter judgment and decree was passed on 27/9/21. Immediately Order 9 Rule 13 was filed, seeking the relief of setting aside the judgment and decree. And the notice was also served on the respondent public plaintiff on 17/11/21. And thereafter the respondent also filed an execution petition for obtaining the sale deed. And in the execution petition also notice was issued and the notice was returned with an endorsement not claimed. And hence an application was filed for appointment of court commissioner and sale deed is also obtained from the court to the court commissioner. The main contention of the counsel appearing for the petitioner that appellant that the respondent managed to get an endorsement not claimed and refused. And also in the petition filed under Order 9 Rule 13, bailiff and postman also examined before the court as court witness. And also the bailiff says that if a plaintiff was there along with him while serving the notice, but he did not take the signature of the plaintiff. And postman also says that he heard the noise of children in the house, but they did not open the door. And hence he returned the same as door locked. And the trial court, having considered the material and record, comes to a conclusion that not made out any sufficient cause to set aside the judgment and decree. And hence the present appeal is filed before this court. The main contention of the counsel appearing for the petitioner that appellant that it was stage managed in the original suit and also in the execution petition. And this court and counsel appearing for the respondent brought to notice of this court that when the judgment and decree was passed on 27/9/21 and copy was applied on the very next day, that is on 28/9/21. To this certified copy, that copy was applied on the next day, but came to, in the pleadings it is stated that he came to know about on 3/10/2021. And also while filing the petition, it is stated that till date copy has not been obtained, but record discloses that copy was obtained prior to filing of the same. And falsehood also brought to notice of this court by the respondent. And also the material discloses that in the cross-examination of the appellant also, he admits that he came to know about the filing of the suit in the year 2020. And the fact that suit was decreed is in 27/9/21. And also the wife who has been examined as PW2 also categorically admits that a registered post came in the name of her husband and the same was returned. And having taken note of the submission of appellant counsel and also the counsel for the respondent, And also the appellant counsel filed an application and order 41 rule 27 before this court, relying upon two documents of loan transaction. And the same is also dated 4/5/2018. And another document is dated the 19.
24/6/19.
Twenty-four six 2019. And in terms of the first loan agreement, an amount of rupees 15 lakh was paid. And in terms of the second agreement, an amount of rupees 35 lakh was paid. 30 lakh was paid. And no action was taken in respect of the loan transaction is concerned for having made the payment. Idan check payment idu?
Cash.
And the same is shown as cash payment in both the agreement. Hodala? And these two documents are not disputed by the respondent. When such being the case, when the doubt creates in the mind of the court with regard to the very transaction is concerned, and apart from that, in both the original suit, summons was not served, but only endorsement is that refused and also not claimed. In execution petition also not claimed the endorsement. And admittedly, the notice was served in the petition filed under Order 9 Rule 13 on 17/11/21. And in an ingenious method, the respondent also filed the execution petition having knowledge about the petition filed under Order 9 Rule 13, subsequently filed the execution petition and also endorsement unclaimed. And thereafter, commissioner got appointed and the sale deed is obtained, but possession is not yet taken. In respect of the, in terms of the decree, the counsel appearing for the appellant also brought to notice of this court that in the original decree, no schedule was mentioned, but in the, while filing the execution petitions, a schedule was mentioned and subsequently same was got amended in 2023. And having taken note of all these facts into consideration and also the application filed under Order 41 Rule 27, with regard to the very transaction between the parties is concerned, matter requires to be adjudicated on merits. And hence, it is appropriate to set aside the judgment and decree and also the dismissal of the petition filed under Order 9 Rule 13 and having taken note of the answer elicited from the mouth of appellant, as well as the respondent also having the knowledge and obtained the sale deed subsequent to the filing of miscellaneous petition Order 9 Rule 13, it is appropriate to allow the appeal and set aside the order and documents which have been placed under Order 9 Rule under Order 41 Rule 27 could be placed before the trial court in a suit, in original suit, for the consideration of the matter on merits.
May I please?
And hence, permission is given to the appellant to rely upon these documents before the trial court.
That's my note. My lordship may kindly note my submission that ಈ ಸೇಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಅನ್ನೋ
The counsel for the respondent plaintiff would contend that these two sale agreements are not in connection with the sale agreement, and the same will be considered during the course of the trial before the trial court on merits, and parties are given an opportunity to substantiate their contention before the trial court while considering the matter on merits. Having taken note of conduct of the appellant, that he had applied the certified copy on the very next day, and also certain admissions available on record, the appeal is allowed on cost of rupees 50,000, and the same is payable by the appellant before the trial court. Out of that, an amount of rupees 40,000 is payable to the respondent plaintiff. The remaining amount of rupees 10,000 shall vest with the state.
Time limit for
both parties are directed to appear before the trial court on 10th of March 2025 without expecting any notice from the trial court. The trial court is directed to dispose of the matter within a time bound period of 1 year. 1 year. And the appellant is directed to file the written statement within 1 month from 10/3 21 and thereafter ಒಂದೇ ತಿಂಗಳು ಕೊಡೋದು
10/3/25.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಗೆ
10/3/25.
10/3/25 ನಾ ಏನ್ ಹೇಳಿದೆ within 1 month from 10/3/2025 and thereafter trial court frame the issues and consider the matter on merits
My lords,
within a time bound period.
One submission, my lords.
ಹೇಳಿ
Officially, I am the owner of the property, my lords. They are in possession of the property. ಅಲ್ಲಿ 3 ಪ್ರಾಪರ್ಟಿ ರೆಂಟ್ ನ ಇವ್ರು ತಗೋತಿದ್ದಾರೆ. Let them all deposit that rent in the executing court, my lords, because let it not
unless you get the decree, how can the court can now grant?
them
ಈಗ ನಿಮ್ದು ಅದೇನಾದ್ರು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲ, ಇದು ಓನ್ಲಿ ಅಲ್ಲ ಸೇಲ್ ಲೋನ್ ಅಗ್ರಿಮೆಂಟ್ ಅಂತ ಅಂದ್ರೆ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಇಂಟ್ರೆಸ್ಟ್.
until then let the tenants deposit the rent before the trial court. ಅಂದ್ರೆ ನನ್ ಕಡೆ ಇದೆ ಅಂತಂದ್ರೆ
unless property is transferred in favor of you, how can you seek for an order?
Please
ಮಾಡಕ್ ಬರಲ್ಲ. ಟೈಮ್ ಬೌಂಡ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇನೆ, ದಟ್ಸ್ ಆಲ್.
grateful.
ಯಾವ ಅಯ್ಯೇ ಅದ್ರ ಮೇಲೆ ನಾನು ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಲೆಟ್ ದೆಮ್ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅಲ್ಲಿ ಹೋಗಿ ಹಾಕೊಳ್ಳಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ. Order 41 Rule 27 ಅಲ್ಲಿ and ತಗೊಳ್ಳಿ, in view of the observation made in the order, IA filed under Order 41 Rule 27 is disposed of and the appellant counsel is original xerox copy na ಇದು ಫೋಟೋ ಕಾಪಿನ ಇದು ಕಲರ್ ಫೋಟೋ ಕಾಪಿ ಅಂದ್ರೆ ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. Permitted to produce the original documents before the trial court.
Grateful.
38 PM Siddappa.
Notes 30. Passover. Yes, counsel record ಬಂದಿದೆಯಲ್ಲ?
ಬಂದಿದೆ.
The respondent shall file the charge sheet against this petitioner for the offense punishable under
Section 7 ಅದಕ್ಕೆ 3 months ಕೊಟ್ಟಿದ್ದಾರೆ, 10,000 ಹಾಕಿದ್ದಾರೆ ದಂಡ. 420 red with 511 ಗೆ 1 year 3,000 ಹಾಕಿದ್ದಾರೆ. ಹೇಳಿ ಏನು, what is the error in revisional jurisdiction?
of essential command is public distribution command. ಬರದೇ ಇಲ್ಲ. ಆ ಪ್ರಾವಿಷನ್ ಬರಲ್ಲ,
ಪ್ರಾವಿಷನ್ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ ಅಂತ.
ಯಾಕಂದ್ರೆ ಇದು ಪಬ್ಲಿಕ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್.
What is their case actually, prosecution case?
The prosecution case is that on 12/5/2016 at 6 PM at Godown number 26, some persons were illegally stored the rice and wheat which was supposed to be distributed to the public through ration card and trying to transport the same. Further, the necessary, it was there afterwards on the information sent by the SP office, the CW9 has gone to the spot and watched for some time and found that some persons are loading the lorry of there afterwards they try to caught hold of them. One of the person they caught hold is the petitioner. Another person is the accused number 1. The accused number 1 was acquitted by the trial court. The accused number 2 was caught hold by them. That is now the order is passed against him. As per the complaint,
what was the seizure at this spot? Seizure ಏನು?
ಸೀಜರ್ ಏನು, ಲಾರಿ ಸೀಜ್ ಮಾಡಿದ್ದಾರೆ, ರೈಸ್ ಸೀಜ್ ಮಾಡಿದ್ದಾರೆ.
ರೈಸ್ ಎಷ್ಟು ಬ್ಯಾಗ್?
279 bags of 50 kg each.
50 kg
each. 170 bags of wheat. 50 kg each.
50 kg
each. And lorry.
Seized rice, wheat were released to the government.
Whether this PDS rice?
Yes,
in order to prove that fact, they have not produced any document before the court. The only statement is PW3. PW3 was Assistant Director of Food and Civil Supplies. May I draw your lordship's kind attention to with regard to the statement, so that your lordship could appreciate whether the courts will or. May I draw some court attention to the PW3, Mala, who is the Assistant Director, the then. ನಿವೃತ್ತ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಆಹಾರ ಮತ್ತು ನಾಗರಿಕ ಸರಬರಾಜು ಇಲಾಖೆ. According to his own chief examination portion, they kindly be seen, madam. 12/5/2015 ನಾನು ಸಂಜೆ 6:15 ಸಮಯದಲ್ಲಿ ವಿನೋಬ ನಗರ ಠಾಣೆಯಿಂದ ಚಾಸ 9ರವರು ನನಗೆ ದೂರವಾಣಿ ಕರೆ ಬಂದಿದ್ದು APMC ಯಾರ್ಡ್ ಗೋಡನ್ ನಂಬರ್ 26ರಲ್ಲಿ ಏನು ಸಾರ್ವಜನಿಕ ವಿತರಣೆಗೆ ದಾಸ್ತಾನು ಮಾಡಿದ್ದ ಅಕ್ಕಿ ಮತ್ತು ಗೋಧಿಯನ್ನು ಅಕ್ರಮವಾಗಿ ಲಾರಿಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದಾರೆ ಎಂಬ ಮಾಹಿತಿ ಬಂದಿದ್ದು ನನ್ನನ್ನು ಸ್ಥಳಕ್ಕೆ ಬರಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ನಾನು for a moment take a pause for a moment. Your lordship kindly come to PW1's chief examination portion. 12/5/2015 ನಾನು ಶಿವಮೊಗ್ಗದ SP ಅವರು ನೀಡಿದ ಮಾಹಿತಿ ಮೇರೆಗೆ APMC ಯಾರ್ಡ್ ಗೋಡನ್ ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಸಾರ್ವಜನಿಕ ವಿತರಿಸಲು ದಾಸ್ತಾನು ಮಾಡಿದ ಅಕ್ಕಿ. Here the officer of the food department states in the chief examination, the ಗೋಡನ್ ನಂಬರ್ 26 ಶಿವಮೊಗ್ಗ ಇಲ್ಲಿ ಸಾರ್ವಜನಿಕರ ವಿತರಣೆ ದಾಸ್ತಾನು ಮಾಡಿ. ಇವ್ರು ಹೇಳ್ತಾರೆ PW1 ಅಕ್ರಮವಾಗಿ ದಾಸ್ತಾನು ಮಾಡಿ. Next PW2 also states same. PW2 is the one of the retired PSI. 12/5/24ರಲ್ಲಿ ನೀಡಿದ ಅಕ್ರಮವಾಗಿ ಸಾರ್ವಜನಿಕರಿಗೆ ವಿತರಿಸಲು ದಾಸ್ತಾನು ಮಾಡಿದ ಅಕ್ಕಿ. ಈಗ ಕ್ವಶನ್ ಮೆಲಾಡ್ whether this fact has been established up. When the food inspector, that is assistant director of food and civil supplies, has stated in the chief examination that the godown belongs to the government, wherein the food grains have been stored for the purpose of public distribution. So with regard to that matter, no documents have been produced, whereas other statement in the chief examination where they have illegally stored food grains of distribution went for public distribution. The question now, whether if their statement were to be, how they come to that godown? If illegally stored, they must come to those from the godowns from apartments. That with regard to that, there is no explanation. If this is taken into consideration, his version is to taken into how it was stored, where they have purchased, because in Islamic court of under the PDS control order, they have to purchase specified the APMC, that is TAPMC is there. From there they have to purchase, and it has to be stored, and thereafterwards it was distributed to the authorized holders of the card. That has to be done. Now with the allegation in the FIR and charge sheet is that how the court has been proceeded. May I draw your lordship's kind attention to the trial court. This would be the position the trial courts have proceeded. Para 26 of the trial court. How the court proceeded. This court has gone through the materials placed as well as both oral and documentary evidence it is the case of the prosecution that SP Shivamogga received the information that accused were illegally transporting the rice and wheat bags which were supplied by the government to the fair price shop and illegally trying to load the same in the godown of 26. Accordingly, CW1 and CW went to the spot and confirmed to say and have informed the CW9 along with the officials and Pancha witnesses went to the spot and conduct the raid. Here the prosecution, in order to prove the specific allegation made against the accused number 1 and 2, examined the CW9, that is valid, that is stated. Then your lordship come to how the trial court. There are 27. There are 27 nalli. Last paragraph, page 28. How it is pertinent to note that in the cross-examination, PW the counsel for the accused admitted that the time of conducting the Panchanama, they have not called for the persons of the neighboring goods. For this, PW12 stated that since CW9 brought to the securities from the APMCR and Pancha witness, and by this time they have conducted the neighboring godowns closed, nobody were available. This godowns, therefore, they are not involved in the other portion of the Panchanama. It is well settled principle that the suggestion it is reflecting the case of the accused. And here in that presence, the advocate accused number suggested that at the time of conducting the Panchanama, they have not involved other Panchas of is admitting the Panchanama in the present. How the court has proceeded. Without taking into consideration the case put forth by the prosecution. That is that the seized rice and distributed by the government. That is, with regard to that, no finding has been recorded by the trial. The fact remains whether these food grains all belongs to the government and meant for distribution of the through fair price shop. There is no documents by the trial court except PW3. None of the other where they have purchased, from whom authorized shop they have purchased the food grains. This is meant for fair price supply through fair price shop. There is nothing on record to show that this purchased and illegally they have stored and supplied. And moreover, this 26 godown is not belongs to the petitioner, and godown statement was not been recorded. And moreover, in the complaint, your lordship kindly see it is stated. Kindly see the complaint dated 12/2015. ಮಾನ್ಯ ನ್ಯಾಯ ಗಣನಾಯಕಕ್ಕೆ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಈ ದಿನಾಂಕ 12/15/2015 6 ಗಂಟೆಗೆ ಮಾನ್ಯ SP ಸಾಹೇಬರ ಆಫೀಸಿನಿಂದ ವಿನೋದನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಪಕ್ಕ ಸರಹದ್ದಿನ APMC ಯಾರ್ಡ್ ಗೋಡೌನ್ ನಂಬರ್ 26ರ ಪಕ್ಕದ ಗೋಡೌನ್ನಲ್ಲಿ ಗೋಡೌನಿನಲ್ಲಿ ಸಾರ್ವಜನಿಕರಿಗೆ ವಿತರಿಸಬೇಕಾದ ಅಕ್ಕಿ ಮತ್ತು ಗೋಧಿಯನ್ನು ಲಾರಿಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಬೇರೆ ಕಡೆ This goes to show that, my lord, whether food grains actually it was stored which belongs to the government meant for food, nothing is there, man. Except that he received the telephonic call and gone there and found that some rice and all that it is there. But the case of the prosecution is these rice and that is wheat meant for public distribution. Well, your lordship is aware that unless it is accounted, everything is accounted with regard to food supply of food, that is food and that is food and
wheat and
rice and wheat through with accountable. Nothing has been placed before the trial court to show that these food grains belongs to the.
Whether you are the PDF, the public distribution shop owner? No.
Allah.
Then how you got
ಅವ್ರು ಹೇಳಿದ್ರು ಅಲ್ಲಿ ನಾನು ನೋಡೋದು
got into the possession of the wheat and the rice?
ನಂದಲ್ಲ ಅದು, ನಾನು ಹೇಳಿದ್ದೀನಿ ನಂದಲ್ಲ, ಗೋಡನು ನಂದಲ್ಲ, ನನ್ ಸೇರಿದ್ದು ಅಲ್ಲ.
But you were there at this spot.
They have told me and they stated.
Why you are there at this spot? If shop is, if Godan is not belongs to you, you are no way connected with the wheat and rice. Then why you are there at this spot? What is your explanation? 313 ನಲ್ಲಿ ಏನ್ ಹೇಳಿದಿರಿ?
Nothing. 313 ನಲ್ಲಿ
313 ನಲ್ಲಿ you have to explain. What you have explained?
Statement.
Madam, 313 ಬೇಕಂತ ಕೊಡಿವ್ರಿ. 313 ನಲ್ಲಿ you have to explain. ನಾನು ಅಲ್ವೇ ಅಲ್ಲ, ನಂಗೂ ಗೊತ್ತಿಲ್ಲ, ಅದಕ್ಕೇನು ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನೀವು ನಿಮ್ಗೆ ಯಾವಾಗ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಟೋಟಲ್ ಡಿನೈಲ್ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಯು ಆರ್ ದೇರ್, ಯು ಆರ್ ಇನ್ ಕಾನ್ಸಿಯಸ್ ಪೊಸೆಷನ್ ಆಫ್ ದಿ wheat and rice at the spot, loading the same to the lorry, and that is the accusation against you. Who has to explain? You have to explain under section 313.
It's only total denial, my lords, para 6. It is only total denial. Para 6 of the my lords judgment, magistrate judgment, my lord.
Total denial ಅಂತ ಅವ್ರು observation ಮಾಡಿದಾರಾ?
Yes. Para 6, my lord.
313. ಇಲ್ಲಿದೆ. ಎಲ್ಲ ಸುಳ್ಳು 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 ಅಷ್ಟೇ. ಏನ್ ಕೇಳಿದ್ರು ಕ್ವಶನ್ ಸುಳ್ಳು ಸುಳ್ಳು, ಇಲ್ಲ ಇಲ್ಲ, ನೀವೇನಾರು ಹೇಳೋದು ಇದೆಯಾ? ಏನು ಇಲ್ಲ. ಸ್ವಇಚ್ಛೆಯಿಂದ ಬೇರೆ ಏನಾದ್ರು ಹೇಳೋದು ಇದೆಯಾ? ಇಲ್ಲ. Who has to explain under section 313?
That question of explanation would arise according to me, my lord. The property is belongs to me, and so Godan is belongs to me.
Then you have to explain.
So how the person who implicating me,
public distribution, rice and bag were in your custody.
When I am not in custody of those things.
But you are loading the same into the lorry.
I am not loading. The persons who are loading run away.
Amal is, but you are there at this spot.
I have not told that. I am saying that there. Therefore, they filed the charge sheet. So unless, my lord, the case of the prosecution is established, the fact that these food grains meant for the PDS, so and then, my lord, it could be probable.
Yes.
But whereas the case of the prosecution is not like that.
What is the illegality committed by the trial court and appellate court? Scope is very limited in the revision. We have to see only legality and its correctness. What is the
First of all, my lord, the conviction made under the provision is not at all available. Those under 6 and 7 of the PDS control order does not provide for it. Kindly see the PDS control order.
3 and 7.
Alla 6 and 7 anta conviction order nalli
illa 3 and 7.
Kindly see the order.
Madrade 3 and 7 ಗೆ 7 ಗೆ ಮಾತ್ರ ಮಾಡಾರ. 3
your lordship essential commodity public distribution system public act
3 ಗೂ ಮಾಡಿಲ್ಲ, 7 ಗೆ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ.
Plus 420.
7 ಗೆ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ ಕನ್ವಿಕ್ಷನ್.
Perishable under section 7 of essential commodity public distribution system.
420 conviction is.
Huh?
420 conviction.
420 for cheating ಅದಿದೆ, but essential commodities concerned.
ಎಸೆನ್ಷಿಯಲ್ ಕಮಾಂಡಿಟೀಸ್ ಕೆಳಗಡೆ ಆಗಿಲ್ಲ.
Section 7 ಮಾಡಿರೋದು ನೋಡಿ.
ಇಲ್ಲ, ತಾವು ನೋಡ್ಬೋದು. ಪೇಜ್ 34. Public distribution system. Kindly see the public distribution system order.
Essential commodities ರೇ, within bracket ಅಲ್ಲಿ public distribution system ಅಂತ ಇದೆ.
ಹೌದು, ಅದಕ್ಕೆ ಇದೆ.
Public control act. ಅದೇನೆ ಪಬ್ಲಿಕ್, ಅದೇನೆ section 7 ಒಂದೇ.
ಸೆಕ್ಷನ್ 7 ಇಲ್ಲ, ಅದು ಕ್ಲಾಸ್ 7 ಅದು ಸೆಕ್ಷನ್ ತಪ್ಪಂತ ಬರ್ತಾರೆ. ಕ್ಲಾಸ್ 7 ಬರುತ್ತಾರೆ. ಇದ್ರೆ ಪಬ್ಲಿಕ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಸೆಕ್ಷನ್ ಅಂತ ಉಪಯೋಗಿಸಲ್ಲ, ಕ್ಲಾಸ್ ಅಂತ ಉಪಯೋಗಿಸ್ತಾರೆ.
3 and 7 of EC Act ಅಂತ ಇದೆ.
ಇಲ್ಲ, EC Act ಅಂತ ಇಲ್ಲ. Public Distribution System Control Act and essential under SI and also.
ಅದು within bracket ಅಲ್ರಿ ಅದು. Public distribution within bracket ಅಲ್ಲಿ ಇದೆ.
ಹೌದು, ಅದೇ ಟೈಪ್ ಇರೋದು. Kindly see my lord.
ಆಯ್ತು ಹೇಳಿ.
Public essential commodities public distribution system control order.
ಆಯ್ತು.
ಅದೇ ರೀತಿ ಇರೋದು ಇದರಲ್ಲಿ. And my lord, the evidence on record, the appreciation of the evidence on record is my lord by the
Only the scope of revision is.
When it is a perverse, my lord,
Perverse ಇದ್ರು ಮಾತ್ರ, otherwise ಇಲ್ಲ.
perverse. Therefore,
What is the perversity? You show me.
how?
If without any evidence, if any reasons are given, then it would be perversity. And then if any evidence is available and the same is not considered, if any order has been passed, that also amounts to a perversity. Where is that circumstance?
Then I would like to draw your lordship's attention to with regard to evidence on record.
Mainly stock witnesses ಅವ್ರಿಗೆ ಇರೋದೇ 3 ಜನ. PW 1, 2, 3.
ಇಲ್ಲ,
PW
5 ಇದ್ದಾರೆ.
PW 1 is the person who has received the information from the SP.
Conducted raid.
That,
Raid, he has conducted the raid.
raid
Yes.
on the instructions of SP. And he secured the PW 3 to the spot, giving information. And also PW 2 is also one of the raiding party.
Raiding team.
These are the witnesses. Material witnesses. ಅವ್ರು ಹೇಳ್ದೆ ಇಲ್ಲದನ್ನ ಏನಾರು ಹೇಳಿ ಏನಾರು ಬರ್ದಿದಾರ ಆರ್ಡರ್ ಅಲ್ಲಿ, then it amounts to a perversity.
ಇಲ್ಲಿ ಅವರು
ಪರ್ವತಾನಂದ ನಂತರ ಅವರಲ್ಲಿ ಒಬ್ಬರನ್ನು ಹಿಡಿದು ವಿಚಾರಿಸಲಾಗಿ ಅವನು ತಮ್ಮ ಹೆಸರು ಪರ್ವತಾನಂದ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸದರಿಗೌಡನನ್ನು ಪರಿಶೀಲಿಸಿ ನೋಡಲಾಗಿ ಸಾರ್ವಜನಿಕರಿಗೆ ವಿತರಿಸಬೇಕಾದ ಅನ್ನಭಾಗ್ಯದ ಅಕ್ಕಿ ಮತ್ತು ಗೋಧಿ ಚೀಲಗಳು ಕಂಡು ಬಂದಿದ್ದು, ಚಾಸ 2 ಮತ್ತು 3 ರವರುಗಳು ಅವುಗಳನ್ನು ಗುರುತಿಸಿದ್ದು, ಅಲ್ಲಿ ಒಟ್ಟು 125 ಖಾಲಿ ಚೀಲಗಳು ಕೂಡ ಕಂಡು ಬಂದಿದ್ದು, ಎಲೆಕ್ಟ್ರಾನಿಕ್ಸ್ ತೂಕದ ಮೆಷಿನ್ ಮತ್ತು ಚೀಲ ಹೊಲಿಯುವ ಮೆಷಿನ್ ಸಿಕ್ಕಿರುತ್ತದೆ. ನಂತರ ಪರಿಶೀಲಿಸಲಾಗಿ 279 50 ಕೆಜಿ ತೂಕದ ಅಕ್ಕಿ ಚೀಲಗಳು, 170 50 ಕೆಜಿ ತೂಕದ ಗೋಧಿಯ ಚೀಲ ಹಾಗೂ ಕೃತ್ಯಕ್ಕೆ ಬಳಸಿದ ಲಾರಿ ಇವುಗಳು ಕಂಡು ಬಂದಿದ್ದನ್ನು ಪಂಚರ ಸಮಕ್ಷಮದಲ್ಲಿ ಪಂಚ್ ಮಾಡಲಾಯಿತು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Similar evidence by PW 2 and 3. PW 2 is also one of the raiding party.
Yes.
Next, PW 3 also on information he rushed to the spot. He is the deputy director of food and civil supplies department.
Yes.
He also went to the spot. He was also a raiding party.
PW 4, I want charge sheet.
I like your lordship the finding.
PW 5 is the master witness, he has supported.
Finding
But material witnesses PW 1 to
1 to 3.
ನಾನು ಹೇಳ್ತಿರೋದೇನಂದ್ರೆ the lordship kindly take PW1 chief examination further. So how the courts have misread this evidence in even the chief examination, not apart from, because the trial court considered the suggestions posed to the witnesses.
Suggestions ಬಿಟ್ಬಿಟ್ರಿ, suggestions ನಾವು ತಗೊಳ್ಳೋದೇ ಬೇಡ. ಬಟ್ ಏನು
So ಅದಕ್ಕೆ
credible evidence ಏನಿದೆ ನೋಡೋಣ.
chief examination ತಾವು ನೋಡಿದ್ರೆ, so whether how the courts have proceeded when, if the chief examination is like this.
What is the lacking? Show the court. That's what I am asking you.
My submission to your lordship, the material with regard chief examination, I have pointed out. One with PW1 says that these food grains shall be stored illegally. So it presupposes the fact that these food grains has to be brought from other side and stored here illegally. Whereas the PW3 stated that they have stored the food grains in 26, Godan number 26. So if it, legality of these things has to be established. So legality in the sense, my lord, so one, if they are, it is one thing is the Godan belongs to the government. And it is meant for the storing of the foods which are meant for supplying of the fair price shops. That is not stated. This fact is not, though it is not brought on record, it is considered by the courts below. Therefore, I am reading this chief examination portion of the PW1. ಸಾರ್ವಜನಿಕರಿಗೆ ವಿತರಿಸಬೇಕಾದ ಅನ್ನಭಾಗ್ಯದ ಹಕ್ಕೆ ಮತ್ತು ಗೋಧಿ ಚೀಲಗಳನ್ನು ಕಂಡು ಚಾಸ 2-3 ಅವರುಗಳನ್ನು ಗುರುತಿಸಿದ್ದು. ಅಲ್ಲಿ ಒಟ್ಟು 125 ಖಾಲಿ ಚೀಲಗಳು ಕಂಡು ಬಂದದ್ದು. ಎಲೆಕ್ಟ್ರಾನಿಕ್ ತೂಕದ ಮಿಷಿನ್ ಮತ್ತು ಚೀಲ ಹೊಲಿಯುವ ಮಿಷಿನ್ ಸಿಕ್ಕಿರುತ್ತದೆ. ನಂತರ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ 179 50 kg ತೂಕದ ಚೀಲದ 55 ತೂಕದ ಅಕ್ಕಿ ಚೀಲಗಳು, 170 50 kg ತೂಕದ ಗೋಧಿಯ ಚೀಲ ಹಾಗೂ ಕೃತ್ಯಕ್ಕೆ ಬಳಸಿದ ಲಾರಿ ಇವುಗಳು ಕಂಡು ಬಂದಿದ್ದು. ನಾವು ಪಂಚರ ಸಮಕ್ಷದಲ್ಲಿ 6:45 8:30 ಪಂಚನಾಮ ಮಾಡುವ ಮುಖಾಂತರ ನಂತರ ವಶಪಡಿಸಿಕೊಂಡ ಮಾಲುಗಳನ್ನು ಆರೋಪಿತ ಠಾಣೆಗಳಿಗೆ ಹಾಜರಾಗಿ ರಾತ್ರಿ 9 ಗಂಟೆಗೆ ಮೇರೆಗೆ ಪ್ರಕರಣವನ್ನು ದಾಖಲು ಮಾಡಿರುತ್ತೇವೆ. ನಂತರ ಚಾಸ 1ರಿಂದ 8ರವರೆಗೆ ಹೇಳಿಕೆಗಳನ್ನು ದಾಖಲು ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನಂತರ ಆರೋಪಿತರ ನ್ಯಾಯಾಂಗ ಬಂಧನಕ್ಕೆ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತೇವೆ. Then my lord, kindly come to the cross examination. May I read one? ಯಾವುದೇ APMC ಯಾರ್ಡ್ನಲ್ಲಿ ಕೃಷಿ ಉತ್ಪನ್ನಗಳು ಒಳಗೆ ತರಬೇಕಾದರೆ ಸೆಸ್ ಕಟ್ಟಬೇಕಾದರೆ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಥಮ ವರ್ತಮಾನ ದಾಖಲಾಗುವ ಮೊದಲೇ ಪಂಚನಾಮೆಯನ್ನು ಮಾಡಿದ್ದೇನೆಂದರೆ ಸರಿ. APMC ಯಾರ್ಡ್ ನಲ್ಲಿ ಡೀಟೇಲ್ ವ್ಯವಹಾರ ನಡೆಯುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಬೆಳಗ್ಗೆ 9ರಿಂದ 8ರವರೆಗೆ APMC ಯಾರ್ಡ್ನಲ್ಲಿ ಜನಸಂದಣಿ ದಟ್ಟವಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. CP1 ಪಂಚನಾಮೆ ತಯಾರಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿ ಇದ್ದ ಅಕ್ಕಪಕ್ಕದ ಅಂಗಡಿ ಮಾಲೀಕರನ್ನು ಕರೆಯಲು ಯಾವುದೇ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಸಂಜೆ ಆದ ಕಾರಣ ಅಂಗಡಿ ಬಾಗಿಲು ಹಾಕಿತ್ತು ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ಚಾಸಾಂ 5ರವರನ್ನು APMCಯ ವಿನೋಬನಗರ ಕಡೆಗೆ ಇರುವ ಗೇಟ್ನ ಸೆಕ್ಯೂರಿಟಿಯಲ್ಲಿದ್ದವರನ್ನು ಕರೆತಂದಿರುತ್ತೇವೆ. ಈ ಪಂಚನಾಮೆ ತಯಾರಿಸುವ ಮುಕ್ತಾದರಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಗೋಡಾನ್ ಇರುವ ಸ್ಥಳಕ್ಕೂ ಹಾಗೂ ಚಾಸ 4-5 ಸ್ಥಳಕ್ಕೂ ಸುಮಾರು 2ರಿಂದ 3 ಕಿಲೋಮೀಟರ್ ಅಂತರವಿದೆ ಎಂದರೆ ಸರಿಯಾದ. ಮುದ್ದೆಮಾಲ್ 1ರಿಂದ 3ರಲ್ಲಿ ಯಾವುದೇ ಪಂಚರ ಸಹಿಯನ್ನು ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. APMC ಯಾರ್ಡ್ನಲ್ಲಿ ಸ್ಥಳ ಪಂಚನಾಮೆ ನಡೆಸಿದ ಗೋಡನ್ ಅಂತಹ 100 ಗೋಡನ್ ಇದ್ದೇವೆ ಎಂದರೆ ಸರಿ. ಎಲ್ಲಾ ಗೋಡನ್ಗಳಲ್ಲಿ ಖಾಲಿ ಚೀಲಗಳು ದೊರೆಯುತ್ತವೆ ಎಂದರೆ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ತನಿಖೆಯ ಕಾಲದಲ್ಲಿ APMC ವತಿಯಿಂದ ಹಾಕಲಾದ ಗೋಡನ್ ಸಂಬಂಧಿಸಿದ ನಿಬಂಧನೆಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಸದರಿ ನಿಬಂಧನೆಯನ್ನು ತಬ್ಲಿ ನೀಡಬಾರದು ಎಂಬ ನಿಬಂಧನೆ ಇದ್ದು ಅದು ತನಿಖೆಗೆ ತಿಳಿದಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅನ್ಯವಾಯುಗ್ಯ ಯೋಜನೆಯನ್ನು 2016ರಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಹೊರಡಿಸಿದೆ ಎಂದರೆ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ಆರೋಪಿತರು ಯಾವುದೇ ತಪ್ಪು ಮಾಡಿದ್ದರೂ ಸಹ ಕೇವಲ ಅಂಕಿಅಂಶಕ್ಕಾಗಿ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲು ಮಾಡುತ್ತೀರಿ ಎಂದು ಸುಳ್ಳು ದೋಷ ಪಟ್ಟಿದೆ ಸಲ್ಲಿಸಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. So your lordship kindly see in the cross examination, admittedly when the goods are entered into the APMC Act, that has been checked, and thereafterwards it was sent to the godans. With regard to that, no documents have been produced.
Yes.
To show that those grains have been stored and meant for the food and for public distribution system. Your lordship kindly see PW2 evidence. Already I pointed out, he also said ಇದು ಅಕ್ರಮವಾಗಿ ಸಾರ್ವಜನಿಕರಿಗೆ ವಿತರಿಸಲು according to the PW2, these food, that is rice and wheat have been stored illegally in this godown meant for public distribution system. Currently, see in the chief examination ಸ್ಥಳಕ್ಕೆ 6:42 ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ನಂತರ SP ಅವರು ಚಾಸ 9ರವರೆಗೆ ದೂರವಾಣಿ ಮುಖಾಂತರ ವಿಷಯ ತಿಳಿಸಿದ್ದು, ಚಾಸ 9ರವರು ಚಾಸ 2ರಿಂದ 4 ಅವರನ್ನು ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಸ್ಥಳಕ್ಕೆ 6:45 ಸಮಯ ಹೋಗಿ ನೋಡಲಾಗಿ ಅಕ್ಕಿ ಮತ್ತು ಗೋಧಿಗಳ ಲಾರಿಗೆ ತುಂಬುತ್ತಿದ್ದ 2-3 ದಿನ ವ್ಯಕ್ತಿಗಳು ನಮ್ಮನ್ನು ನೋಡಿ ಓಡಿ ಹೋಗಿದ್ದಾರೆ. ನಂತರ ಅವರಲ್ಲಿ ಒಬ್ಬರನ್ನು ಚಾಸ 9ರವರನ್ನು ಹಿಡಿದು ವಿಚಾರಿಸಲಾಗಿ ಅವರ ತಮ್ಮ ಹೆಸರು ಪರ್ವತಾನಂದ, ತಂದೆ ವರಿಕೆಂಚಪ್ಪ ಎಂದು ತಿಳಿಸಿರ್ತಾರೆ. ನಂತರ ಸದರಿ ಗೋಡನ್ನು ಪರಿಶೀಲಿಸಿ ನೋಡಲಾಗಿ ಅಕ್ಕಿ ಮತ್ತು ಗೋಧಿ ಚೀಲಗಳು ಕಂಡು ಬಂದಿತ್ತು. ಚಾಸ 2-3 ಅವರು ಅವುಗಳನ್ನು ಗುರುತಿಸಿದ್ರು. ಅಲ್ಲಿ ಒಟ್ಟು 225 ಚೀಲಗಳು ಕಂಡು ಬಂದಿದ್ದು, ಎಲೆಕ್ಟ್ರಾನಿಕ್ ತೂಕದ ಮಿಷನ್ನು ಮತ್ತು ಚೀಲ ಒಲಿಯುವ ಮಿಷನ್ನು ಸಿಕ್ಕಿರುತ್ತದೆ. ನಂತರ ಪರಿಶೀಲಿಸಲಾಗಿ 279 ಕೆಜಿ ಅಕ್ಕಿ ಚೀಲಗಳು ದಟ್ ಇಸ್ ಲಾರಿಯನ್ನು ಗುರುತಿಸುತ್ತಾರೆ. ಸ್ವಾನ್ಸು ಪಂಚನಾಮೆಯನ್ನು 6:30ರಿಂದ 8:30 ಬರೆಯಲಾಗುತ್ತದೆ. ಸದರಿ ಪಂಚನಾಮೆಗೆ ಸಾಕ್ಷಿದಾರ PS ಅವರು ಕರೆತಂದಿರುತ್ತಾರೆ. ಅವರನ್ನು ಯಾವ ಭಾಗದಿಂದ ಕರೆತಂದಿರು ಎಂದು ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ APMC 2ನಲ್ಲಿ ಬೆಳಗ್ಗೆ 9ರಿಂದ 8ರವರೆಗೆ ಜನಸಂದಣಿ ಇರುತ್ತದೆ. ಗೋಡನ್ 26 ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಗೋಡನ್ 25, 27 ಇರುತ್ತದೆ. ಸದರಿ ಗೋಡನ್ಗಳು ಸಹ ತೆರೆದಿದ್ದವು. CP 2 ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಬರೆಯಲಾಗಿದೆ ಎಂದರೆ ಸರಿಯಾದ. Then my lord, the PW3
Yes, continue on Monday.
Please.
Third in part, please. Discuss matter on Monday.
May I request on Tuesday?
Tuesday ಬೇಕಾ? Tuesday. Yes, today Tuesday. 11th.
Final hearing matter 48. Nehru P.
For the petition law. Are going on. 138.
Talks are going on.
Morning he was there. Earlier also. Before this.
ಆಯ್ತು, ಎಷ್ಟು ದಿವಸ ಬೇಕು?
10 days, 18th afternoon.
Sorry, counsel for the petitioner submits that settlement is going on. And hence this matter on 18/2.
49. ನಿಮ್ದು 49. ನೆಹರು P.
ಎಲ್ಲ ಅವರೇನೆ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅವ್ರು ಹೇಳಿರೋದು 48, 49, 50, 51. Next 52.
52.
HL Pradeep Kumar.
Kapil Dixit.
Kapil Dixit. ಇಬ್ರು ಇಲ್ವಾ? Both. Respondent. You are appearing for whom, madam? Petitioner, want of time, list this matter on 22. 53.
53. P. Prasad.
Want of time, list this matter on 22.
10.
Jagdish AM, want of time, list this matter on 22.
55.
Nehru ನಿಮ್ದೆ ಮತ್ತೊಂದು ಯಾವಾಗದು?
ಅದನ್ನು
18/2. Next 56.
56.
Want of time, list this matter on 22.
57.
ಎಲ್ಲಾ ಮ್ಯಾಟ್ರು 22, ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ 22. ಏನಾರು ಬೇರೆ ಡೇಟ್ ಇದ್ರೆ ಕೇಳ್ಬೋದು ಯಾರು.
Ships kindly.
Serial number 60, 21st.
21st ಬೇಕಾ? ಅದರ್ ಸೈಡ್ ಇದಾರ 21st ಹಾಕಿದ್ದು.
Serial number 66 tomorrow.
66 ಯಾವಾಗ ಬೇಕು?
Tomorrow.
ಟುಮಾರೋ ಆಗೋದಿಲ್ಲ, ನಾಳೆಗೆ ರೀಚ್ ಆಗೋದಿಲ್ಲ.
Serial number 58, my lord.
22.
Tomorrow, Monday.
26 ಮ್ಯಾಟರ್ 22.
Serial number 58, my lord.
ಸೀರಿಯಲ್ ನಂಬರ್
58. I
ಹೇಳಿ, ಏನಾದ್ರು?
lost it on 21st, my lord.
21st.
Yeah,
ಓಕೆ ಆಯ್ತು. 21-2 50 58 21-2 ಹಾ 63 ನಾ ಯಾವಾಗ ಬೇಕು? 26 ವರೆಗೆ ಕೊಡಲ್ಲ. 20 ಒಳಗಡೆ ನೀವು ಯಾವ ತರ ಕೇಳ್ಬೋದು?
11 on 11th.
21-2
64 my lords, may I request on 21st my lord, 22nd.
24 ಆಯ್ತು. 21-2
Please.
64. Lord, ಅದು ಹೊಸದು application ಮೇಲೆ ಬಂದಿರೋದು.
ಯಾವುದು?
Ready?
64.
I'm not seeking time.
64 ಯಾವಾಗ ಬೇಕು?
Stay ಆಗುತ್ತೆ.
ಹಾ
ಚಾರ್ಜಿಂಗ್ ಇದೆ ಸ್ಟೇಜ್.
ಆಯ್ತು. 21ಕ್ಕಿಂತ ಮುಂಚೆ ಬೇಕಾ? ಆಯ್ತು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
ಆಯ್ತು
ಕೊಡಿ ಯಾವ್ದಾರ ಒಂದು ಕಡಿಮೆ ಇರೋ ದಿವಸ ಕೊಡಿ. ನಿಮಿಷ ಇರಪ್ಪ. ಹಾ
72.
17-2 ಇದು.
Please, 17 interim order may be extended.
Entry order granted earlier is extended till instead of hearing. ಅಷ್ಟೇನಾ?
62.
ಬಾಕಿದೆಲ್ಲ 21. ಯಾವ್ದಾವ್ದು ಡೇಟ್ ಕೇಳಿಲ್ಲ ಅದೆಲ್ಲ 22 ಕೊಡಿ. ಹೇಳಪ್ಪ ಏನು?
66 Monday.
ಹಾ
66 serial number 6 Monday.
24ನೇ ಇಸ್ವಿ ಕೇಸು ಹಳೇದೆಲ್ಲ ಇದೆ. 2016 ಮಂಡ್ಯಕ್ಕೆ ತಗೊಳಕ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ 22. ಅವತ್ ಲಾಯರ್ ಕರ್ಕೊಂಡ್ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಸಿ. ಹಾ ಅಷ್ಟೇ ಅಲ್ಲ ಮೇಡಮ್?
5 ಆಗಿದೆ. 5 ಆಗಿದೆ.
5 ಹಾ
60. 63.
ಹಾ
62.
20ನೇ ತಾರೀಕು.
22 ಡೇಟ್ ಕೊಡದಿದ್ಲೆಲ್ಲ 22. ಯಾರ್ಯಾರು ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೇಳಿದ್ರು ಅದೆಲ್ಲ 21-2.
ಮೇಡಮ್ 61 61
ಹಾ.
ಏನ್
ಅದು
ಡೇಟ್
20ನೇ
ಕೊಟ್ಟರೋ
ತಾರೀಕು.
ಅದು 20. ಓಕೆ